by the panel prior to the presentation of the defense's witnesses?
The exhibit matter that we discussed at the end of yesterday, if I may address that.
Yes,
Mr.
please.
Chair? Okay. Per instructions, sorry, can you hear me?
Yeah, let's just go on let's make sure we're on the record is all.
Okay. Per instructions, or at least what we hope we understood to be the instructions, we have amended our exhibit lists to remove any exhibits we either have not used or do not intend to use going forward. I have provided that list to defendant's counsel, and I'd be happy to distribute copies of that now if I may.
That'd be fine, Mr. Walpole. Have you also been able to identify the sections of the depositions that that may be used in advance so that Mr. Williamson could know what the cuts are of those depositions?
Yes, Mr. Chair. We have eliminated 2 full deposition transcripts. They are crossed out on this list that I will distribute. There's one remaining one, 300, which is Kim Weeks' deposition. It's 60 pages, and we went through and started eliminating pages, and we ended up eliminating fewer than 10. And so we figured let's just keep the whole thing in there for context's sake. It wouldn't really be helpful or save anyone time anyway.
All right, you can distribute those. Mr. Williamson?
Oh, that's fine. I appreciate the State Bar doing that. I do also, you asked about the answer.
Yes,
The
sir.
Mix up in the.
You can take this
numbering.
off if you want, Mr. Williamson, so we can
Oh,
hear you.
yes. Thanks very much. I'm prepared just to identify for everyone what the correct numbering is.
Let's do that if we can, just so that we're all on the same page.
It's fairly easy.
I have the answer to amended complaint in front of me. Do you want to direct me at that point, what I need
Yes.
to change? Starting
Yes.
at what page number?
Yes, well, everything I think matches up through page 11, paragraph 108, and that's when it kind of went off the rails.
My page 11 begins at paragraph 97. Should it be then 97 be 109?
I'm not,
The end of the way that and folks tell me if you have a different document, but mine says on page 10 ends with a long denial labeled as paragraph 108. And then as I go to page 11, it actually carries forward still part of 108. And the next number that appears on page 11 for me is paragraph 97.
I think that's the same thing. Paragraph 90, that's about the last third of the page. with
Yes.
that 97 appear. Okay, yes, that's the same document.
So 97 would then be,
97 would be 109. And that reference to paragraph 96 should be paragraph 108. And basically it continues like that.
just consecutively at that point.
Right, like 98 is 110. Again, the reference is 108. 99 is 111. Again, the reference is 108. The 100 should be 112. 101 should be 113. 102 should be 114. And 103 should be 115. So the wording of the answer isn't any different. It's simply to correct the misnumbering of the order of the paragraph.
That's fine. I just want to make sure we're all on the same page about that. Mr. Walthall, any issues about that?
No, sir. No objections. Thank you.
All right, we'll just, the panel accept that then as an amended answer to the amended complaint. Verbal amendment, that's fine.
I would have typed that up, except I didn't quite have the
Doesn't matter.
capability. to
We'll
do
just,
that.
we just noted now on the record that those changes have been made, so that should not be an issue. Are we ready otherwise to proceed?
Just to be clear, the State Bar does respectfully move to admit those exhibits that are on the amended exhibit list now. Move to admit those into evidence at this time.
Any objection, Mr.?
No
Williamson?
objection.
All right, those will be without objection. Those will then be accepted into evidence.
And then I wanted to handle this one separately. We would also at this time move to admit our timeline into evidence. And if I could just make a few points before we decide on that. One, this document, just as a threshold issue, is what we have said it is. And that is a summary of what the state bar contends are the key events and documents at issue here. We stated at the outset, this does not include every document, does not include every event. Additionally, now that those have been admitted into evidence, every document entry on the timeline contains a document that has already been admitted into evidence and it's been stipulated to. Third and finally, Rule 1006 of the North Carolina Rules of Evidence specifically says the contents of voluminous writings, recordings, or photographs which cannot conveniently be examined in court may be presented in the form of a chart, summary, or calculation. That's exactly what this is. It's an illustrative exhibit, a summary of all of the other exhibits to help the panel follow along. So on that basis, we moved to admit that timeline into evidence as plaintiff's illustrative trial exhibit 1.
Mr. Williamson?
I'm not objecting to its admissibility, or simply to note that it's a compilation document and not any kind of a source document, and it's prepared obviously as an advocacy piece and not as a fair and balanced timeline for the panel.
All right, that will be admitted, I believe, also under Rule 1006 that that complies with what that rule contemplates. So, anything else?
The state bar will rest at this time, although obviously we reserve the right to call any rebuttal witnesses and admit any rebuttal exhibits if needed.
All right, Mr. Williamson.
Thank you.
All right, if I may, before we call our first witness, who is going to be Dr. James Bellard, there's an exhibit that wasn't listed on our list that we would propose to provide now. It's not a new exhibit, it's a document that's been provided to the state bar before. Basically, it's a forensic report addendum from Dr. Bellard dated October 24, 2017, an addendum to his original report, which is exhibit 59. Do you have that? Make sure that state, I would ask that we be allowed to use that.
Any issues, Mr. Walthall?
Well, I'm not. We're trying to find out if we have this document or if we've seen it before. Can you help us with that, Lane?
Sure.
Was it produced in discovery?
Oh, yes, yes.
Okay, so
Along with 400,000 pages.
the October 24th, Lane.
Yes, sir.
Thank
You got it?
Thank you. Yes, sir.
Oh, I'm sorry.
Any objections, Mr. Walthall?
No objections. Thank you.
All right, thank you.
All right, Mr. Williamson, you may call your first witness.
All right, first, if I may note for the record, I am foregoing any motion at the end of the state bar's evidence,
All right, sir.
as is my right. Defendant would call as its first witness, Dr. James E. Bellard, MD. Around, sir, be sworn.
Sworn at the stand?
Yes, sir.
Up there. And
Dr. Bellard, if you would, sir, place the Bible place your left hand on the Bible and raise your right hand and face the clerk. Do you solemnly swear the testimony you're about to provide to be the truth, the whole truth, and nothing but the truth to help you God?
I so swear.
All right, sir, you may have a seat. Thank you.
And in order to make it easier for all of us, I believe we have the convention here. You can remove your mask during testimony while you're in this enclosed cubicle.
Yeah,
Thank you.
Dr. Bellard, the only thing we'd ask, and we've asked this of all the witnesses, that at the conclusion of your testimony, if you would take those wipes that are there with you and anything you may have touched or microphone may have spoken into, if you would clean those areas before you leave.
Sure.
Dr. Bellard, if you would state your full name and your business address.
So my full name is James E. Bellard. The last name is spelled B as in boy, E-L-L-A-R-D. I'm an MD. And my business address is 3900 Browning Place here in Raleigh.
And what is your specialty?
I work in general and forensic psychiatry.
And will you describe generally what that field consists of?
So general psychiatry is fairly self-explanatory. I treat people with a variety of psychiatric illnesses. My subspecialty that's more pertinent for our work here today is forensic psychiatry. And forensic psychiatry is that part of psychiatry that involves things before the court. So I evaluate people with criminal charges. I evaluate various kinds of civil competencies, and I have been involved in bar reviews and med board reviews in the past as well.
And have you on occasion testified and been accepted by the court or the administrative body as an expert?
Yes, on numerous occasions.
Could you tell the panel about your general educational and professional qualifications?
Yes, received my undergraduate degree at the University of Virginia in 1977. I went on to Emory University in Atlanta, where I got my MD in 1981. I did my psychiatric internship and residency at Chapel Hill and finished there in 1985.
And do you have any special certifications?
I am board certified in general psychiatry, and until 2 years ago, I was board certified in forensic psychiatry. I am not currently board certified in forensic psychiatry.
But you have been certified in the past.
I was certified as a forensic psychiatrist for 20 years. I decided not to take the exam because I'm moving toward retirement.
Okay. So you didn't give that up for any disciplinary reason from the medical board or anything like that, I take it?
No, sir. No, sir. Just personal preference, and I'll take the test.
At this point, Mr. DeVore, I would offer Mr. Ballard, tender him to the panel as an expert in general and particularly forensic psychiatry, authorized to give opinions in that field.
Any objection, State Bar?
No objection.
All right, yes, so is admitted as an expert in general and forensic psychiatry.
All right.
Thank you.
Now, Dr. Ballard, I want to take you back. Did you, at some point in the past, create a forensic report and investigation for a Mr. Henry McCollum?
Yes, I did.
Okay. And I'll bring up Exhibit 59.
Mr. Williamson, will these be done digitally, or do we need to pull the books out for
It
these?
should be done digitally.
All right,
If Mr. Megaro can do that without help. We can do it by paper, but we have the paper. All right, Dr. Ballard, what is on the screen there is the first page of Exhibit 59. Do you recognize that?
I do.
Okay. And I'm going to ask you a number of questions about that. And if at any point you want to point out or refer to something in that exhibit, just let us know. But first, I'll ask you, how did it come to be engaged that you were asked to do a forensic report on the patient Henry McCollum?
Mr. Megaro contacted me and asked me to evaluate Mr. McCollum.
Okay. And when was that?
The initial contact I don't have a record of. I would assume it was several months before this report was compiled.
And in response to that request, what generally did you do?
Reviewed a vast number of documents. Some pertain to the original crime of which Mr. McCollum was accused. Most of them were prior psychological and some psychiatric evaluations of Mr. McCollum. Some of them were depositions. Some of them were actual medical records from Central Prison. I interviewed Mr. McCollum in person on one occasion and by telephone on another occasion. And I interviewed his fiance and his sister. The fiance I interviewed in person, the sister I interviewed by telephone.
And is there listed in this Exhibit 59 the documentation that you reviewed?
Yes.
Okay. And does that begin and then go on for a number of pages, starting at page 2 of the exhibit?
So the list starts on page 1 and finishes there on page 2, and then a synopsis of what I thought to be important segments from those reviews is the ensuing pages, which goes on and on for quite a while.
And I'm not going to ask you specifically about every page and every notation that you made, but this for the panel, I'll ask you, according to your review, what stood out to you as important for your evaluation, if you recall?
Oh, okay. Well, what stood out from my review was that Mr. McCollum had been evaluated a number of times by psychologists, and that he had shown himself or demonstrated on those evaluations to have an IQ which varied between 56 and 71. Some of the earlier reviews also went further to diagnose Mr. McCollum as having what was then called mental retardation by doing what is required to diagnose mental retardation, which was to look at his scales of adaptive functioning. The more recent evaluations of Mr. McCollum, however, were lacking. There wasn't any recent evaluation of his IQ, and there was no recent evaluation of his scales of adaptive functioning. Notably, there was Dr. Corwin's evaluation, which was also from 2017, where Dr. Corwin diagnosed Mr. McCollum with intellectual disability, which is the new term for mental retardation. Dr. Corwin concluded that the IQs were subnormal, and that in Dr. Corwin's view, there was adequate evidence of lack of adaptive functioning. So he went ahead and made the diagnosis of intellectual disability. The rest of the record review was notable for the tragedy of what had happened to this man regarding the crime that he was falsely accused of.
Did you also review, in addition to historical records that you talked about, was there some additional testing information that you had access to that was more current?
There was very little current testing information. There was Dr. Harbin's attempt to test him, most of which was not valid, but there wasn't what I felt was a true recent battery of neuropsychological testing, which I stated in my report what I thought was lacking from the record.
Now, at some point, did you review some further testing by Dr. Harbin after this initial report?
Not that I recall.
If you would go to 171, is that right? Okay. You see that on your screen.
I see it on my screen. I will tell you and the court that I have not reviewed that for this purpose. So if you want me to comment on that, I'll probably need to take a look at it and read it.
Okay. Let's hold off on that for a while. Get through this. You mentioned Dr. Corwin's report. Do you have any comment to make specifically about the report that Dr. Corwin made at that time?
So I disagree with Dr. Corwin's conclusions and his approach. Dr. Corwin put a lot of stock in a score of 22 out of 30 on the Montreal Cognitive Exam, otherwise known as the MOCA. Dr. Corwin thought it was appropriate to diagnose Mr. McCollum with a separate cognitive illness based solely on the results on the MOCA, which I thought was inappropriate. The MOCA is a screening exam. Mr. McCollum's score on the MOCA of 22 certainly warrants further investigation, but it does not constitute a diagnosis. So I disagree with Dr. Corwin about that. I further disagree with Dr. Corwin about his conclusion that Mr. McCollum should be diagnosed with intellectual disability, because I didn't see evidence that he lacked adaptive functioning. Dr. Corbin said there was that evidence, but was, in my mind, wholly unspecific about what lack of adaptive functioning Mr. McCollum had. Dr. Corbin also made the conclusion that Mr. McCollum was not competent to manage his affairs, and my conclusion at the time was that based on the information I had, Mr. McCollum was competent to manage his affairs.
Okay, and I'll simply ask that question again that you just answered. Did you come to a conclusion as to whether Mr. McCollum at that time did have the practical ability to manage his own affairs?
I did.
And what was that opinion?
My conclusion was based on the interviews I had with him, the interviews I had with his family, which Dr. Corbin did not have, and my review of all the documentation, that the weight of the evidence supported that Mr. McCollum did have the capacity to manage his affairs.
And did you come to any conclusion as to whether he was in need of a guardian?
It was my conclusion, based on the information I had at the time, that he was not in need of a guardian.
Have you had occasion recently to review an additional or addendum report from Dr. Corbin?
Yes.
Okay. And do you have any comments to make regarding that report?
Well, none really different than what I just said. I think Dr. Corbin is still making the same statement that results on the MOCA constitute a diagnosis of something, intellectual disability plus something beyond that. And I did not find evidence in Dr. Corbin's report of the lack of adaptive functioning required to make the diagnosis of intellectual disability.
At this point, if you could take a moment and we can. Yeah, go ahead. I want to direct your attention to certain portions of your report, and if you need to look at others, just let me know. But I want to ask you some questions in Exhibit 59. First, I would direct your attention to page 11 at the bottom, where it lists some IQ scales, and over
Yes.
to 12. Okay, do you see there what's highlighted there? Several scores, 71 and 72. What's the significance of those, if any, of those IQ scores?
Well, they vary a good bit. There's a wide variation in the IQs that he's had. And the other point that I thought was important to make is that none of them are particularly recent.
Next, I would direct your attention to page 44.
Oops. Yes, sir.
Do you see that second paragraph? Mr. McCollum states that lawyers working with him on his appeal had urged him to consider taking a plea. What is the significance of that notation to you, if any?
Well, I thought it showed that Mr. McCollum, despite being under considerable duress and suffering from some fairly significant PTSD while he was in prison, continued to be his own advocate and to not take the plea because he believed in his own innocence. And I thought in that way, he was showing that he could be his own person, make his own decisions. It took a lot of courage for him to do that.
And at the bottom of that page, and going over to page 45, 46, and so forth, there's a narrative about, I would say, essentially what he's done since leaving prison, You see all that?
Yes.
Okay. What was significant to you, if anything, about what he had done since he had left prison?
That he'd been his own man, that he'd relied on his family for some help, and he needed that help, but that he had made his own decisions. He'd figured out where he was going to live. He had started a relationship with a woman, which apparently has continued, and that he made his own decisions on his own behalf.
And is that indication that of his adaptive skills?
I believe it is.
Yeah, let's go to page 48. While we're getting there, would you believe that somebody with the adaptive skills that you found that Mr. McCollum had would have any need for a guardian?
I did not think that he had a need for a guardian. I thought that he had the ability to use the supports that he had available to him, which were his family. He had a great deal of friction in his relationship with Mr. Tarleton that he went on and on about. And it appeared to me that he made decisions in a reasonable, considered fashion.
Okay. Now, in regard to his criticism of Mr. Tarleton, we have up on the screen there, page 48. Is that sort of representative of what he was telling you about the difficulties he had with Mr. Tarleton?
Oh, well, it's a direct quote.
And what, if anything, is the significance to your opinion about that observation?
Well, again, that he was acting as his own man, that when he perceived people as not working to his benefit, he was felt free to and was able to articulate clearly what his resistance to the process was.
And in so doing, was that, did you believe that was a reasonable observation for him to make?
I found nothing unreasonable about it, certainly.
I'm going to ask you a little bit about interviews with his sister and I believe his now fiance. But first off, why did you believe it helpful to conduct those interviews?
Well, we want to get as much information as we can. And it had seemed to me at that point that the crux of the matter about whether he should be diagnosed with an intellectual disability was the issue about adaptive functioning. And what we usually do to determine levels of adaptive functioning is interview family members or other helpers. The person who knew him best at the time was Keona Jones, his fiance, and I thought second best was the sister that I spoke with.
All right. And going to page 49, that's where you note your notation about your interview with Keona Jones. That's the fiance, correct?
Correct.
And then going on to 50, there's more, and then the interview with Latosha Hicks. And who is Ms. Hicks?
Ms. Hicks is his sister, Mr. McCollum's sister.
Now, looking at page 49 and 50, first off, the interview with Ms. Jones. What did you find significant, if anything, from your interview with Ms. Jones?
That she provided evidence that he acted independently. She gave him credit for having areas of intelligence that she did not. She found him able to do things around the house, maintain the relationship, maintain his checkbook, do things that we generally don't consider consistent with a person with intellectual disability.
including paying his bills and making car payments.
An
and,
active member of the household.
And then the interview with Ms. Hicks. What, if anything, that goes from 50 on to 51 and a bit on to 52. But looking at your synopsis of that interview, what, if anything, was important to you about your interview with Ms. Hicks?
She provided similar information about Mr. McCollum being his own man, making his own decisions. She was more accepting that if the court thought he needed a guardian, then they'd have to live with it. She provided corroboration for Mr. McCollum's report about how the amount of money he had been spent and why that happened. So that was useful. And she didn't provide any red flags of him needing a lot of help.
And in regard to his spending money, was there anything about his the way he spent his money that gave you special concern?
You were moving away from just the interview with Ms. Hicks now?
overall.
Okay. Well, sure. He spent a lot of money very quickly. It did give me concern. So I asked him about it. His statements about it, however, were entirely reasonable. He needed a lot of help while he was in prison to maintain his stance of his innocence. He needed the support of his family. And when he got out of prison, he wanted to reward them for what they had done. He bought a lot of things for a lot of people as rewards for their support for him. And that's really what Ms. Jones said as well. That's how she saw it.
Going on in the report, now you talked about your investigation of what you thought you needed to do in order to make an assessment of Mr. McCollum's adaptive functioning. Did Dr. Corvin do such an inquiry similar to yours?
Not that I read. He may have and not included it. That seems unlikely. Had he done it, he probably would report it. I can't say. But he didn't include it in his report if he did. I will note that my preference in my report was that things slow down and that Mr. McCollum receive a thorough neuropsychological evaluation and a more thorough evaluation of his adaptive functioning be done than what I had done. Certainly when in criminal cases, which I'm frequently involved in, where mental retardation or intellectual disability is an issue, the determination of a person's adaptive functioning is lengthy. It's not just talking to two people like I did or no people like Dr. Corvin did. It's talking to a number of people about what the person's adaptive functioning is. This was done too quickly. And I said that in my report, that we should pause and take a closer look at this, get a more recent IQ, do a full neuropsychological evaluation and a full evaluation of his adaptive functioning.
And of course, things have slowed down to the extent that it's now 2021. And Dr. Corvin has done another report. Has he done all those things that you think should have been done to do a more thorough examination at the time?
No, and to my knowledge, no one has.
Do you believe that what Dr. Corvin's supplemental report, do you think that adds to our understanding of whether Mr. McCollum has the ability to handle his practical affairs and needs a guardian?
I didn't shed any new light for me. It did provide the information that Mr. McCollum has continued to try to get his driver's license and hasn't been able to, which is of significance. But it doesn't sound like he needs other people to manage his affairs any more or less than when I evaluated him in 2017.
At this point, to refresh your memory, if we just take a moment to review 171, and we do have paper there. It's not, oh, that's right, it's not up there. I have. I think it would be easier to, if I can just hand up and let him read my copy rather than scroll through this.
How long is that report, Mr.?
It's much shorter. It's 7 pages.
All right, sir.
Thank you.
Any objection by the state?
Can we just request, this was not on their exhibit list, although it was turned over in discovery. If he needs time to read it, could we all just take maybe 5 minutes to read this? and take a
That
recess to
seems
do that?
fair.
Oh,
Why,
sure.
why don't we just recess for 5 minutes and everyone be at ease?
Okay,
Thank you.
That also means you don't have to.
Well, I'll sit here. It's easy, easiest anywhere. Thank you.
Mr. Chair, it may take more than 5, but we'll.
Just take the time you need. Mr. Williamson, you're still showing us on the screen. I'm not whether you're intending to do that or not, but just to let you know, you are still,
Oh, well, that's fine.
all right.
Fine.
I just want to let you know that was happening.
If I touch this, I'm gonna break it. I'm just looking through it myself. Yes, if you need to. Yes, that's fine. Be easier for you to refer to it if you do that. Yeah, of the 15 hours. First one versus recollection. Mr. DeVore, if it's okay, if I may take the time to go to the restroom, I have the old man's enlarged prostate.
More information than we need there.
Is that on the record?
feel like I just need to. So the lawyers never-
Let's go back on the record, Amy. Just tell me when you're ready. Mr. Walthall and Mr. Murphy, if you had time to review the document.
Yep.
All right. Further questions for this witness, Mr. Williamson?
Yes, Mr. Vore, thank you. Just briefly in reference to Exhibit 171, Dr. Ballard, during this break, have you had a chance to review that exhibit?
Yes, I have.
And is that an additional document that you prepared relating to the examination of Mr. McCollum?
Yes, it was.
And does that refresh your recollection as to whether you, subsequent to your first report, considered some additional information?
That's right, I did, but more testing from Dr. Harbin.
Right. And I'll come back to that because I'm not quite through with your initial report. If we could go back to Exhibit 59, just a few more questions about that report. Yes, at page 56. Now, there's the question posed there at the top, if we can see the top. What is Mr. McCollum's current level of adaptive functioning? And then you go to give your opinion. What is the importance of the consideration of adaptive functioning to make a diagnosis of intellectual disability?
So the diagnosis of intellectual disability doesn't rely just upon a low IQ, So a low IQ is required, but it's not sufficient. To make the diagnosis of intellectual disability, you also have to have evidence of significant gaps in adaptive functioning.
And in layman's term, what does that mean? Gaps in adaptive functioning. What sort of gaps could you give as
You don't manage your own affairs. You need significant help in managing your own affairs. You might not bathe, you might not brush your teeth. In his case, you might not be able to drive. Those are all practical matters of adaptive functioning.
Okay. And now, as an MD, are there certain matters about to test adaptive functioning, some testing that you have to rely on another professional to do?
So in general, when I have testified about a diagnosis of intellectual disability in other matters, I have relied upon a psychologist to do the assessment of adaptive functioning.
And was that done in this case to an extent?
So after my initial report and before my addendum, Dr. Harbin saw the patient again and did an assessment of adaptive functioning.
And did you rely upon that in forming the opinion that you have today?
Yes.
I'll come back to that. But first, I want to ask you some more about your earlier opinion. And we go down to the bottom of page 56. And I believe you're speaking about whether Mr. McCollum has the functioning of a child due to his IQ. Could you make any comments that you think are relevant about that?
Well, the worst testing or the lowest testing of Mr. McCollum showed him to have an IQ of 56. And then one of the commentators who said he had the functioning of a 9-year-old child, and I just thought that was unfair. The testing shows him to have significantly higher levels than 56. And the way he comports himself in the world, I thought, was not consistent with that of a 9-year-old child, but was consistent with what many adults have.
Okay. If we go to the next page, 57. And you talk about some factors there that are not childlike.
Right.
And you make the statement, this is simply not the functioning of a person with the IQ of 56 or the adaptive function of a 9-year-old. That's your opinion?
That is my opinion.
And it's still your opinion?
Remains my opinion.
Okay. And going further down that page to the heading forensic opinions. And this is where you really give your opinion, correct?
That's right.
And if you would, read the highlighted portion, and I'll just ask you if that's still your opinion.
The purpose of this evaluation is to provide an opinion as to whether Mr. McCollum requires a guardian. It is my preliminary opinion, based on the information presented to me thus far, that he does not. However, I believe that this opinion is not fully informed and that we need more data regarding his current intellectual functioning and more data regarding his current adaptive functioning before a definitive opinion can be given.
All right. And you have talked about needing more data, and that was something that Dr. Corbin certainly did not provide, correct?
I didn't see Dr. Corbin's evaluations as providing more data, no.
Okay. Now, having reviewed Exhibit 171, did you, after this preliminary opinion, get some additional data that was helpful to you from Dr. Harbin?
Yes, I did.
Okay. And now, hold on. Okay. Are we 171 now? Yeah. Okay.
First page.
Okay, we're going back to 171. Is this where you give your opinion again, having taken into consideration some additional information from Dr. Harbin?
You are on page 5.
Page 5. Is that right? Okay. Of 171. And it's also on your screen. Do you see that?
I do.
And if you could read, just read that paragraph under answers to forensic questions.
Sure. I gave a provisional opinion in my initial report that Mr. McCollum did not require a guardian, page 57. The initial information provided by Dr. Harbin's, the additional information provided by Dr. Harbin's neurocognitive evaluation confirms this opinion. Mr. McCollum's intellectual difficulties are quite mild. His deficits in adaptive functioning similarly are quite mild. It remains my strong opinion that if Mr. McCollum were to be seen by the court as incompetent and in need of a guardian, that he would be the highest functioning individual that I have ever, in over 36 years of psychiatric experience, evaluated for competency to be adjudicated incompetent.
And that was that last sentence about your opinion as to whether he would be the highest functioning individual that you've ever, in your experience, evaluated for competency to be adjudicated incompetent. That was also a conclusion that you expressed in your earlier report as well, correct?
That's correct.
So is it fair to say that basically the opinion that you felt qualified to give at that time was simply buttressed by the additional information that you got from Dr. Harbin?
Yes.
And what was the nature of the additional information that Dr. Harbin provided to you that you reviewed and believed was relevant to your opinion?
He provided a more recent IQ, which showed an IQ of fairly high. It was still in the range allowed for intellectual disability of 69, just south of the number 70, which is kind of the magic number. And he provided
The
some
magic number that the diagnosis can change if you're under 70 as opposed to over 70.
There's a lot of disagreement in the psychological field about whether you could even be diagnosed at 71 because of statistical margins of error that Dr. Harbin could probably comment on more intelligently than me. But 70 is the number. And to be at 69 is pretty darn close to 70 is my point. And also I had a great concern that it had been 20 years since his IQ had been tested. So I thought 69 was low enough to make the diagnosis, but still high enough to be worthy of consideration for what his true functioning was. The other information that I got from Dr. Harbin's subsequent report was that there was nothing in Dr. Harbin's evaluation which confirmed Dr. Corbin's additional cognitive diagnosis of unspecified neurocognitive disorder with frontal lobe and executive functioning impairment, which Dr. Corbin appears to have made based solely on a MOCA exam, which I think is inappropriate. So there may be the diagnosis of intellectual disability based on a number of 69 and based on very mild adaptive functioning deficits, but there's no other neurocognitive illness there.
And in making these sorts of diagnoses, it's not like a mathematical equation, correct? You take into account a number of factors. Right. This kind of evaluation, is it formulaic?
Is it formulaic? Well, it's formulaic in that we have to follow the current DSM. So you got to go by what the DSM-5 says. In that sense, it's formulaic. I think what I'd offer is that what isn't formulaic is the determination about competency. One can be intellectually disabled, one can be mentally retarded and not require a guardian. The majority of people with mental retardation, now called intellectual disability, do not require a guardian. They manage their own affairs with the help of family members if necessary. But it doesn't, if you are diagnosed with intellectual disability, it doesn't automatically mean you need a guardian. That's not formulaic at all.
Is it fair to say that intellectual disability and competency, as we've looked at it here, are not necessarily the same thing?
They're separate determinations. And one has to be formulaic based on the DSM-5. The other has many other determinant factors.
And just to be clear, which is formulaic and which has to be determined?
I'm sorry, the formulaic is the diagnosis of intellectual disability. The non-formulaic is the determinant of competency.
Just a couple of things in your original report. Going back to 59, at page 58. At page 58, those two paragraphs above what we've already talked about, that is your bottom line opinion. But you discuss about how he spent his money and the interest, the loans that he got and so forth. What, if anything, was the significance to you of those matters? And if you have that in front of you, if you could just comment on that.
Well, regarding the money that he spent, I found that he provided rational reasons, rational reasoning. I guess reasoning is always rational. Anyway, reasonable thinking about how that money was spent. And this was an opportunity for him to tell me that, that the money had been spent to reward his family for their unending support of his endeavor to gain his freedom. He felt he had probably made some mistakes and should have saved more money for himself, but he spent the money largely out of generosity on his family. And regarding the loans, he likened his thinking about the loans to the fact that he needed the money after spending too much, and that his understanding of the loans was similar to loans that he had been involved in and been aware of in prison.
And then if we scroll down just a little bit, that's the last paragraph of your opinion. If you could initially, if you could just read that, I would additionally note.
I would additionally note that if the court determines that a guardian is needed for Mr. McCollum, he will most certainly be the highest functioning individual I've ever, in over 33 years of psychiatric experience, evaluated for competency to be adjudicated incompetent.
And as you previously testified, that was also the conclusion after you got additional information from Dr. Harbin, correct?
That's correct.
And is it still your opinion today?
It is still my opinion today.
And in terms of your psychiatric experience, you talk about years of experience. If you could tell us about the extent of the evaluations of folks you've done for competency.
It would be an estimate. I've been doing competency evaluations throughout my forensic career. The forensic career started in '93. So that's 23 years of forensic experience. I had more psychiatric experience prior to that. Actually did some competency evaluations then. I would estimate that I have evaluated 100 people for competence.
All right, thank you. I'm sure you'll have additional questions from the State Bar.
Cross-examination.
Yes. Dr. Is it Ballard?
Ballard.
My name is Pat Murphy, along with Josh Wathall. We represent the North Carolina State Bar in this proceeding. Do you understand what this proceeding is about?
I don't have an extensive understanding of it. I will tell you my understanding of it is that it's about Mr. Megaro and whether he acted ethically in his
Please.
representation.
He's away from the microphone.
Oh, I'm sorry.
Sitting there, bring it closer.
My apologies. I'll move it. No, can't move it. Okay. My understanding is that it's about Mr. Megaro and whether he acted ethically in his representation of Mr. McCollum.
When did you first get involved in this matter? And when I say in this matter, I assume at somebody's request was the first time you met Henry McCollum.
Oh, that matter.
Yeah.
I would say there's two matters, but the involvement with Mr. McCollum would have begun in summer of 2017 when I was contacted by Mr. Megaro.
And what did Mr. Megaro want?
An evaluation about Mr. McCollum and his whether he had a psychiatric diagnosis and his competency.
His competency for what?
To agree to a series of settlements regarding civil suits.
A series of settlements of civil suits?
Civil suits, yes.
Okay. And so he wanted you to know if he wanted you to evaluate Mr. McCollum to see if Mr. McCollum was competent to agree to a civil settlement or civil settlements.
Yes.
And was that the limited scope of his request to
As
you?
I recall it.
Okay. Was there anyone else involved in conducting mental evaluations of Mr. McCollum at that time?
I asked Mr. Megaro if a psychologist was involved because I knew there would be some issue about intellect. And he told me that Dr. Harbin was involved.
Did you consider that you and Dr. Harbin would be a team?
Only if we agreed.
Okay. And your evaluation was it the purpose of your evaluation to just opine or render an opinion on that one issue of whether Mr. McCollum was competent to accept the settlement agreement, or was it to produce a report more compelling than Dr. Corbin's?
I was certainly never asked to produce a report more compelling than Dr. Corbin's. I was asked to consider Dr. Corbin's report.
Mm-hmm. Did you ever tell Mr. Megaro that you needed certain information to make your report more compelling than Dr. Corbin's?
I stated what I stated in my initial report, that more information would help me arrive at a diagnosis.
Okay, so we'll get back to that in a minute. How are you going to be compensated
For the evaluation of
evaluation
Mr. McCollum?
Yeah.
I was going to be compensated by Mr. Megaro.
And did you have a fee agreement with Mr. Megaro?
We did.
And what was that fee agreement?
I don't have it with me, but as I remember, it was probably $400 an hour. It may have been $360 an hour. I was in the process of changing that number.
Okay. And did you have extensive conversations with Mr. Megaro about the evaluation that he wanted?
I wouldn't call them any more extensive than any other evaluation of this sort. I think we talked initially for 15 minutes, and we probably talked 2 or 3 more occasions after that. We have 20 minutes each.
So probably 15, 20, and 20?
Yeah.
Have you spoken to him and getting ready for this hearing today?
Have not.
Now, what did you understand Mr. McCollum's situation to be at the time you did your evaluation? And according to your report, I believe your evaluation was done, at least interviews, on September 19 and September 22 of 2017.
Your question is, what did I understand his situation to be?
Yeah.
He's living with his fiance in South Boston. He was not in good shape financially. He was looking at other, let's call it settlements that might help him financially. It was his opinion, Mr. McCollum's opinion, that his ability to make those decisions himself was threatened. And that some people were stating that he did not have the ability to make those decisions himself. That's a fair synopsis.
And did you have a guardian at the time?
Yes.
Who was his guardian?
I gather it was Mr. Tarleton.
Did you speak with Mr. Tarleton?
I did not.
Why not?
Why did I not speak to Mr. Tarleton? I don't remember.
Told
my-
not to?
I don't remember. Oh, I was not told not to. No.
Yeah.
I don't remember my thinking about it at the time.
Well, had Mr. Tarleton already had some interaction with Mr. McCollum?
Yes,
Just
Mr. McCollum
recently.
described that for me. Yes.
Right. And lawyer, professional, had been appointed by the court as a guardian. You didn't think it was important to talk to him?
Well, as I said, I don't remember my thinking about it at the time.
And did you know that a federal court, have you ever testified in federal court in Eastern District of North Carolina?
Oh, yes.
And have you ever testified in front of Judge Boyle?
Had not.
Did you know?
No,
that
still have not.
Did you know that Judge Boyle had appointed Mr. or was, we'll strike that. Judge Boyle had already appointed Mr. Tarleton as Mr. McCollum's guardian at that time. And when I say that time, I'm talking about the time you interviewed him.
So I did not know it was a matter of settled law at that point that a guardian had been appointed. I thought there was a question about whether that was going to continue. I thought that was part of the question that I was trying to answer.
Do you know whether Mr. McCollum has a guardian right now?
I have assumed that he does, but I don't know that.
But you don't think he needs one?
I haven't been presented with any information to change my opinion of 2017.
And have you sought any additional information about Mr. McCollum since your addendum to your report? And I believe the addendum is dated in October of 2017.
I was provided with Dr. Corbin's report update. That's all.
And that was more recently.
Yes.
Okay. Was that in an email or how did you get Dr. Corbin's report?
Yes, that was in an email.
From whom?
Mr. Williamson.
And how long ago was that?
About a week.
Do you know where Mr. McCollum is living right now?
Based on Dr. Corbin's report, he's still living in South Boston.
Do you know whether Mr. McCollum currently has a guardian or some kind of conservator in the state of Virginia who is managing an irrevocable trust controlling his funds?
I'm not aware of that.
Is that important to you at all?
It's reasonable information to know.
Okay. But to this, as of you testifying right now, you did not know that.
That's correct.
Now, at the time you came on board in the summer of 2017 at Mr. Megaro's request, what information were you supplied to assist you in what you needed to do?
What's listed on page 1 and 2 of the report.
Would this be exclusive or is there anything else you considered?
It would be inclusive. That's everything.
It's everything. So there's nothing else that you considered other than what's on here.
That's correct.
Okay. Were you aware of the positions Mr. Megaro and in fact, Dr. Harbin had taken with respect to the civil litigation that was going on in terms of Mr. Megaro's competency, his adaptive functioning skills, his IQ, those type matters? Were you aware of the positions they were taking in that case up to that point?
Mr. Megaro made me aware of his position about it in the introduction to the case.
Okay.
And I learned about Dr. Harbin's position when I read his report.
And which report was that of Dr. Harbin?
Well, there's 2, so it would be the earlier of the 2 at that point.
Okay. And
I'm sorry. And then there was a deposition, I think, of Dr. Harbin, which further elucidated his opinion.
all right. And what position were they taking in the civil suit on behalf of Mr. McCollum in terms of his intellectual abilities or disabilities and his adaptive functioning skills or lack thereof? if you know?
My memory of it is that it was their opinion that he could enter, he was capable and competent to enter into those agreements.
I'm talking about claims he was making in his civil lawsuit. Do you understand? Do you know what claims he was making in the civil lawsuit?
I don't have the details of that.
Well, let's go back to the beginning. Do you know what happened to Mr. McCollum I believe it was in September of 1983?
Yes.
What?
Well, it's detailed in my report, but he was falsely accused, arrested for murder. He and his brother were arrested for murder, and he was tried by the state several times, found guilty several times, and sentenced to death several times. Subsequently, he was released, and money was provided him, starting some of the cascade of events that ended us up here.
In fact, Mr. McCollum and his brother Leon Brown were questioned. First, Mr. McCollum was questioned by law enforcement officers regarding the murder of a young 11-year-old in Robeson County. You knew that?
Yes.
And that he was the claims in the civil suit was that he was questioned for several hours by law enforcement.
Okay, so what I want to be clear about is that I have that from the news. I have that from Mr. McCollum. I've never looked at any of the civil suits themselves.
I'm just asking you if you're aware of this as it pertains to your ultimate opinion that you rendered.
I was aware of it at the time,
Okay.
and I'm aware of it now, yes.
And as part of that investigation, Mr. McCollum was how old at the time, if you recall?
When he was accused of murder?
Right.
Gosh, he was young. He was like 12.
Huh?
He was young. I don't remember his age.
He was 12. He was 19.
19. Okay.
And he had. Do you know whether there had been any psychological testing of Mr. McCollum prior to 1983?
Yes, we have records of prior testing.
And in fact, he had gone to school in Jersey City, New Jersey, correct? And there was information about very low IQ scores there, correct?
That is correct.
And he was in special ed classes.
He was in special classes.
Were you aware he had dropped out of school in the 9th grade?
It's in my report, yes.
Okay. And that he, after being questioned by law enforcement officers for several hours, he gave a confession.
Well, that's up to, there is some question about
He gave a
that.
statement that was inculpatory. Would you agree with that?
He signed a statement that by his report was prepared by the officers.
And were you aware that at some point he told the officers after he signed it, could he go home then?
Yes.
Does that suggest to you someone who's naive, someone who is vulnerable, someone who is suggestible by the comments or conduct of others?
Sure. Yes.
And in fact, that was the claims that was made throughout the next 31 years on behalf of Mr. McCollum, that he did not have sufficient intellectual abilities. He was suffering from, back then, mental retardation. We now call it intellectual disabilities disorder, and that he had frontal lobe injury, that he had been knocked out and raped on one occasion, that he had had a head injury when he ran into a dumpster type fixture, and that at the time he was questioned by law enforcement officers and read his Miranda rights, he did not have the mental capability of understanding those rights.
Well,
Did you understand that those were the claims that were being made for about 31 years?
Those were the claims that were being made. The idea that he couldn't be properly Mirandized, he wasn't competent to give a confession, I don't think was ever upheld by a court.
Right, but those were the claims that were being made on his behalf.
Those were the claims being made.
And do you know who was primarily making those claims for him?
I assume Mr. Rose.
Mr. Rose and lawyers who represented him at least at the second trial. Do you aware of any claims that lawyers were making at the second trial on his behalf regarding his ability to understand the confession?
No, I don't.
And so you mentioned Mr. Rose. Do you know Mr. Rose?
We've met.
Okay, and how have you met?
We did a case together.
Okay. And do you find, what case did you do together?
I don't remember.
Did you find Mr. Rose to be an honest man?
Sure,
Did you work together with him for some period of time?
I did.
Do you know he was head of the Center for Death Penalty Litigation in the state of North Carolina for decades?
Yes.
That he's worked tirelessly on behalf of death row inmates over the course of his entire career to try and give them legal representation in the state of North Carolina on claims that may result in some relief from their death sentences?
Yes.
Do you know that he worked with Henry McCollum for many years, over
Yes.
20?
Yes.
Do you know he has testified in his court that he, at this hearing, that he met with Mr. McCollum several times, and that they developed a strong friendship, at least from Mr. Rose's point of view,
I didn't know that.
and that Mr. Rose, every time he met with Mr. McCollum, essentially every time Mr. McCollum would protest his innocence?
Mr. McCollum told me that.
And that Mr. Rose and the Center for Death Penalty Resources filed a motion for appropriate relief on behalf of Mr. McCollum and gathered information for that motion for appropriate relief pertaining to his mental and emotional evaluations that he'd had over the course of his life.
I'm aware of the motion. I haven't read it.
Okay. Were you aware that Mr. We'll come back to that. If Mr. Rose has testified in his proceeding that he believed Mr. McCollum needed a guardian, was incompetent to enter into certain loans with multi-funding, and he was not competent to enter into the legal services agreement with Mr. Megaro, would you give weight to Mr. Rose's opinion?
If I were the court making the decision, of course.
Is there anything you know about Mr. Rose that would cause you to not believe something Mr. Rose said?
No, I don't. I think he's an honest person. I would state that Mr. McCollum, in my interview with Mr. Rose, did have some differences with him.
Who had differences with?
Mr. McCollum had some differences with Mr. Rose. That's
Right.
all.
And let's assume Mr. McCollum has IDD and PTSD. Would it be surprising to you that Mr. McCollum might disagree with Mr. Rose about Mr. McCollum's need for a guardian or some assistance in handling his daily affairs?
It would not surprise me.
Now, you are aware, are you not, that with the assistance of Mr. Rose and Vernetta Alston in the death penalty Center for Death Penalty Litigation, that they filed a motion for appropriate relief on behalf of Mr. McCollum, and that they were ultimately successful in getting him exonerated?
Yes.
And that as part of their strategy, they went the route of a motion for appropriate relief. And they also got information from the North Carolina Innocence Inquiry Commission showing DNA taken from the crime scene that Mr. McCollum was convicted of, found DNA evidence that matched to another person named Roscoe Artis.
Yes, I was aware of that.
And that ultimately they were able to get Mr. McCollum exonerated. A Superior Court judge set aside both his convictions and the judgments in his case in 2014.
I was aware of that.
And were you aware that Mr. Rose had arranged a group of civil attorneys to assist Mr. McCollum in pursuing whatever civil rights or whatever claims or torts he may have as a result of his wrongful conviction?
I was aware of that.
And were you aware that Mr. Rose and Vernetta Alston, pro bono, filed a petition for a pardon of innocence with Governor McCrory?
I knew that someone had. I did not know it was them.
And do you know that while that pardon of innocence was pending, that is when Mr. Megaro got involved in the Mr. McCollum's case?
I did not know precisely when Mr. Megaro was involved.
And did you know that Mr. Rose was intending, we'll strike that, let me back up. Do you know anything about the General Statute 148-84, essentially that provides compensation for people who are wrongfully convicted?
No, I don't.
Okay. Essentially how it works is if you meet criteria under the statute, in Mr. McCollum's case, if you have a pardon of innocence from the governor and you have been incarcerated for a period of time as a result of that, then you are entitled to compensation from the state of North Carolina. And I believe it's $50,000 for each year of wrongful incarceration, capped at $750,000. Now, did you know anything about that with respect to Mr. McCollum's case when you were doing this evaluation?
Only what I would have read in the media before being involved in the case.
In the media? Is the media listed in your items?
No.
Anyway, we'll look at that.
No, it's not.
So my point to you, Mr. or Dr. Ballard, is that under the statute, if you have a pardon of innocence and you can show from Department of Correction records that you have been incarcerated for the crime for which you got the pardon of innocence, you get the money. You understand that?
Yes.
And that in Mr. Megaro's case and in the case of his brother, Leon Brown, they were entitled to $750,000.
Okay, you meant Mr. McCollum's case and his brother, Mr. Brown. You said Mr.
Leon, yeah, I
Megaro.
misspoke. Yeah, in both Mr. McCollum's case and in the case of his half brother, Leon Brown, they were both entitled to $750,000 under the statute. Did you know that?
Yes.
Okay. Did you know that Mr. Rose was going to represent Mr. McCollum in the Industrial Commission pro bono?
No, I did not know that.
Okay. So do you understand what pro bono means?
Of course.
That he wasn't going to charge him anything.
Mhm.
That Mr. McCollum would walk out of this proceeding with a check for $750,000. No attorney's fees. Did you know that while the pardon of innocence was pending before Governor McCrory, that Mr. Megaro then became their attorneys, and that Mr. Megaro signed a legal services contract with Mr. McCollum and Mr. Brown, under which he would get 1/3, roughly 1/3. It was on a graduated scale or sliding scale, essentially 1/3 of any recovery, including the Industrial Commission money and including any other civil litigation that may be involved. Did you know that?
No. I assumed that Mr. Megaro had an agreement with Mr. McCollum that he would be reimbursed part of proceeds
Right.
from Mr. McCollum gave.
Do you know if Mr. Megaro, when he had Mr. McCollum agree to that legal services contract, and we know that this happened in February of 2015, that when do you know whether Mr. Megaro told Mr. McCollum, listen, if you stay with Mr. Rose, you get the full $750,000. If you hire us, we're going to take a third of that, and you'll only get $500,000. You know if that conversation ever took place?
I have no idea.
Do you think Mr. McCollum was competent to enter into that legal services agreement, willing to give up $250,000 to Mr. Megaro for work that the lawyer on the other side, the lawyer for the state of North Carolina, was not opposing and was guaranteed money?
So to answer your question, I would have to talk to Mr. McCollum about those issues.
You did
And
not.
find out what I did not, and find out what his reasoning was.
Do you think that someone who you now, as I understand it, you have agreed that he does have some adaptive functioning deficits?
Right.
You initially did not, but now you do. Is that correct?
That's correct.
And he does have a sub 69. So even though it's close, he does meet the criteria for intelligence deficit disorder.
Yes.
Do you think that someone who is able to communicate, understand complex matters, and has the intellectual disability disorder that you now diagnosed him as having, would you have concern about whether that person is making a rational decision by essentially giving away $250,000?
Yes.
Pardon? You would have some questions.
Yes. Yeah, it's the way you've got it set up here. It's hard to look at him and be near the mic.
I'm sorry. Well, that's what happened. Is Mr. McCollum signed a legal services agreement with Mr. Megaro, and they went into court, into the Industrial Commission, and at the Industrial Commission, in a transcript. You understand what a transcript is? I know you do. In the transcript that's 7 pages long, the hearing officer said, which was unopposed by the state, all right, he granted both claimants $750,000. And at that point, Mr. Megaro walked away with a $250,000 fee from Mr. McCollum, and then $250,000 fee from Leon Brown. Did you know that?
I did not know that detail. No.
Do you think it might have been helpful for Mr. McCollum to have had a guardian or some other person to explain to him that Mr. Rose was going to do this pro bono, and that by signing this piece of paper, this legal services agreement, that with Mr. Megaro, that you're giving away $250,000. You and your brother together are giving away $500,000 for, which is essentially a matter where you check boxes. Do you think it would have been helpful? Maybe he had a guardian like Ray Tarleton at that point to say, you know what? You may not want to enter into this agreement. Maybe you want to set aside the Industrial Commission matter and then just consider maybe just going with him representing you on something other. Let Mr. Rose do this pro bono, and you walk away with a whole $750,000. You think a guardian might have been helpful to him in that situation?
In answer to your specific question, it might have been helpful. Whether it would be fully in Mr. McCollum's best interest is another question. And it really would require discussion with Mr. McCollum about that.
Mhm.
But your question is, might it have been helpful? And it might have been.
Does it concern you at all that Mr. McCollum, under those facts, just gave away $250,000 that he could have had himself?
It concerns me in that it would be worth asking him questions about what his reasoning was at the time.
But didn't I hear you say several times that Mr. McCollum is his own man? That was your impression from him? He was his own man,
It's very important.
acting as my own man?
It's been very important for him to present himself as his own man. And I think he shows himself to have done that in many of the decisions that he's made.
You have your report there with
The
you?
initial one?
Yes.
Yes, sir.
Sorry. Yep, please. It's 59. Defense Exhibit 59. Do you have your report in front of you, Doctor? Yeah.
Yes, I do.
Okay. Will you look over I went over this briefly earlier, but down at the bottom of page 1, there's several numbers listed, and you said that this is inclusive. That is all the information you had available to you when you made your initial evaluation.
Well, to be complete, the information used in the preparation of the report is listed on page 1 and 2, and it includes all of that printed information, and then includes the in-person interview with Mr. McCollum, a telephone interview with Mr. McCollum, telephone interview with Miss Jones, and a telephone interview with Miss Hicks. And then at the bottom of page 2, it is, I have discussed the case extensively with Mr. Megaro and had a conversation with Dr. Hartman. So that's the full list, yes.
Is the retainer agreement for Mr. Megaro listed here?
No,
You didn't have a copy of that?
I don't have a copy of it with me. I've had a copy in the file.
And I believe at the first of it, you said under the introductory information, has we'll just read that.
The introductory information?
Yeah. First
In
paragraph.
September of 2017, I was approached by Patrick Megaro, who asked that I perform a forensic evaluation on his client, Henry McCollum. Mr. Megaro asked that I provide an opinion, if possible, regarding whether Mr. McCollum, quote, has the practical ability to manage his own affairs, unquote, and whether he is in need of a guardian.
And you knew that he had a guardian at that time, Mr.
I
Tarleton.
did not realize it was settled law that he had a guardian. I thought there was a question before the court about that. It became clear when I tried to testify that it was settled law.
Who told you that it wasn't a matter of settled law?
Who told me that it was? The
Who
judge.
told-
The judge.
Huh?
The judge.
What judge?
The judge at the hearing where I wasn't allowed to testify.
Oh, I'm sorry. I think we're talking across purposes.
All right.
Who told you it wasn't a matter of settled law?
No one told me it wasn't.
So you were there to answer the question whether Mr. McCollum has the practical ability to manage his own affairs. Is that and is in need of a guardian? Is that more limited than doing an evaluation of whether he's competent?
I would say it's a matter of simply of wording. It's the same thing.
The same thing? Competency to do what? Competency at that moment, competency retrospective for some decisions he's made, or what?
That wasn't specified by Mr. Megaro.
So how were you taking it?
I was taking it competent to make decisions in his own, to manage his own affairs at the current time.
A snapshot of that moment. Would that be true?
Yes,
Yeah. So you weren't looking back retrospective. You were just looking at this moment. Is he competent to manage his own affairs?
the question to be answered was his competency at the moment, but of course, informing that is whether he's made competent decisions previously.
And did you offer an opinion on whether he'd been competent previously, or did you offer an opinion of just what he's competent at this time?
I was not asked to do the former, I did the latter.
Okay. Did you see the petition that Mr. Megaro had filed with the Industrial Commission?
If it's not on this list, then the answer would be no.
Dr. Billard, over on your screen to your left, you should be able to see a document. And if you will look at that, do you see the caption of it? Sorry, the caption. This is an industrial commission proceeding, a verified petition of compensation pursuant to Chapter 148. You see how it's captioned there?
I do.
And it's the claim of Henry McCollum. You see that?
I do.
And if you scroll down all the way to the bottom, let's see who it's signed by. You see where it's signed by Patrick Megaro on June 19th of 2015?
I do.
All right, so let's go on up to paragraph 3. Excuse me, paragraph 2. Would you read paragraph 2 into the record?
At all times hereinafter mentioned, both men had and still have limited mental abilities. Mr. McCollum's intelligence quotient, IQ, has been scored at 56, while Leon Brown's IQ has been scored at 54. Both of these IQ scores are within the intellectually disabled range, classified by some as mental retardation.
You know, I asked you some questions earlier. Did you know what positions Mr. Megaro was taking on behalf of Mr. McCollum in the civil action and in the proceedings to gain compensation? Does this help illuminate that he was taking the position that both men had limited mental abilities?
That's how it reads, yes.
And that he was representing to a court that they both had IQs in the 50?
That's what it says, yes.
And was there a basis in law or a basis in fact, for him to make those claims?
Yes.
Because Mr. McCollum had been diagnosed by several mental health professionals who had scored him in the 50s.
Question?
Yeah.
What's your question?
Had Mr. McCollum been evaluated and had IQ scores in the 50s as represented by Mr. Megaro in his petition before the Industrial Commission?
Yes, he had been.
Now, I understand that you say that there can be some variation in those scores, but if you're saying someone's got a 50, isn't that saying that that's a pretty low score, isn't it?
It is.
I mean, there would be no question if someone had well, I won't say no question, but if someone had a 50 on a IQ score, would that not at least say this bears more investigation, some more due diligence, and let's find out whether this person is suffering from some mental or emotional disability that's impairing their ability to do whatever?
Yeah, yes, it would.
And so that's what he's representing to the Industrial Commission, that he's got two clients who have significantly low IQ scores.
I'm sorry. frequently you'll make a statement and I think you mean it as a question. I hear it as a statement. Do you want me to just agree? Is that?
I agree,
used to
Mr.
answering
Murphy.
questions.
Please make the questions, and I have some of the same issue. Please
Thank you.
phrase those in terms of questions.
Happy to answer your questions.
Did, according to that document, Mr. Megaro represent to a court that Mr. McCollum had a significantly low IQ score?
Yes.
Um, Let me refer you, if you look at the screen, this is the 116. You see what it's the heading of the exhibit is?
Yes.
And what is that?
It's a petition for adjudication of incompetence and application for guardian and interim guardian.
And there's a file stamp on it. Can you see when it was filed?
August 17th of 2015.
And it says, it starts out Patrick Michael Megaro, Esquire. So it's a petition not filed by Mr. Megaro. Do you see that?
Yes.
Were you aware that he had petitioned to have Leon Brown, the half brother of Mr. McCollum, found incompetent?
No, I was not.
Have you ever seen this petition before?
I have not.
Do you know who became the guardian for Leon Brown as a result of this proceeding?
I do not.
Do you know Geraldine Ransom?
Say the name again.
Geraldine Brown Ransom.
I do not.
You know, she is a sister of Mr. McCollum and was his sister of Mr. McCollum, was appointed the guardian for Leon Brown.
I knew that Mr. McCollum had a sister of that name. I did not know she was the guardian of Mr. Brown.
She wasn't all, she was later removed, but she was initial. Did you know that?
No.
We're going to scroll down to paragraph 35 of the petition, and if you'll start about midway, a little. Well, you see where it says $2,500, and there's footnote 3, the one right below that, where it says both brothers.
I see it. Yes.
Start the first full sentence.
Both brothers need assistance with budgeting their monthly allowance because they are unable to understand the concept of paying utility bills and making purchases. One thing is clear, neither Leon Brown nor Henry Lee McCollum have a concept of budgeting or spending limits, nor do they have any experience in managing money, let alone large sums of money.
And if you read the highlighted portion here.
The secondary purpose of the trust is to protect both Leon Brown and Henry Lee McCollum's assets from fraudsters and frivolous spending.
You scroll down to the bottom and see who this is signed by making this petition. Do you see who's making this petition?
I do.
And who is that?
Patrick Michael Megaro, Esquire.
And that's on August 14th of 2015.
Yes.
Did you know when you were doing your evaluation that Mr. Megaro was taking the position that Henry Lee McCollum was in need of assistance of handling his money?
No.
Did you know any of the information that is contained in that petition?
No.
Is that contrary to what you were led to believe with your discussions of Mr. Megaro?
Mr. Megaro's opinion that he expressed to me was that Mr. McCollum was managing his money and that he was competent.
You reviewed several reports from various mental health professionals in putting together your initial report. Is that correct?
More than several.
Yeah. In fact, there's an extensive history of Mr. McCollum's being seen by mental health professionals over the course of his life.
There's a lot of evaluations, yes.
And you had medical records from reports by Dr. Harbin, correct? On
Right.
page 3.
Yes.
And one of the notations you made is that after having no understanding of the consequences of the confession, he, meaning Mr. McCollum, asked, "Can I go home?" You put that in your report. Why was that significant?
It was part of how all this began.
And do you find it unusual that someone who had just signed a document that implicated them to a horrible murder would then be asking, "Can I go home?"
It indicates a lack of full understanding of what's going on, sure.
Over on page 4, quoting Dr. Rumor. Do you know, I don't know if I'm pronouncing it right, but do you know Dr. Rumor?
I don't think I've met Dr. Rumor, no.
Okay. Would you read that first where it says quoting from affidavits of Dr. Rumor, that first paragraph there?
Quoting from the affidavits of Dr. Rumor, quote, on 23 January 2002, Dr. Rumor wrote that Mr. McCollum had an IQ of 61, measured in 1975, of 56 in 1978, of 71 in 1979, and 72 in 1984. His school records in Jersey City categorized him as educably mentally retarded.
Mr. Murphy, may we see that on the screen?
Oh.
It's page 4 of my report.
59, defensive exhibit 59, page 4. Have you read the statement that Mr. McCollum made to law enforcement officers in 1983?
My honest answer is I think so. I
Would
don't
you-
know if the source of that was media or this evaluation.
Would you agree with Dr. Rumor? If you'd read from that next where it says page 4?
Would I agree with the statement on page 4?
Yes, and read it.
I will read it. Dr. Rumor opined that the statement that Mr. McCollum allegedly gave to police was well above his level of literacy. And your question is whether I agree with that? I agree with that.
Dr. Helen Rogers is the next one. Would you read that?
Referring to the affidavit of Helen Rogers, PhD, quote, he was unlikely to have been able to comprehend, quote, the principles and strategies of his defense, unquote, unquote, quote, unable to follow the progress of his criminal trial, unquote, quote. She further stated that his decision-making was severely impaired and he was not capable of weighing the consequences of his choices and is susceptible to leading questions, unquote.
Did you find that to be a credible estimate or credible finding by Dr. Helen Rogers?
Sure, yes.
What about Faye Sultan? Did you have some information from Dr. Sultan?
I did.
And the next paragraph, if you read that,
You want me to read the regarding Dr. Sultan?
please.
Quote, she opined that Mr. McCollum is, quote, highly suggestible, unquote, and that he has received antidepressant and anxiolytic medications throughout his incarceration.
Would
Unquote.
you agree with her assessment there that Mr. McCollum was highly suggestible?
I don't disagree with her assessment. I would state that my assessment, I did not find him to be highly suggestible in my evaluation of him, which of course was many years later.
If you go over to page 5 and the italicized part down at the bottom, referring to an interview of Geraldine Ransom. Do you know who Geraldine Ransom was?
She's the sister.
What did you get from Geraldine Ransom's interview?
What did I get from it?
Yeah, if you just read.
Oh, okay, that's
portion.
different than what I got from it.
Yeah.
So you want me to read what I quote there from Ms. Ransom?
Please.
Quote, he had failed the written test for his driver's license 9 times. He is impulsive and has purchased 6 cell phones, 4 tablet computers, and 2 laptop computers, unquote. Quote, Ms. Ransom reported that Mr. McCollum is naive about marketing. For example, he thinks that promotional offers on television are directed at him personally. She stated, quote, he's confused and he'll die confused, unquote, unquote.
Do you know what contact Geraldine Ransom had with Mr. McCollum after he got out of prison?
I didn't interview Ms. Ransom for my report, so I don't know more details about that.
But you knew she was a sister.
Right.
And you knew this was at her comments referred to Mr. McCollum after he got out of prison, after he'd been released in 2014.
Well, they had to. He wasn't able to buy those things in prison.
So that's the reasonable assumption. He had failed a written for the driver's test 9 times. Do you know if he's got a driver's license now?
By Dr. Corbin's report, apparently he does not.
And I think when you were saying that, that was significant.
It is.
Why is it significant?
It is an evidence of lack of adaptive functioning.
And did you see in some of the reports that he continues part of his day when he's not working on his book, that he studies for the driver's exam? Did you see any reports of any records about his activities doing those things?
He told me that himself.
Yeah. And so he makes it a daily practice, at least according to his statement, or a consistent practice, to try and study for the exam, and he's unable to do so. Is that correct?
That is correct.
Mr. Murphy, I think we'll take our morning break right now. Why don't we,
That report was made by Dr. and am I pronouncing it right? I don't know. Is it Dr. Jenoson?
Without being, your guess is as good as mine. I don't know the man, I don't know the name, and I don't know the circumstances in which it was requested.
But the report was done February 13 of 2017, so it was pretty recent at the time you did your evaluation, correct?
Yes.
And would you just read through the findings from that report that you've noted in your report?
Page 14, Mr. McCollum produced the Paranoid Valley or Psychotic V profile. These individuals experience psychotic disorganization and mental confusion. Individuals with this configuration are likely to have recurrent episodes of psychosis. Mr. McCollum's low score on the ego strength, ES10, also renders him unstable and subject to confusion in the face of stress. His day-to-day coping and immediate practical self-sufficiency tests as disorganized, ES10 at the lowest 1% of the population. Low scorers on ES, such as Mr. McCollum, are more rigid in their choices of action and approaches to problems. Page 15. He endorsed several instances of probable hallucinations and delusions, items 65 and 92. Examination of his specific ATR items suggests that he is likely to be psychotic. Mr. McCollum evidences severe signs of depression and psychotic mentation, MMPI-2. He is a highly dependent individual, MMPI-2. His day-to-day coping is disorganized and he is subject to confusion in the face of stress, MMPI-2.
Why did you include this in your report?
It was a significant signal that he may be psychotic, worthy of further investigation.
And what does psychotic mean?
Well, psychosis is our term for just being divorced from reality, not knowing what's real and what's not.
So this is a recent report of testing that suggests that Mr. McCollum is psychotic, correct?
That's correct.
The MMPI, what is that?
It's probably the most widely used psychological test.
It's a Minnesota multiphasic inventory, whatever.
Minnesota multiphasic personality inventory, yes.
And what's that used to measure?
I would say personality and psychological functioning.
Okay. And so did you investigate further to see if these MMPIs that Dr. Jenoson had done were recent?
I knew the date of them.
Okay, so the date was that they were recent?
The date was recent.
So there was testing that had gone on within just the several months of your evaluation.
And the issue I had was that no intellectual or neurocognitive testing had been done recent to my report.
You know who requested Dr. Janosin to do this?
I don't know.
Do you know who you got this information from?
All of this information was received from Mr. Megaro.
And was Dr. Janosin, is he a psychiatrist or a psychologist?
I would wager, and I know I need to be careful about doing that, that he's a psychologist.
In any event, this was significant findings that you thought should go into your report.
Or I would not have included it. That's correct.
There's an affidavit you referenced of Dr. Helen Johnson Rogers at the bottom of page 8. Is that up on the screen? Okay. Would you read what you've included in your report from the affidavit of Dr. Rogers?
I administered the Wechsler Adult Intelligence Scale Revised, WAIS-R, to Mr. McCollum. He scored a verbal IQ of 68, a performance IQ of 72, and a full scale IQ of 68. At times during the testing, Mr. McCollum exhibited difficulty following basic instructions, which was consistent with severe deficits in communication skills and with his significant sub-average intellectual functioning. My evaluation in 1995 revealed that Mr. McCollum had substantial deficits in 2 or more areas of adaptive functioning, including functional academics and communication skills.
So are communication skills part of the adaptive functioning, a piece of adaptive functioning that would go into a diagnosis of someone's competency?
Okay, so we don't diagnose competency. Okay, when you say diagnose, that means we're trying to render a diagnosis. Okay, not an opinion, it's a diagnosis.
Right.
Okay, now regarding competency, we have an opinion.
Right.
So there's a difference. You want to restate your question?
In rendering your opinion on whether someone meets the criteria for IDD, would severe deficits in communication skills and be part of the adaptive functioning that you've talked about earlier that would be considered?
It would be considered. That's why I included in the report. I cast some doubt about it because of how early it was.
Well, you found, Dr. Rogers back in 2002 found adaptive functioning disabilities, correct?
Correct.
You found adaptive functioning disabilities in 2017, correct?
Well, initially I didn't see them. Consulting, the retesting by Dr. Harmon did show some, and I agreed that he did have some, but they were mild.
And Dr. Corbin also found that he had adaptive functioning deficits.
He did.
So we've got a period now from 2002 to, 2021, where we've got medical opinion that Mr. McCollum suffers from adaptive deficits or adaptive functioning deficits.
That's true.
Now, over on page 9 of your report, I want to know something about this. What's this motion to terminate a guardian ad litem?
That is how it was titled to me.
And do you know who filed that?
I don't have the original document with me
What
or
is-
access to it.
Would it surprise you that it was Mr. Megaro?
No,
In fact, you know it was Mr. Megaro.
I assumed it was.
And Mr. Megaro, notwithstanding what he said to the Superior Court or clerk in Cumberland County, and notwithstanding what he said to the Industrial Commission, you've quoted him as saying that clearly and unequivocally, Mr. McCollum, and just read through this if you would.
You want me to read the first paragraph or all of it?
Let's just read through 13.
Read on,
Yeah,
including 13.
Yes.
Okay. Mr. McCollum clearly and unequivocally stated that he wanted undersigned counsel to represent him in this action and no other attorney other than his current attorneys. Mr. McCollum clearly and unequivocally stated that he understood that he could fire his attorney at any time for any reason and hire new counsel without limitation. Mr. McCollum clearly and unequivocally stated that he specifically wanted an attorney to represent him in this action who was from out of state. Mr. McCollum clearly and unequivocally stated that he did not want the assistance of a guardian to help him at all and trusted his current attorneys. Mr. McCollum clearly and unequivocally stated that his best interest was to conclude the litigation without unnecessary delay, and he wants to put the extremely unpleasant experience of his 31-year wrongful incarceration behind him rather than relive it.
Do you think that Mr. Megaro has had any financial interest in filing this motion?
Yes, I assume he did.
Because if the guardian does not confirm the financial agreement he has or the legal services agreement he's got with Mr. McCollum, he may no longer be in the case, correct?
That's my understanding, sure.
Uh, 14 over on the next page, page 10, where you make a quote from 14. If you just read that one paragraph, first one.
Mr. McCollum clearly and unequivocally stated that he understood when he signed the retainer agreement that he was hiring counsel and fully understood the terms of the loans that he borrowed and intended to enter into those contracts for reasons he set forth on the record.
Thank you. Now, Mr. What was the date that you actually interviewed Mr. McCollum?
Give me a sec. Let's see. Mr. McCollum was interviewed in my Raleigh, North Carolina office for 2 hours and 20 minutes on September 19th, and a follow-up interview took place via the telephone on September 22nd, both of 2017.
Do you know if anybody talked with Mr. McCollum about your upcoming evaluation of him?
I don't know.
Do you know if Mr. Megaro had any discussions with Mr. McCollum about the legal services agreement, the loans he had been involved with, bank accounts he may have, feelings he had about Mr. Tarleton? Do you know if Mr. Megaro had any discussions with Mr. McCollum about that?
I don't know.
Do you think it would be improper for a lawyer to go over matters of that nature shortly before he knew his client was going to be evaluated by a mental health professional?
Improper. I think it's probably in the area of things that I would prefer not happen, but something that I would acknowledge probably does with some frequency.
Unfortunately, that's not a question. Do you know if a mental health professional recommended to the lawyer? Well, let me strike that. Would you ever recommend to a lawyer who was getting ready to have a client evaluated by a second mental health professional to go over with the client things about bank accounts, things about legal services agreements, things about loans, knowing that those were going to be topics that the evaluator was going to be asking about?
Let me just make sure I understand your question. You're asking if I would recommend that.
To ever do that?
Do I ever recommend that to a lawyer to have a session with the client before their evaluation by me? No, I do not.
How about when you know they're going to be the client's going to be evaluated by someone else, a third party, in their third party mental health evaluator?
Well, that's a little different. I have in criminal cases where competency has been an issue, have recommended that the defendant have a session with their lawyer about competency issues before they're evaluated by someone else. I have recommended that. It's a little different.
What about in the civil realm of what you were doing?
I've never done it in the civil realm.
Let me direct you to page 29 of your report, down at the second half. And this is, I believe, dialogue between Dr. Corvin and Mr. McCollum.
Yes.
And would you start down where it says page 135 and read the colloquy that you have in your report there, through page 29?
Yes. Dr. Corvin, Dr. Corvin, quote, "Let me ask you this. What if the choice was this? You get no money today, but in a year you get 2 million. Mr. McCollum, Dr. Corvin, or the choice is you get 1 million today and not any of the 2 million in a year. Mr. McCollum, I'll take that $1 million right away. Dr. Corvin, and tell me why that is. Mr. McCollum, because I could live off that. I could get a small business. Dr. Corvin, that's enough? Mr. McCollum, that's enough for me until my other suits are pending. Dr. Corvin, oh. Mr. McCollum, I put myself on a budget. In other words, I put myself on a budget and pinch off it.
Okay, that's why did you include that part about 1 million today versus 2 million down the road?
I thought it reflected Mr. McCollum's thinking about it.
And his response is that he would take the 1 million today.
That's my understanding, yes.
Would you look over on page 130, 32? Down where, below where it says page 6 and starts quoting, but the next paragraph, would you read the first? Well, let me first set this up. This is still Dr. Corvin.
This is Dr. Corvin's report.
Okay. And where it starts, Mr. McCollum, would you just read that first statement there?
And how far do you want me to go?
Just the first sentence.
Mr. McCollum stated with notable pride that he balances his own checkbook and that his account, quote, got my name on it, unquote.
And do you know when Dr. Corvin's evaluation took place, the first one?
I don't have it in front of me, but it would have been shortly before mine. It was September 9th.
Okay.
The report is dated September 9th. I don't know what date he actually saw it.
So Dr. Corvin evaluated him on September 9, and your first interview with Mr. McCollum was 10 days later.
That's right.
Over on page 39, You start off with a biographical sketch
Yes.
and continuing on. Is this information that you got from Mr. McCollum or is it from various sources?
All of the above.
Okay. Would you look over on page 45, the bottom paragraph? And would you read that? And it goes over to the next page. Read that information now. Is this information you got from Mr. McCollum?
Well, especially when it's in quotes, it
Yeah,
is.
That's what I'm trying to be clear for the record.
But not all of it is directly from Mr. McCollum. If it's in quotes, it is. So you want me to read the paragraph that begins Mr. McCollum and his brother and that goes over to the next page?
Please.
Okay. Mr. McCollum and his brother both received $750,000 settlement from the state of North Carolina. From other sources, I was aware that Mr. McCollum spent this money in a period of less than a year. I asked him to explain how he had spent this money. He responded, quote, "Well, first off, I didn't get $750,000. It was 300 and something. And I took care of my family. I bought my sister a car for 12,000. I bought me a BMW for 10,000. It's a nice car. I bought my brother-in-law a car. I bought my nephew a car. I bought myself a sport bike. Some of my money went for a van to escort me around to all my court dates. I had to pay some rent well in advance. I went to Disneyland with my fiance, and Leon and I paid for everything. And it was at pretty expensive hotels. I bought furniture for my house. I have 6 TVs. I got 2 in the living room, 1 in the back room, 1 in the bedroom, 1 in the den that used to be a garage. I bought an iPhone. Since I got out, I've had 5 different phones. I like to carry 2 phones. I keep 1 for business and 1 for family and friends. I do that for privacy. I bought more electronics like a laptop and a touchscreen and a desktop and an iPad, and I have 2 watches. The living room suite cost about $1,600, and yes, I've only got $100 left. But things were expensive. I had to stay in hotels for all the law proceedings. I had to pay my nephews to stay with me. I gave money to family members. I gave some money to people I left behind on death row. I sent each of them about $100. I have to pay the light bill. I know that that's a lot of money, and I have had to put myself on a budget, unquote.
Now, did you believe when you reviewed this information from Mr. McCollum that these were reasonable ways to spend his money?
I thought he gave a reasonable response to my question. Your question is not an easy one to answer. It is not how I would have spent the money, but he gave me what I thought were a rational explanation of how the money got spent the way it did.
And what was that rational explanation?
The one I just read to you.
Why did he spend the money like that?
He felt that he owed people a lot for the support that they had given him.
Did you talk about what support his sister had given him to warrant giving her a car for $12,000?
I didn't ask in specifics, no.
What about his brother-in-law, the car he bought for him, what the brother-in-law had done to warrant being gifted with a car?
I did not break it down that way, no.
Did you talk with those individuals to verify that they had been supportive of him during his time on death row and that they requested a car in response to that?
I did not.
He bought his nephew a car. Did you talk to the nephew about the circumstances under which the nephew got a car and what kind of car the nephew got?
I did not.
Do you know if any of these, let's strike that. He went to Disneyland. Do you know why he went to Disneyland?
I don't.
Do you know when he went to Disneyland?
I don't.
Do you know that he got who he talked to when he was in Disneyland?
I didn't ask. No,
Do you know whether he had any meetings with Mr. Megaro when he was down at Disneyland?
I don't know.
You don't know anything about that trip other than what he told you.
That's right.
What about 6 TVs?
A lot of TVs.
He's got 2 in his living room, 1 on the back porch. How many in the bedroom? 1 in the bedroom. 1 in the den that they used to be a garage, and a lot of TVs. I would agree with you. What about iPhones? Had 5 different iPhones. Well, he didn't say he said 5 different phones. In the course of we know he got out in 2014, and this is 2017 when you're talking to him. So in the course of 3 years, he's bought 6 TVs and 5 phones, according to what he told you. Correct?
That's correct.
He needs to carry 1 for business and 1 for family and friends. You tell what kind of business he needed 1 cell phone for?
I didn't ask. I made the assumption that the business was this business that we're talking about, the settlements and the various legal entanglements that he was involved in.
And do you know how many people on death row he gave $100 to?
I didn't ask to be more specific.
I sent each of them about $100. So was that each person that was on death row? Because there was over 100 people on death row at one time, and I think during this period of time.
I didn't ask.
Okay. Did you ask him about the loans?
Some.
What did you know about the loans?
I had some of the documentation on the loans. I don't know if that's reflected in what was there, but I had some documentation about the loans.
And do you recall that he took out a $100,000 loan with multi-funding at some point?
I remember there were 3 loans.
Okay. Let's talk about, we'll break them down. Let's go back to the first one. Do you know what the first one was for?
What the first one was for? You mean
no, the amount of the first one?
I don't remember offhand.
All right. If the record shows that it was $100,000 that he was engaged or got from multi-funding, would that be consistent with what you recall? Or
Sure. Yes.
and do you remember what the interest rate on that loan was?
Interest rates on all of them were high.
18, 19%?
A lot of money.
Did he tell you who helped him get those loans?
He indicated Mr. Megaro did.
He indicated Mr. Megaro helped him get those loans. Have you seen any email that went back and forth between Mr. Megaro and multi-funding
No.
regarding those loans?
No, I have not.
Do you, okay. Do you know when he got the first loan for $100,000? Was that before he got any compensation or after, or do you know?
I don't know.
If the record shows that Mr. Megaro got 300, what's that, 360? Yeah, if Mr. McCollum got approximately $360,000 out of his industrial commission award, and 8 months later was having to borrow another $50,000 from multi-funding at 18% compounded every 6 months. Would that be something you'd think you would be relevant to investigate to determine whether Mr. Megaro, Mr. McCollum is capable of managing his own finances?
As I said, I talked to him about the loans.
And what did he tell you?
I don't have to look. That's on page 46. Do you want me to read that?
Sure.
Okay. I then asked Mr. McCollum about the series of loans that he had obtained. He reported the following, quote, I spent most of the $300,000 and I was only getting $735 a month from Social Security. Rent is $500 a month, so I called my lawyer and I took out a loan for $50,000, unquote. I asked him about the terms of the loan and he stated, quote, I did not fully understand it was going to be that much interest. I figured it was going to be me paying back $65,000 total, but that's a lot of interest, but I really needed the money to be able to live out there. I have my life to live, so I had to do something. Maybe I shouldn't have thought about other people and should have thought about myself more, unquote. He continued, quote, I didn't expect 18%. I expected 2 to 3%. I found out it was that high in May of this year. They should have cut that down. I didn't ask what the rate would be. I was just happy to get the loan, but I have to take care of my family. I had loaned the money out and no one would pay me back. I got short. Now I've learned budget, but I couldn't go to nobody else. I had no one else to turn to. No one else would help me. Unquote.
That's good. So he didn't fully understand what the interest rates were, correct? According to what he told you.
That's correct.
He didn't expect 18%, correct?
That's what he told
He
me.
expected 2 to 3%.
That's what he told me.
He didn't ask what the rate would be.
That's what he told me.
Do you find that problematic in making an evaluation of whether a person is competent to manage their own affairs, that they don't even know the interest rate of the loans they're taking out?
It's problematic. It isn't particularly compelling to me, given my knowledge of other people who are felt to be competent, who I know well. Some are my patients, some are friends, some are family members who couldn't tell you the rate on a loan that they have. I don't think this is unusual. It's not good, but it's not unusual. And by itself, it certainly doesn't mean one is incompetent.
Let me just see if I understand this, that it's not, you don't find it to be particularly relevant in this case that the man didn't know what the interest rate was on the loan he was taking out and he'd been in prison for 31 years. Is that what you're telling us?
That is not what I said.
Well, say it again. Maybe I misunderstood.
I think you did. I said that by itself, it doesn't make him incompetent. And I think this level of misunderstanding or misinformation or not being informed about a loan is not uncommon. And as I said, by itself does not mean that you're incompetent. I didn't say it was irrelevant. That was your term.
Now that we know about the $100,000 loan, correct?
Correct.
Then we know the one we were just talking about, or he had another loan of $50,000, which he took out after he blew through the Industrial Commission Award, correct?
Right.
You know about that?
I do.
Was there another loan?
I understand there were 3.
And what was the circumstances of the third loan?
I don't know.
Do you know if it was $15,000?
I don't know.
Do you know if there was any communications between multi-funding and Mr. Megaro about the fact that he was wanting additional loans?
I do not know.
Did Mr. Megaro tell you that?
He did not.
At what point would getting so many of these loans be relevant to you in your evaluation here?
Look, you're saying whether it's relevant. I obviously thought these loans were relevant, or the conversation that I had with him wouldn't have taken place, nor would I have included in the report. I do think it's relevant. I don't think it is compelling information to say that he's incompetent.
Okay. Look over on page 51, please. Now, who are you speaking with here? Do you know? Is this Miss Hicks?
Hang on. So this would be the interview with Miss Hicks, yes.
And that's his sister, correct?
That is correct.
And you thought she was a very good source, a collateral source who had current relevant information?
Yes.
Would you look over on page 51, if you're not already there? Okay.
Mhm.
The second full paragraph at the top where it's as regards, could you read that for the record?
As regards to spending of in excess of $300,000, she noted, quote, those were handled by him and he was aware of what was going on. Did we have concerns? Yes. I encouraged him not to spend it all and to save some. He knows there are things he could have done better. He needs to be thrifty, unquote.
She had concerns. His sister had concerns about the way he was blowing through that money.
She did.
Legitimate concerns?
I assume them to be, sure.
That sounds legitimate to me.
Objection there, Mr. Murphy. No editorial comments, please. Just ask questions.
The next, the fourth paragraph. Would you read that to the record?
The one that begins,
She stated.
I'm sorry. She stated that Mr. McCollum is able to express himself verbally and to take care of his personal cleanliness. She stated that he is able to take responsibility for himself, stating, quote, "He's a grown man, but he might go to the wrong people for advice at times," unquote.
And continue on with the next one, please.
She noted that her brother could be, quote, "easily persuaded. Sometimes he knows how to approach a person and sometimes he does not. Sometimes, there may be a typo here. Well, I'm going to read what the report says. Sometimes not, sometimes he knows what is for him and what is against him, and sometimes he does not." Unquote.
Thank you. Now, at the end of your report, let's go over to page 54. What was your diagnosis as a result of your
So
evaluation?
initially, with my initial report, let me get there. Yeah, I diagnosed him as having subnormal intelligence and rule out intellectual disability. Rule out means it's a possibility. As I go to explain later, further information would be needed, and post-traumatic stress disorder.
So you did find he had subnormal intelligence, but not IDD.
I wasn't willing to make the diagnosis of intellectual disability then.
And rule out intellectual disabilities. That's what you were just talking about, correct?
But it means it's a possibility. So by lay people, it's frequently misunderstood as that it's being ruled out. It really means it's a rule out that you're considering.
Let me go over to page 59, excuse me, 57. And so what was the, looking at the forensic opinion, what was the purpose of the evaluation?
I wrote there, the purpose of this evaluation is to provide an opinion as to whether Mr. McCollum requires a guardian.
And it was your primary opinion based on the information presented to me thus far that he does not. Is that like a snapshot in time at that moment? He does not need a guardian? Is that what you're saying?
Yes.
But he already had a guardian.
Turns out he did.
Then continue on. However, I believe.
However, I believe that opinion is not yet fully informed, and that we need more data regarding his current intellectual functioning and more data regarding his current adaptive functioning before a definitive opinion can be given. I continued, certainly with the stakes this high in this case, those evaluations should be completed prior to the court rendering its opinion regarding whether Mr. McCollum requires a guardian. Do you want me to continue?
No, that's fine, just there. Why didn't you get the more information that you said you needed?
Say it again.
Why didn't you get the information you needed before you did this report?
Oh, time. I really thought that what was going to happen was I thought my opinion was needed, and I gave the best opinion I could. Mr. Megaro wanted the opinion by a certain time. And so I said, there's other information that's needed.
And he was pressing you for an opinion because he had a hearing coming up, correct?
Well, pressing's a little strong. He said, I need the opinion by this date. That's not unusual in these cases.
And you told him you needed additional testing?
I told him I have an opinion, and I told him what it says in the report.
And no additional testing was provided to you at the time you issued this report, correct?
The initial report.
Right.
That's correct.
So what, you sent that report on to Mr. Megaro, what happened then?
At some point later, he said, I believe, he said, would Dr. Harbin be a person that could do that additional testing? And I said, sure, that's fine.
Right, and you got information from Dr. Harbin,
That's correct.
and as a result of Dr. Harbin's testing, your ultimate opinion did not change that that Mr. McCollum does not need a guardian, but after you reviewed the additional testing, which included a Vineland, you have the opinion that he does have mild intellect. Mr. McCollum does have intellectual difficulties that are mild, quite mild is where you refer to it, correct? It's the second report.
This is 171 now you've moved on to? All right.
Just a moment.
We have a thumb drive that has it on.
Mr. Williamson, I apologize. Did you give us 171 earlier today?
Not in paper form. We relied upon.
All right, that's what I recall.
This is 171. What was your psychiatric diagnosis of Mr. McCollum after you got the additional information? And I'll refer you to page 4 of your report.
Right. So after reviewing Dr. Harbin's further neuropsychological testing, I agreed that he had intellectual disability mild.
And post-traumatic stress?
And post-traumatic stress disorder, yes.
Let me refer you to Plaintiff's Exhibit 162. Over on your screen. We'll scroll through these so you can look at them.
I can't scroll, can I?
Yeah, just go through them one by one because it's a 10-page document. And they'll start on page 9. You recognize what plaintiff's exhibit number 162 is, Dr. Millard?
It looks like emails between me and Mr. Megaro.
And it's on Thursday, August 31, 2017. Mr. Megaro wrote to you. What did he write? You
He
could read it.
wrote, the transcript of the interview is attached. It may help you to read along.
Oh, do you know what he's talking about there?
I'm assuming he's talking about the transcript of the interview Dr. Corvin had with Mr. McCollum.
And did you respond to that?
Yes.
And what did you respond?
I said, okay, I'm through Dr. C's interview as well. I'm on the road tomorrow and free to discuss during the following timeframes, and gave him some times I was available.
All right. Let me refer you to page 6 of the exhibit, where you sent a email to Mr. Megaro. Well, starting down at the bottom on September 15th, 2017, 11:47 a.m., Mr. Megaro wrote to you. What did he write to you?
Do you have any availability to see Henry soon?
That's September 15th, and you wind up actually seeing him on the 19th.
That's correct.
And you responded to that above there at 11:53. What did you tell Mr. Megaro?
I can see him next week, but I would not be able to complete a report regarding him until October 6th.
Why was the date of the report important? Or was it? I don't know.
I don't know. I don't remember the context about why I said October 6th. I was probably just looking at my schedule and knowing when I'd have time to get it together.
But you actually issued it September 24.
Yep.
So you're able to get it out a lot earlier.
Yes.
Would you look over on page 2? And would you read the content of that email starting down at the bottom? Your email to Mr. Megaro on September 16 of 2017.
Mr. Megaro, in order to make my evaluation/report more compelling than Dr. Corvin's, we need, in my opinion, to do several things that he, Dr. Corvin, neglected to do. 1, a Vineland or similar scale of functioning. 2, interviews and probably a Vineland by his fiancée and sister. 3, a more complete neuropsych eval.
Continue on, would you please?
Okay. This is his response. As regards, oh, wait a minute.
This is still your response, correct?
Okay. As regards each, I am trying to obtain a Vineland so I can administer it Tuesday. I don't possess one, as this scale is usually done by psychologists, but I'm reaching out to psychologists I know to see if I can borrow the actual form. In that regard, can you give me Dr. Harvin's email? Number 2, providing an opinion of functional capability without consulting family is one of the biggest errors in Corvin's approach. Can I interview sister and fiance? 3, Corvin took McCollum's subpar performance on 2 subtests of the Montreal and used those to substantiate his disability, period. To refute that, I think we need a more complete neuropsych battery. Individuals capable of providing this would include Claudia Coleman, PhD, with whom you are familiar, and Chris Herfkin's PhD. Could Dr. Harbin do this and expand his narrow opinion? Lastly, how much time do we have? Is there any sense that the court would allow? Is there any sense that the court would allow to testify on this question?
And it's signed by you, thanks, Jim Ballard, MD, correct?
Correct.
So you were hired to do what?
It's hard to provide an evaluation of Mr. McCollum's competency.
And when did you interview Mr. McCollum?
September 19th and 22nd.
And could you complete your evaluation of Mr. McCollum without interviewing him?
No.
So at the time of this email, you hadn't completed your evaluation.
Oh, no, that's
And you
true.
hadn't even come close to forming an opinion on the issue of whether he needed a guardian.
I completed the record review.
Yeah. Had you formulated your opinion, which, as I see from your, well, go ahead, had you formulated your opinion?
No.
So why are you telling Mr. Megaro 3 days before you even interview Mr. McCollum that in order to make my evaluation report more compelling than Dr. Corbin's, we need, in my opinion, to do several things that Dr. Corbin neglected to do? Is it from that statement, is a reasonable interpretation that you weren't rendering a non-biased opinion, you were looking to render an opinion contrary or call into question Dr. Corbin's report?
Absolutely. I was looking for information to call into question Dr. Corbin's report. It's true.
Why would you do that?
I didn't trust it.
You didn't trust Dr. Corbin?
I didn't trust Dr. Corbin's report.
So even you started out, before you had even completed your evaluation, you started out with the mindset that I'm going to do something to contradict Dr. Corbin's report.
Oh, I didn't have that opinion before I saw Dr. Corbin's report, but I did have it after I saw his report.
And you'd already seen it because you're talking about here
At
that
that,
to be more compelling.
at that point, yes.
So you also told Mr. Megaro that you needed a violent or similar scale functioning, correct?
Correct.
And before you issued your report, that was not done.
It was not.
And you've admitted, understand that your report, you couldn't reach a conclusion. Well,
No.
strong. Your report speaks for itself. I'll leave that. Okay. But you later did get a violent done.
I did.
Why couldn't you get the violent done before you issued the first report?
Well, I did look into doing it myself. And as I indicated, that's usually done by a psychologist. I did some research about whether that could adequately be done by me, and I got to the conclusion I couldn't. Lack of experience in the area on my part.
A more complete neurological evaluation is
Neuropsychological
difference. What did you mean by that?
Well, my ambition, what I really wanted was a full neuropsychological battery. And what we did get was a more complete set of IQ testing by Dr. Harbin. I suggested 2 neuropsychologists that I use in consultation. And we ended up going with Dr. Harbin.
You said you didn't trust Dr. Harbin's report, correct?
No, I did not. I said I did not trust Dr. Corbin's report.
Corbin's report, excuse me,
Okay.
yes. Do you know that Dr. Harbin, prior to engaging you, had recommended that Mr. Megaro consider Dr. Corbin?
I think you got your names mixed up again. You want to try that again?
Do you know that before Mr. Megaro made a decision and contacted you, that Dr. Harbin had recommended Dr. Corbin or you to conduct the evaluation?
No, but it doesn't surprise me.
Isn't the truth of this matter that you were asked to produce an opinion that would challenge Dr. Corbin's opinion?
I think it wasn't stated that way to me, but it was certainly understood.
So you went into this thinking you're going to, regardless of the facts, I am going to produce a report that contradicts Dr. Corbin's report.
No, that's not true. So
Go ahead.
it's done.
No, go ahead.
Okay. It was clear to me that Dr. Corbin's report existed, knew what its findings were, and I knew what Mr. Megaro would like to see in a report. Had I not been able to produce a report of that opinion, I would have told Mr. Megaro that. It wasn't the case.
How can you know a report you can produce until you do the evaluation?
Oh, you don't?
If you look at 167, which is on the screen. Recognize with it is.
I don't remember it, but okay.
Does it appear to be an email from Patrick Megaro on October 23rd of 2017 to Tom Office? I believe that would have been Tom Harbin and James Ballard. That would be you. Subject McCollum Henry. You recognize that?
Yes.
And what did the email say?
The only part I can read so far is need your reports ASAP. I need to challenge this.
So you'd already given Mr. McCollum, excuse me, Mr. Megaro, your report of September 24 of 2017, correct?
That's true.
And then on October 23, he's asking you for your reports to challenge. Do you know what he's wanting those reports to challenge?
Well, I'd have to have you scroll down for this. I can make some assumptions, but I'm told I shouldn't do
Okay,
that.
let's go.
Stan.
You know what the attachment is?
You're asking me
Yeah,
if I know what the attachment is? I don't recall what the
Okay.
attachment is, no.
yeah, we don't have that right now, though. You see what's listed?
I do.
What is it?
It reads docket entry 233, order finding Henry incompetent.pdf.
So do you know that Judge Boyle had entered an order finding Henry incompetent on October 23rd, and that's the email from Mr. Megaro telling you he needs your report so he can challenge that.
That's what it looks like to me, yes.
Let me refer you back to 162. Exhibit 162. And the first page of the email. And I'll ask you to start sort of upper mid part of it where it says on Saturday, September 16th, 2017. Could you read there, starting there, the email you got from Mr. Megaro?
Do you plan on having Dr. Harbin do more testing? I will call him, but to your knowledge, has Dr. Harbin already done a Vineland on Mr. McCollum? Do you have Dr. Harbin's email? Thanks, Jim Ballard.
And what was the email below that that precipitated your response?
Call Dr. Tom Harbin. He is on our team and he is a neuropsychologist. He has a Vineland that he sent me before, but for some reason I cannot find it myself.
So did you consider yourself on the team with Dr. Harbin?
No, I did not.
Okay, well, it says so, but I'm just trying to determine whether you viewed it that way, and you did not.
I did not.
Let me refer you to Exhibit 163. And let me refer you over to the third page of the exhibit. Down at the bottom. You see where it says from James Ballard, and it's dated September 20 at 4:24.
Yes,
Would you, and it's to Mr. Megaro, correct?
it says, in our collective haste, we did not address whether I should seek to have contact with Mr. Tarleton,
Who is Mr. Tarleton?
the guardian.
And what was the response? If you'll look over at the next page 2.
Henry does not want you to do this. Sorry, forgot to tell you, he does not trust him.
So is that the reason you did not contact Mr. Tarleton?
I accepted that at the time.
You consider, what would you why do you think there needed to be some discussion about whether you should contact Mr. Tarleton?
He might be a source of information.
He's the guardian, right?
Yes,
And Mr. Megaro ultimately told you that Henry didn't want you to do so, and you did not.
that's all correct.
Oh, yeah, sorry. Did you, excuse me, did you know, a Robert Crustrini,
No,
Custrini?
and the name does not ring a bell.
State Park Exhibit 659. We look at this email.
I'm looking at it now.
You would, it's dated November 15, 2017, and this is about, what, a month after you issued your report, correct? Your addendum?
Yes,
And do you know whether Mr. Megaro had sought another mental health professional to do a evaluation of Mr. McCollum?
not known to me.
Okay, if you would read this email into the record.
Good morning, Mr. Megaro. Per your request, I have completed my review of the transcript of HM's psychiatric evaluation with Dr. Corbin, as well as the report that resulted from the same. Without exception, I am in agreement with the conclusions drawn by Dr. Corbin. He conducted a very thorough assessment, and his findings are clearly supported by the data. They are also consistent with the data obtained in my own evaluation of Mr. M and the associated case records. Please feel free to contact me if you have any questions or if you expect that you will need me to testify on 11/28. However, given my own data set and the findings and recommendations resulting from the same, it is difficult to envision that my testimony would support your position. Signed, Robert Custrini, PhD.
You don't know Dr. Crustrini?
Never heard of him.
You were looking for testing, weren't you? Data?
I was.
You were begging for a Vineland.
I didn't think I begged.
You were looking for other psychologists who could provide one. Claudia Coleman, correct?
Well, that's all true. By the time this took place, whatever interaction that was, I had received that information from Dr. Harvey.
But you were never told that he'd asked someone else to look at and evaluate Dr. Corbin's interview, or Dr. Corbin's report, and had found without exception, he was in agreement with it. And he had done some, a data set and fully endorsed it. You were never told that?
I was never told that.
All right, that's all I have. Thank you. Well, yeah, I'm through. Thank you. They may have.
Will there be further direct, Mr. Williamson?
I will try to be brief. Yes, but Dr. Ballard, there's been reference here about Mr. Tarleton being the guardian of Mr. McCollum. Do you recall hearing that today?
Sure.
Did you have any understanding that he had been appointed as a general guardian?
Oh, I did. I knew of his existence, and I talked to Mr. McCollum about Mr. Tarleton some.
Now, in fact, he was and is a guardian ad litem for Mr. McCollum in the civil lawsuit. Is there a difference between a guardian ad litem, that Latin phrase, and a general guardian?
Well, there's a difference between a guardian ad litem and a guardian of a person. Yeah.
Do you know what guardian ad litem means in Latin? Common.
I don't.
Like modus operandi, we know what that means. Okay.
But no, I don't know what guardian ad litem means in Latin.
But in any event, was not a general guardian. Do you have any information that he'd been appointed general guardian? And do you have any indication?
I don't know anything more than that he was guardian ad litem.
All right. And there is in your report that exhibit 59, I believe it's on page 48. I don't think I'll just read it to you. I don't need that we have it on the it is on the screen.
Yep.
That paragraph that's highlighted in green, could you read that?
Sure. I asked him.
Excuse me, in blue and green.
Blue and green. I asked Mr. McCollum specifically about his interactions with Mr. Tarleton. He gave the following response, quote, "I don't like him. He says I've got an IQ of 56 and I know I don't. He only spoke to me for a total of 45 minutes. I don't trust him and I don't trust that other doctor." I asked him to tell me more about his interactions with Mr. Tarleton. He gave the following response, quote, "We only met once for 45 minutes. He called me and said my lawyers were not working for me. He said he could get me more money. He's pitching me like I don't know nothing. I'm 53 years old and I've learned a lot. He's got a lot of game with him. He has tricks up his sleeve. I think he is out to rob me. I am not going to bow down to a guardian. I'm not some little kid." Unquote.
Would you think that it would be valuable to interview someone for your investigation into Mr. McCollum's adaptive abilities who had met with him for only 45 minutes?
Well, I would not dismiss it as entirely not valuable. It could have had some value.
Now, does the fact that we've discussed here, Mr. Tarleton is a limited purpose guardian, or Mr. McCollum, affect your opinion in any way?
Does it affect my opinion about Mr. McCollum's competency? No, no.
And during the cross-examination, you were pointed to a number of matters that are in fact detailed in your report. You recall that testimony?
Sure.
And all of that is in your report, correct?
Yes.
And as you stated, you regarded that information as relevant.
Or I would not have included it in my report. Yes.
Yes, as you have said. And your opinion is still as stated, both in your initial report and in your subsequent report.
My opinion has not changed.
Nothing.
Any redirect? I mean, recross? Mr. Morris? Questions? Mr. Bennett? Dr. Ballard, I do have just a couple of questions for you. First of
Yes, sir.
all, as a forensic psychiatrist, is there a difference between competency in the criminal setting as to whether or not one may be tried for a crime for which they are not competent, and that of a civil and competent person who would not be able to enter into contract?
Absolutely, yes.
And is it fair to say that the criminal is a higher burden, in other words, the level of incompetency is more significant or not?
It's just different. I can't say it's a higher or lower bar. It's just different.
All right, sir. I also noticed in your report that there was as much as a 16-point difference in the IQ test that Mr. McCollum provided. It looks like in 1975, he tested as 61, and 78, he tested as a 56, and by 1984, he tested as a 72. Is there some professional data, scientific data that would suggest that additional IQ testing affects the score? In other words, the more tests you have, are you likely to do better or worse, or is that not affected by the number of tests that you've taken?
I really should defer to Dr. Harbin about something that specific about psychological testing.
All right, sir. And lastly, did you do any sort of, in your analysis, did you take into consideration in any way the impact, psychological impact for 30 years in the death row on Mr. McCollum?
Yes, sir.
And tell me about that. How did that impact your analysis?
Well, I thought that he had experienced a great deal, that it made him more vulnerable with all the time that he had spent in jail. I didn't think it affected his competency. I think if anything, it affected how much he felt he owed other people that had helped him.
All right, sir. Mr. Williamson, in light of my questions, do you have any additional questions, sir?
No, sir.
Does the State Bar have additional questions?
No.
Thank you. Dr. Ballard, if you would wipe down your area, you may be excused.
Oh, yeah, wipe down.
And any reason not to release him from a subpoena?
I don't think so. Very, very quickly in regards to this witness, I don't think this impacts his release, but there was reference made in the testimony to an email from defendant or defendant's counsel to this witness that has not been provided to the State Bar. We asked numerous times if there were any documents that the defendant needed to produce pursuant to his ongoing obligation to update discovery, and no documents were produced. The State Bar produced our text messages and emails with our witnesses to the defendant. So I think he was well aware of his obligation. Can I just ask that we get a copy of that email? I don't know if he has it or the defendant.
Can you be more specific? Is there a time frame, or is there
That's why I didn't want him to leave. I understood there was an email to him, including Dr. Corbin's updated report just a few weeks ago.
Yeah, it's in a transmittal. Here it is. I'll show him.
I got it right here.
Let me suggest this. Why don't you just at the break, why don't you show it to him and see if there's additional reason for it to be otherwise produced?
And any other communications with the witnesses, I think, should be provided as well, if there are other ones similar to this that weren't. Thank you.
Mr. Williamson, would you, at some point before the conclusion of all the testimony, would you be able to provide us with a hard copy of 171? Your
Yes,
exhibit?
we would.
Gentlemen, this strikes me as a good time to take our lunch break. It's now almost 12:30. Why don't we reconvene at 1:45? That gives everyone an hour and 15 minutes for lunch. Let me just mention this before we break. It's been brought to my attention by Ms. Miani that there is some expectation of extremely bad weather tomorrow. I would recommend that we all provide her with our cell numbers, Amy, you as well. She doesn't have it already, so that if there is some decision made by the State Bar as to the delay of the opening of the building, that we all are aware of what that scheduling may be. All right.
Yes.
Thank you. Have a good lunch. We'll see you in an hour and 15 minutes. Other way around. left hand on the Bible, right hand. There you go. Dr. Harbin, do you solemnly swear or affirm the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Dr. Harbin, we have agreed you can remove your mask for purposes of your testimony. Just ask that you wipe down your cubicle there after the testimony is over.
Yes, sir. Let's make sure, is the microphone on? Little red dot. Check. Please so. Dr. Harbin, what is your full name and business address?
Thomas Harbin, Thomas J. Harbin, and it's Main Street Station in Pittsboro, North Carolina.
And what is your profession?
I'm a psychologist.
Are you a neuropsychologist?
I'm a neuropsychologist. I'm a clinical psychologist, and I'm a forensic psychologist.
Would you describe for us generally what your practice is?
My practice has evolved in the last year or so. I'm no longer doing any patient treatment, with the exception of one or two, and I primarily do evaluations now part-time, some neuropsychological and some forensic.
Would you describe and tell the panel generally what your educational and professional background is?
I got my bachelor's in psychology from Notre Dame in 1976, a master's in psychology from the University of Florida in 1979, my doctorate in psychology from the University of Florida in 1981. I did a postdoc at Duke from 81 to 83, and a postdoc for the National Academy of Sciences from 1983 to 1985.
And since then, do you have any professional certifications or belong to any professional organizations of note?
I belong to the North Carolina Psychological Association. I'm certified by the National Academy of Neuropsychology, and I'm a health services provider for North Carolina.
At this time, I would tender Dr. Harbin as an expert in the field of psychology and that he be qualified to give opinions as such.
Any objection from the state? Mr. Williamson, this is in general psychology or forensic psychology or both?
All right. Well, let me ask, are you experienced in forensic psychology?
Am I?
Are you experienced in forensic
Yes.
psychology? Yes. And would you describe your experience in that regard?
I've been doing forensic evaluations for 20 some years in personal injury, criminal, competence, civil cases, general forensic psychology.
Mr. Williamson, I'll accept him as an expert in both general and forensic psychology.
Thank you, Mr. DeVore. Now, did there come a time that you got involved in a matter involving Henry McCollum?
Yes.
How did that first occur?
I believe Mr. Megaro contacted me to do an evaluation.
When you say do an evaluation, what kind of evaluation did he ask you to do?
This was a psychological evaluation for the purposes of for damage for a civil suit, and to assess the effects or his psychological condition after his incarceration.
And in connection with that initial inquiry, what did you do?
I did a psychological evaluation.
And what did that consist of?
I interviewed Mr. McCollum. I reviewed a number of documents, and I did some psychological testing. And I also interviewed his sister.
Which sister was that?
At the time, I think her name was Suarez, Geraldine Suarez.
Do you know that she was also known at some point as Geraldine Brown?
I'm sorry, it was, at the time I knew her, it was Geraldine Ransom.
Okay, Ransom. You know, she was also known at some point as Geraldine Brown.
At some point, yes.
Okay. And what sort of psychological testing did you do?
I used the Minnesota Multiphasic Personality Inventory, second edition, the Personality Assessment Inventory, the Trauma Symptom Inventory, second edition, and the Structured Inventory of Malingered Symptomatology.
And if you would just describe briefly what those tests are and what they're designed to show.
The MMPI and the PAI are both self-report instruments designed to describe a person's personality as well as the existence of any psychopathology. The Trauma Symptom Inventory is also self-report to evaluate symptoms of post-traumatic stress disorder. And then the Structured Inventory of Malingered Symptomatology is a measure of symptom manufacture or exaggeration.
And as a result of that inquiry and your testing, did you come up with some impressions regarding Mr. McCollum?
He on the test, it indicated that he was exaggerating his symptoms. But as is common in a lot of PTSD cases, I interpreted that to be not necessarily deliberate malingering as much as attempting to bring his condition to the attention of other people, what we call a cry for help. And I concluded that despite the symptom exaggeration, he was experiencing a considerable amount of psychological pain. I concluded that he was suffering from the symptoms of post-traumatic stress disorder, and as well as many symptoms or characteristics of prolonged incarceration, anxiety, hypervigilance, paranoia, difficulty making decisions, and discomfort outside the prison environment. He still had not adjusted to being outside of the prison. He also had not developed the normal life skills that most adults outside of prison would have. Something that people refer to as prisonization.
When did you do that evaluation?
In April and May of 2016.
And again, what was that evaluation to be used for, according to what you were told by Mr. McCollum?
My understanding is to be used in seeking damages for his incarceration based upon any psychological pain and suffering stemming from his incarceration.
Did there come a time that you were asked to do some further work regarding the evaluation of Mr. McCollum?
Yes.
Okay. When was that?
That was sometime in the spring of 2017.
What were you asked? Well, was that something that Mr. Megaro asked you to do again?
Yes.
And what did he ask you to do that time?
At that time, he asked me to evaluate Mr. McCollum's ability to appreciate the settlement offer that was being offered by, I think it's the town of Red Springs, as well as his ability to competently accept or reject that settlement offer.
And what did you do additionally at that time for that issue and that evaluation?
That was limited to an interview.
You say an interview with Mr. McCollum?
Yes.
When did that occur?
8th of March, 2017.
And did you draw any conclusions from that interview of Mr. McCollum?
Yes.
What were your conclusions or opinions from that interview?
I'm sorry, sir.
What were your opinions or conclusions from that interview of Mr. McCollum?
That he understood the nature and amount of the settlement offer, the ramifications of accepting or rejecting the offer, that he was competent to make the decision to accept or reject the offer. And then more generally, that he was competent to manage his financial affairs and to make decisions regarding his person and finances.
And was that opinion based upon your interview that you mentioned on March 8th, plus the work that you had done earlier?
Primarily my interview of March 8th, but I mean, I couldn't ignore what I had found earlier.
Now, did there come a time that you were asked again by Mr. Megaro to do a further evaluation?
Yes, sir.
When was that?
That would have been sometime in the late summer or early fall of 2017.
And what did Mr. Megaro ask you to do at that time?
A neuropsychological evaluation.
Do you recall that he asked you even before then to do a critique of Dr. Corbin's report?
I recall that I was asked to do that. And yes, it looks like it was before the neuropsych eval.
Okay. Let's talk about that first. If we could get Exhibit 58. I know you can't see a whole lot of that right there, but do you recognize that? Is that a report that you did for the critique of Dr. Corbin's report?
Yes, it looks like it.
Okay. And in doing that critique, what did you review?
I reviewed Dr. Corbin's report.
And do you recall that you listened to an audio CD of Dr. Corbin's interview with Mr. McCollum?
Yes, I did.
Did you reach some opinions regarding Dr. Corbin's report as a result of that review?
As a result of my review,
Yes.
I'm not sure I understand your question.
Well, did you reach some opinions regarding Dr. Corbin's report and make some observations concerning it as a result of your review of his report?
Yes.
Okay. And are those contained in this Exhibit 58? And we're going to scroll down and look at some more.
Are you referring to, I'm not sure what you're referring to. Talking about referring to Doctors Rumor and Rogers and Sultan and those.
No, I'm still on the first page, the first paragraph. If you look at the screen, you see what's bold there.
Okay.
Okay. It says, this conclusion is at variance with the conclusion expressed in my letter to you dated 8 March 2017 and in my subsequent testimony. Could
Yes.
you say what you meant by that?
That I disagreed with Dr. Corbin's conclusions.
Okay. And in what respect did you disagree?
that I did not agree with Dr. Corbin that Mr. McCollum lacked the ability to manage his affairs.
And scrolling down a little bit more, there is, you see where it says there are several issues that weaken the foundation of his, and I assume that means Dr. Corbin's opinion of Mr. McCollum's competence. Do you see that?
Yes.
And then you discuss some issues. The first one is Dr. Corbin bases determination of incompetence in part on previous diagnoses of intellectual developmental disorder, formerly mental retardation. If you could expand on what you wrote there as to what your observation was in that regard.
Well, again, competence is not defined by an intelligence test. Intellectual disability is not defined solely by an intelligence test. That would be one issue. The other issue is that an IQ score has a known variance that it's assumed that an IQ score is composed of a true score plus random variance, and that random variance has been determined to be roughly 34% above or below, or 34% of people will be 15% higher than their true IQ score. 34% will be up to 15 points lower than their true IQ score. So the number isn't a solid, a concrete number. It's the center of a range.
Going to the next page, the paragraph 2. You speak that there's a determination of deficits in adaptive function is necessary. Could you expand on what you were talking about there?
Well, to diagnose someone with intellectual disabilities, it's two-pronged. It needs a certain IQ level and a level of deficits in adaptive functioning.
And did you have a criticism that Dr. Corbin did not do that sort of inquiry?
If he did it, he did not report it. He didn't report any measure of adaptive functioning.
And you set that forth here in what we've highlighted, I see.
Yes.
And then you go on in the next paragraph to discuss who he actually did interview, including Ken Rose. What is your criticism about that interview with Ken Rose?
Well, he didn't report what Mr. Rose said with regard to the management of his affairs. So we were left wondering what information Mr. Rose did present.
And then you also go there forward and say, Dr. Corbin opined that Mr. McCollum has an extensively well-documented history of adaptive functioning deficits without providing the alleged documentation of that history other than brief references to previous psychological evaluations. Could you expand on what you meant there?
Well, first of all, those were very old evaluations. And secondly, there was no presentation of what measures, if any, were used to determine adaptive functioning deficits.
Now, number 3, you criticize his basing his opinion upon the MoCA, Montreal Cognitive Assessment. Could you expand on that?
Diagnosing cognitive impairment requires more than a screen, which is what the MoCA is. In addition, Dr. Corbin sort of lumped together two distinct abilities, visual spatial functioning and executive functioning, as an indication that for some reason there was cognitive impairment. And I think in order to make that kind of a determination, a more complete evaluation was needed.
And is the MOCA more or less a screening test and not a test that one would rely on to make an ultimate conclusion?
I have not used it, so I'm not familiar with it. My understanding is that it's screened.
Whoa, there was an
Just a
objection.
second, Doctor, with an objection? Overruled. Only, Mr. Murphy, I gave you a lot of leeway in your cross-examination earlier, and I know you can lead during cross-examination, but overruled at this point.
Let's back up. Is the MOCA a screening test?
Yes,
And is it a test that is intended to be relied on to form an ultimate opinion?
I am not familiar with the MOCA, so I can only provide sort of a speculative answer to that. But if it is a screen, it's one that I've never used. If it is a screen,
Mr. Murphy, just a second. Mr. Murphy, I cannot hear you when you do an objection. If you're giving one, I cannot hear it.
He said he's giving a speculative answer, and I object to him giving any speculative answer.
Overruled.
Go ahead and continue with your.
short answer would be that a complete neuropsych eval should have been used.
And you noted that at the end of that paragraph, correct?
I'm sorry?
You noted, that's what you noted at the end of that paragraph. However, if one,
Yes,
yeah, and was that done?
not by Dr. Corbin, no.
Now, the next number on that page, you say Dr. Corbin reported no assessment of strengths and weaknesses directly related to Mr. McCollum's management of his financial affairs. Could you expand on that observation as well?
Well, in my opinion, if you're going to determine someone's competence to manage their financial affairs, you ought to ask more questions about their financial affairs and what they know about their financial affairs and how they manage their affairs.
We go to the next page, page 3. You noted there at the top that Mr. McCollum balances his own checkbook, et cetera. What was the significance of that, if any?
Well, he didn't ask him any details of the proposed settlement.
Now, the last paragraph begins in consideration of. If you could just read that paragraph, and I'll ask you if that's still your opinion.
In consideration of the above information, it is my opinion that Dr. Corbin's evaluation provides little information relevant to the question of Mr. McCollum's general competence, his competence to accept or reject a settlement offer, or to manage his financial affairs. In addition, I reiterate and stand by my opinion to a reasonable degree of psychological certainty that Mr. McCollum does have the capacity to accept or reject the offer and to manage his affairs.
And realizing that you did some additional work on this matter after that, are the opinions expressed in that paragraph still your opinions today?
Yes.
Now, after that report, did you have yet another occasion to do some additional work regarding Mr. McCollum?
Yes.
And what were you asked to do? Or was that something else that you were asked to do by Mr. Megaro?
Yes.
And what were you asked to do?
A neuropsychological evaluation.
And if we would go to Exhibit 60. And just looking at that heading there, that's dated October 19, 2017. Do you recognize that as the report that you did of your neuropsychological evaluation?
I recognize the letter, and yes, that looks like the evaluation.
And that date, October 19, is almost exactly a month after Exhibit 58, which was your critique of Dr. Corbin. So was it within that time frame that you did the neuropsychological evaluation?
I saw Mr. McCollum on the 4th of October of 2017.
And if we could go to the next page where it's a neuropsychological evaluation. Now that recites in some detail what you did on, I take it on October 4th, but if you could just generally describe for the panel your process in doing that evaluation.
I did a specific neuropsychological interview, which asks about the respondent's opinions of his various abilities. And then I also tested him in those various abilities, including overall intellectual functioning, memory, attention, language, perception, and praxis. And then also I assessed his adaptive living skills.
And to your knowledge, had Dr. Corbin done any of that?
Not to my knowledge. With the exception of the MOCA.
Right. And at that point, you indicate at the bottom of that first page, going over to the second page, that you did review Dr. Corbin's September 9, 2017 report, correct?
Correct.
And you also reviewed under paragraph 2 on the next page, the forensic report by Dr. Bellard dated September 24, 2017. Did you, in fact, review Dr. Bellard's report?
Yes.
And were you here this morning when Dr. Bellard testified about such matters, including that report?
Yes.
And you also reviewed your September 18, 2017 letter to Mr. Megaro, and that number 4, a psychological evaluation conducted by this examiner dated 28 July 2016. That was the earlier evaluation that you did, you've already testified about.
Yes.
Correct. Okay. Now, the rest of that page 2 on to 3 basically contains your observations and a synopsis of your interview with Mr. McCollum. Is that correct?
That's correct.
And what would you, in particular, if anything, stress to the panel about your observations and interview that was important to your overall opinion?
Well, he denied certain areas of impairment, including language, comprehension and spelling. He denied impairment of his mathematical skills and his visual spatial skills, denied left-right confusion. But he did say that he denied memory impairment, but he did say that he experiences impairment of his concentration when he's tired. He denied psychological symptoms, including depression, other depressive related symptoms. He did report symptoms of PTSD related to his previous incarceration. Denied most neurological symptoms, reported that he had one head injury with a loss of consciousness. And then described living with his fiance, being independent in his activities of daily living, with the exception of driving. Denied drug use, and reported what I interpreted to be substandard education.
Now, at the next page 3, you talk about the tests that were administered. See that? You do see that, right? That was the
Yeah,
question.
yeah.
Okay.
I did list the tests that I used.
Okay. Now, in that first paragraph, you refer to a number of tests. Could you just, since we're all laymen other than you, if you would just go through the tests that you administered and just tell the panel and us what each test is really designed to show or measure.
The MMPI-2 is designed to, again, describe a personality as well as pick up any psychopathology. The aphasia screen is a series of exercises designed to pick up language disturbance. Apraxia screen is a series of exercises designed to pick up any disturbance of fine motor control. Figure of fluency is a measure of in a right-handed person, right frontal lobe functioning. The California Verbal Learning Test is a verbal memory test. The Continuous Performance Test is a measure of attention. The right-hand finger oscillation is again a measure of fine motor control. The Ray Osterith complex figure test is a measure of visual spatial functioning and right hemisphere functioning. The 2 and 7 test, is a measure of the ability to initiate behavior, which is a frontal lobe ability. The controlled oral word association test is similar in that it is a measure of the ability to generate behavior or generate items in the verbal domain. Trail making test is a measure of planning and executive function, as is the Wisconsin card sorting test. And the Vineland is a measure of adaptive skills functioning.
And were all of these tests components of a comprehensive neuropsychological exam?
The Vineland isn't usually part of it. I added that, but the rest of them are my standard neuropsych test battery.
What, if any, of these had been administered by Dr. Corbin previously?
I don't think any of them were.
In administering all these, how long did all that take with Mr. McCollum?
Usually takes about 4 hours without the Vineland. And he wasn't involved in the Vineland. So I would guess, I can't remember exactly, but probably around 4 hours.
Now, for the next several pages, before you reach summary and conclusions, you talk about results, correct?
Correct.
From the test that you administered that we just went over. Let's go from each one in order that you have here. And if you would just tell the panel what you believe was significant for the finding of each of those. First, as the overall intellectual level, what did you determine there?
He had a full scale IQ of 69. But that was less interpretable due to differences in some of his subscales. His processing speed index, for example, was in the low range of normal. That's a measure of speed of information processing. Working memory and perceptual reasoning, which is visual perception abilities were moderately impaired, and his verbal comprehension index was severely impaired. So there were significant differences in various aspects of IQ testing.
What, if any, was the significance to you that there were significant differences among those subtests?
Well, it's a matter of complete reporting, first of all, but secondly, it indicates that the full scale IQ score is only a very gross measure of functioning. Some abilities that go into it were better than others.
Let's next go on to memory. If you would do the same with that section, tell us what you found significant about that and explain your findings.
I tested memory in a number of ways, both verbal and nonverbal. His nonverbal memory, which is memory for visual sort of geometric figures, was within normal limits for both immediate and delayed recall. For verbal information, his immediate memory span was mildly impaired, while his learning ability and both immediate and delayed recall were within normal limits. He on measures of recall, it was difficult to get what I consider to be an accurate measure, because he had what we call a very liberal response bias. He tended to identify lots of words as ones that I had asked him to remember that were not. But by and large, his recall was generally within normal limits.
We next go on to the section about attention. Again, would you describe your general findings there and what seemed to be significant to you?
There are a number of aspects of functioning that go into what we call attention. His ability to plan and adapt his behavior to changing situations was moderately impaired. For nonverbal measures, his response initiation, his ability to generate responses, was moderately to severely impaired. Verbal fluency was within normal limits. Sustained attention was within normal limits. What we call sequential processing, in other words, the ability to consider stimuli in some order. In one case, it's drawing a line from one number to the next. In a more complex situation, the patient has to alternate numbers and letters. That was slowed. He appeared to be able to switch attention from one task to another. And his processing speed appeared to be also within normal limits.
And the next section there is language. If you could also talk about that.
I measured a number of different aspects of language. Mr. McCollum had difficulty pronouncing difficult words and was unable to repeat what I call a complex sentence. He was able to follow a 2-step, but not a 3-step command. Made errors when writing to dictation. And most of the other things that I asked him to do, remember task instructions, read aloud, copy, were within normal limits, although he did have poor math skills.
Now there's another sort of Latin looking word there at the end of that section, acalculia.
Yeah,
Is that the
acalculia is impairment of mathematical skills.
And you said there was no evidence of that.
Correct.
Just to be clear.
He had poor math skills, which I attributed to his poor education, but the characteristics of acalculia, the inability to line numbers up to be added or subtracted, reversing numbers, things like that was not evident.
The next section is perception. Again, what did you find there and what did you find significant?
His visual perception was pretty bad, is severely impaired. This involves copying a complex figure. He did not do well on that. Various, both what we call the gross overall form, as well as individual details were problems for him.
The next is praxis. First of all, if you would just tell us what the word praxis means in this context.
And fine motor control of the hands.
And again, what were your findings there?
Basically within normal limits. No evidence of problems with dexterity. No evidence of sensory suppression, left-right confusion, or what we call finger agnosia.
What is finger agnosia?
Certain types of brain damage leave people with a deficit in the ability to recognize which finger is being touched, which side of the body is being touched, and so forth.
Now that last sentence says there was no evidence of, is it buccal or buccal facial impairment?
If someone has a language problem, it's important to know if it's coming from the language processing centers of the brain, or if it's coming from the musculature of the mouth and face. In other words, is it the inability to formulate words and sentences, or is it an inability to make your mouth move? And buccofacial muscles are the ones that we're talking about there, and there was no evidence of problems with those muscles.
The last category there from your testing was about adaptive living skills. First off, before you talk about that, why are adaptive living skills an important component of determining one's competency to handle one's affairs?
Well, it is part of the two-pronged definition by the DSM, the Diagnostic and Statistical Manual for determining intellectual disabilities. It's also part, I believe, of North Carolina statute in determining whether or not someone is competent to manage affairs.
Okay. And we've heard testimony about what adaptive living skills means, but if you could just tell us what your understanding of that term is.
It's the ability, those are the skills necessary to carry out their normal day-to-day functioning. The Vineland measures language, personal skills like interacting with people, domestic skills, can you feed yourself, can you keep yourself clean, communication, again, the ability to make yourself known, play and leisure skills, can you recreate, can you interact socially with people, and then coping with disappointment, coping with disagreement, coping with stressful situations.
And what was your finding regarding Mr. McCollum's adaptive living skill?
For written expression, he was at the 12-year-old level. Interpersonal relationships, he was at the 15-year-old level. And at the 18-year-old level or above for the rest of them.
Now, the next section on page 5 over onto page 6 contains your summary and conclusions. If you would, again, tell us what your the important points are about that and what your conclusions were.
There was evidence of cognitive impairment, including a low IQ, mild language impairment, impairment of his ability to plan and adapt. That level of, or those impairments I interpreted to be commensurate with his general overall intellectual ability. I also concluded that he still suffers from PTSD, that with the exception of his written language skills and his interpersonal relationships, he has mostly adequate adaptive living skills. And then finally, that there was nothing in the results of my evaluation to suggest that he is not capable of managing his affairs.
And let me ask you, in your summary of the various tests you did and the various abilities you measured, does the fact that some of them were below normal, does that necessarily mean that someone like Mr. McCollum would not be able to handle his affairs or would need a guardian?
No.
And just why is that?
Everyone has their strengths and weaknesses. Mr. McCollum's abilities are generally lower than I would think the general public, but specific to managing his affairs, it would have to be much lower scores than I found.
And numbers 4 and 5, you did find that there was nothing in the results of this evaluation to suggest that Mr. McCollum is not capable of managing his financial affairs.
I did say, yeah, I did write that.
And would you stand by that today,
Yes,
as far as you know?
as well as far as I knew then.
Now, you personally have not done any further testing of Mr. McCollum after this point, correct?
I have not.
Now, have you had the opportunity to review an additional report from Dr. Corbin?
Yes.
It's fairly recent.
Yes.
And do you have any observations significantly about that report?
My observation was that it was consistent with his first report, both in terms of methodology and conclusions.
Did it contain any additional testing or indeed any information that you would regard as important to your own opinion that you previously expressed some time ago about Mr. McCollum?
I didn't find anything in his most recent report to change my conclusions.
And I take it you were here this morning during the testimony of Dr. Bellard, were you not?
Yes.
Do you recall that that the results of your neuropsychological evaluation were given to Dr. Bellard for his consideration?
Yes.
And having heard the testimony of Dr. Bellard, did it appear to you from his testimony that he took appropriate consideration of your testing results of Mr. McCollum in his testimony?
He appeared to have considered what I had to say.
Well, did he appear to consider it in an appropriate manner?
Yes.
Okay. And you heard his various conclusions about Mr. McCollum's competency and whether he needed a guardian. Do you disagree with Dr. Bellard's opinion in any significant respect?
I don't disagree with what he concluded.
And just to be clear, and I think it is your conclusions are based actually on quantifiable data, and the series of tests that you used are generally accepted tests in this field. Is that fair to say?
Yes.
No further questions.
Cross-examination. Excuse me, will there be cross-examination by the state?
Yes. I proceed. Dr. Harbin, my name is Pat Murphy, along with Joshua Walthall. We represent the State Bar and have some questions I want to ask you about. In your most recent evaluation or testing, I guess, of Mr. McCollum, you found that he had a 69 IQ. It's a full scale. Is that what I understood?
Yes,
And that is, did you hear Dr. Ballard today basically say below 70 or below 70 is generally regarded as the cutoff line for intelligence,
yes,
sub-level intelligence.
yes.
And you also found in your most recent evaluation or testing of him that he has deficiencies in adaptive living skills.
That
He has deficiencies in adaptive living.
he had some, yes.
And would you describe those again?
Dr. Harbin, would you also, I know it's very awkward, but would you try to speak as close to the microphone as you can, sir? I know it's a very awkward cubicle that you're in between screens and microphones,
Right.
but for the purpose of the record, would you try to speak into the microphone?
I won't be avoiding your contact. Eye contact. I'll be doing it when I can.
I understand.
He was at the 12-year-old level for written expression and at the 15-year-old level for interpersonal relationships and at the 18-year-old level or above for the rest of the measures.
How old was Mr. McCollum at the time you conducted this battery of tests on him?
53, I believe.
And he was functioning at a 12-year-old level on written in his writing?
In his written expression abilities, yes.
What does that mean?
To me, it means that he had bad schooling.
And as a result of that bad schooling, what is his adaptive deficiency?
In terms of written expression, it's at the adolescent or pre-adolescent level.
And when you say written expression, you mean writing out things to express himself?
Yes.
Do you know there's been some evidence that he's writing a book? Is he
I
writing
did
it
not know
himself?
that.
Pardon?
I didn't know he was writing a book.
Do you think he would have extreme difficulty in writing a book with his current level of skill?
I don't know what his current level of skills is, but based upon 2017, I would say he might not have trouble writing a book. He might have trouble getting it published.
Any level functioning at a 15-year-old level for interpersonal relationships? What type of interpersonal relationships are you talking about?
The measure, the Vineland asks about interacting with other people, having friends, doing social activities. And the primary aspect of that pulled that score down was he did not have much of a circle of friends at that point. So when that score is included in the overall score, it brought his score down.
Let me ask you, when you say at the end that he's Mr. McCollum, well, there's nothing in the results of this evaluation to suggest that Mr. McCollum is not capable of managing his financial affairs. Are you limiting your opinion to just financial affairs?
In that statement, yes.
So you're not making an overall assessment of his competency under North Carolina law?
In the neuropsych eval?
Yeah.
Correct.
And you produce this information primarily to try and show that Dr. Corvin's testing, in your view, or lack of testing, or his report is deficient.
I produced this document, this evaluation at the request of Mr. Megaro, with the understanding that this part of the stimulus for that was deficiencies, my opinion of deficiencies in Corvin's report.
So he wanted someone to go after and show deficiencies in Dr. Corbin's report, both you and Dr. Ballard. I believe you heard Dr. Ballard testify earlier today. Is that correct?
Are you asking me if I was going after Mr. Corbin?
Going after his report.
No.
Okay. So what was your understanding again of why Mr. Megaro wanted you to conduct this?
To provide a more comprehensive evaluation of Mr. McCollum's cognitive abilities.
There was nothing about trying to discredit Dr. Corbin's report in what you were doing.
I produced a report that reflected my evaluation, and if it supported Dr. Corbin, I would have written so.
Did you hear Dr. Ballard's testimony this morning that even before he had completed his evaluation, he knew that he was going to try to discredit Dr. Corbin's report?
I believe that was your suggestion. I believe Mr. Ballard did not agree with that.
Okay. Do you see our exhibit 167 on the screen there?
Yes.
And it's an email from Patrick Megaro dated October 23rd, 2017 to Tom Office. Now, is that your email?
I don't see my email there, but I assume that's me.
Okay. And then also to James Ballard.
Yes.
And there's a docket entry number 233, order finding Henry McCollum incompetent. And then Mr. Megaro says here, need your reports ASAP. I need to challenge this. So was Mr. Megaro wanting something that could challenge Dr. Corbin's report?
It appears so.
Okay. Now, how did you first get involved with Mr. Megaro?
I have worked on many cases with Mr. Megaro. I don't remember each of them, and I don't remember exactly when it happened, but we have worked together on other cases.
In Mr. McCollum's case, how was it that you started working with him, or what was the connection that engaged your services?
I don't remember specifically. My office used to be located in Fayetteville, and I did a lot of work with the military there. And I wonder if Mr. Megaro had a case centered in Fayetteville, and he looked me up. But frankly, I can't remember how we got involved.
Do you remember do you know an individual named Kim Weeks?
The name sounds familiar. Yes.
Do you know she had any involvement with Mr. McCollum?
I don't remember.
Isn't it true that Kimberly Weeks is the first one contacted you about doing some work for, or doing some evaluations for Mr. McCollum on Mr. Megaro's behalf?
I don't remember that.
come back to that. If you look at the screen, Dr. Harbin, do you see an email?
Yes.
All right, I'll come back to that. What were you originally asked to do in respect to Mr. McCollum?
A psychological evaluation
What purpose?
for the purposes of determining psychopathology subsequent to his incarceration.
So he filed a civil suit or was going to file a civil suit, and he wanted you to be able to provide some testimony with respect to damages, what the effects of incarceration had been on him, that type of information.
Yes,
And did you do a report on him?
yes.
Did Mr. McCollum immediately come and meet with you?
No, it was difficult to get him in.
Why was that?
He just kept missing appointments.
Did he miss as many as 4?
Yes,
And then let me refer you to State Bar Exhibit 124. You see 124 on your it should be State's Exhibit 124 is an email dated Monday, April 4, 2016. If you scroll down to where there's an email from you on April 4 at 1:16. Read for the record what you wrote in that email to Mr. Megaro.
you want me to read it?
Yes, if you would, please.
Has something changed? It didn't seem like Henry didn't want to come in. They just didn't show up.
So is this about the time when he was not coming for his interviews?
Looks like it, yes.
Okay. And then scrolling on up, the reply email from Mr. Megaro at April 4 at 1:38. What did, if you would read that, the text of that email?
Yes, they suffered a financial setback, so as a result, they are now more motivated. Their sister and caregiver is leading the charge as she is the one who is now suffering the most financially.
So what did you take from that in terms of finally getting Mr. McCollum in to do your evaluation?
It's been almost 5 years. I don't know what I took from that.
Would it be a fair assessment that the financial motivation now was what was motivating Mr. McCollum to come in and do the evaluation?
I don't think I can knowledgeably answer that.
Now, you did your evaluation and reported it on July 28 of 2016. It's State Bar Exhibit 643. It should be on the screen for you. Is that your report, sir?
I see the letter. Yep, that looks like my report.
Yeah. So when you first met, when you're putting together your psychological evaluation, was your first impression or your overall impression that Mr. McCollum gave at that point, was that of a suspicious middle-aged African-American male of below average intelligence?
Yes,
And that's from just, would that be just from first meeting him, or is that after the whole process has gone through?
no, that's my initial impression.
Okay, so,
Well, it's my initial impression plus watching him throughout the testing.
and so it's pretty obvious that he just presents himself as a below average, with below average intelligence.
Yes,
And you document some information in here that he'd been on death row for 3 decades, and go over information about that. Let me refer you over to page 3 of 8 of your report. Did you refer to certain affidavits during the course, or review certain affidavits during your evaluation?
are you talking about point number 5?
Yes.
Yes, looks like it.
And would you read that for the record?
Number 5, affidavits of Richard R. Rumor, PhD, on 28 March 1995. Dr. Rumor conducted a psychological evaluation and noted that Mr. McCollum's childhood was characterized by poverty and neglect, and that he was raped at some point. He abused drugs and alcohol. Dr. Rumor diagnosed Mr. McCollum with depression, post-traumatic stress disorder, mental retardation, and, quote, severely limited cognitive functioning, end quote. Dr. Rumor further wrote that Mr. McCollum was suffering from, quote, extreme stress, both from the trial and from the execution of another death row inmate, close quote. Mr. McCollum told Dr. Rumor, quote, I almost lost my mind when they killed Brooke. I can't stand executions. I can't deal with the pressure, close quote. On 23 January 2002, Dr. Rumor wrote that Mr. McCollum had an IQ of 61, measured in 1975, of 56 in 1978, of 71 in 1979, and 72 in 1984. His school records from Jersey City categorized him as educably mentally retarded. In 1991, he opined that Mr. McCollum met criteria for mild mental retardation, that school records indicated that he received special services as educably mentally retarded, that he had very low achievement scores, and that he was victimized by his peers. These conclusions relied on psychological evaluations by Stephen Mercado in 1975, Ronald J. Gironda in 1978, Francis Coylan in 1975, and Elizabeth Carmody in 1978, all of the Jersey City schools.
Okay, you can stop there. So it's fair, is it fair to say that Mr. McCollum has a significant history of low IQ scores?
Mildly low, yes.
Well, would you characterize something in the 50s as mild?
No, overall, I would say they were mildly low.
All right. Well, I'm asking you, a IQ score in the 50s, would you categorize that as low?
I would categorize that as low.
And what about in the 60s, one like 61? Is that low?
Technically, that's low. Anything below 70 is low.
And so he's got a history of them, 56 in 78, 61 in 75. And these are all done, I guess, with Dr. Rumor's report. These were done prior to 1995, correct?
Correct.
Okay. And we know that Mr. McCollum went to death row sometime in the early 90s after his second trial. You recall that?
Yes.
And that he basically stayed on death row until 2014.
Yes.
Do you know what kind of educational services he got while he was on death row?
No.
If anything, you would expect a 19-year-old, a person who went to death row at 19 years old, with already low IQ scores, that would you not expect that that person on death row would not get significantly better in terms of education?
I think that's fair.
And in fact, on your number 6 of your report, there's a psychological consultation by Dr. Rumor, and that's, I guess, dated November 18 of 2019, where he opined that the statement that Mr. McCollum allegedly gave to police was well above his level of literacy. Would you agree with that?
I did not see the statement, so I would have no opinion.
You've never seen the statements that Mr. Megaro, Mr. McCollum made?
If I did, I don't remember them.
Well, do you have any reason to question Dr. Rumor's assessment that they were well above his level of literacy?
I would want to see all the information before answering that.
Now, you were assisting the Mr. Megaro and Mr. McCollum in their civil case, correct?
I would not put it that way.
Okay.
I was an independent expert that they retained.
And they retained you for what?
They retained me to do a psychological evaluation
For what purpose?
for the purposes of his civil suit.
Supporting his claims that he was coerced into making a false statement by law enforcement officers, that he had he was a person with sub-intelligence, low IQ, and that he was put on death row unjustly for 31 years. Weren't you trying to develop those issues, damages?
No,
No. Okay. Did you review a report by Dr. Helen Rogers?
yes, I reviewed it in affidavit.
Okay. And would you read what you concluded from her, or you put in your report from her affidavit?
That it was likely that Mr. McCollum suffered from PTSD and that he was unlikely to have been able to comprehend the principles and strategies of his defense and unable to follow the progress of his criminal trial. That his decision-making was severely impaired and that he is not capable of weighing the consequences of his choices and is susceptible to leading questions.
Is that inconsistent with your assessment of Mr. McCollum?
My assessment of Mr. McCollum did not focus on those questions in this evaluation.
So why did you put this in your report?
Because it was a complete review of the available literature.
Okay. So when she says his decision-making was severely impaired, would you agree with that or not?
Based upon this evaluation or based upon everything that I did?
Based upon this evaluation first.
No.
Dr. Faye Sultan, you reviewed her affidavit, correct?
Yes.
And she conducted a psychological evaluation on 30 March 1995 and found mental retardation. You agree with that?
That she wrote that? Yes.
And do you agree that he was suffering from mental retardation, which is now IDD?
I don't agree that he suffered from intellectual disabilities because he did not have severe impairment of his adaptive living skills.
And she found he had impaired verbal comprehension. Did you find anything inconsistent with that?
I found information consistent with that.
She found that he's highly suggestible. Did you find anything inconsistent with that?
I have no opinion with regard to that.
Dr. George Baroff examined him in 1995 and in 2002, he found he was found mental retardation and difficulty with verbal comprehension. He opined that Mr. McCollum could not have knowingly waived his Miranda rights. I take it you disagree with his finding that he found Mr. McCollum suffering from mental retardation.
Back then, the criteria were different. I don't know if I don't remember when the requirement for impairment of adaptive living skills was included. But based upon today's standards, I would say that Mr. McCollum does not suffer from intellectual disabilities.
Although he found some, you found that he did.
He would not suffer from the official condition.
Now you. Did you interview Geraldine Ransom?
Yes,
And that's his sister?
yes.
Do you know what role she was playing at the time in his life and Mr. McCollum's life?
At some point, I believe she was appointed as a guardian or some other supervisory position, but I don't recall exactly.
What did she tell you in her interview?
You want me to read it?
Please.
Ms. Ransom is Mr. McCollum's sister, and he was living in her home at the time of this evaluation. She reported that he is messed up. She reported that he gets offended when people look at him, always carries a flashlight with him because he's afraid that someone is hiding to get him, is afraid to pull money out of his wallet, afraid that people are trying to read the numbers on his debit card, and afraid to travel alone without accompaniment. She reported that he has nightmares and falls out of bed crying for his deceased mother. He has failed the written test for his driver's license 9 times. He is impulsive and has purchased 6 cell phones, 4 tablet computers, and 2 laptop computers. Ms. Ransom reported that Mr. McCollum is naive about marketing. For example, he thinks that promotional offers on television are directed at him personally. She stated that he is confused and he'll die confused.
Now you did some testing of Mr. McCollum for this report, did you? The 2016 report, correct?
Yes,
What testing did you do?
the MMPI, the PAI, the SIMS, and the TSI.
And what is the MMPI? What is the MMPI designed to measure?
Personality and psychopathology.
And what information will it give you or can give you to help you make an assessment?
It will give you a description of the person's personality along with information with regard to psychological problems such as depression and anxiety.
But you couldn't use that to evaluate Mr. McCollum because of he appeared to be exaggerating the severity of his symptoms.
Yes, that's correct.
Did you conduct one of those later on?
No,
In the second?
in the neuropsych eval.
Yeah.
It is listed there, but that is a mistake. I don't think I redid it. It's listed in the neuropsych eval, but I did not re-administer it.
What's the PAI?
Similar to the MMPI, a measure of personality and psychopathology.
Were the results of that test valid?
No,
Why not?
exaggeration again.
And the SIMS, what is that designed to measure?
That's a specific measure of the tendency to exaggerate symptoms of psychopathology.
And the result of that is that he was in fact exaggerating the severity of his symptoms,
That's right.
in your opinion. The TSI-2, what was that designed? What's that designed for?
It's a measure of the psychological sequelae of a traumatic incident or psychological trauma.
And he had reported psychological trauma to you, had he not?
Yes,
And what did you file down at the bottom? You said his profile also suggests that he will be overly dependent upon others for decision-making, will be overly influenced by others, will lack self-confidence and assertiveness, and will be easily influenced and manipulated by others. Is that what you found,
yes,
according to that testing?
yes.
And do you still stand by that?
Do I stand by that state?
Right.
Yes.
So as of the last time you met with Mr. McCollum, which was, I guess, October, November of 2017, is that correct when you did the testing?
This was the first test that I did. This
Right,
was
I
in
understand.
2016.
Yeah, I understand that, but so the findings here that you had in 2016 evaluation, do you still think that's a valid result as of the last time you interviewed him or conducted your analysis of him, which would have been in 2017, I believe?
The purpose and conclusions of this evaluation bear little upon the purpose and conclusions of the subsequent evaluations.
How so?
This was a psychological evaluation. It was not a competency evaluation. It was also not a neuropsychological evaluation.
So are you saying that your statement here is no longer true?
No, I'm saying that it doesn't bear directly on conclusions from my subsequent evaluations.
Okay, so we should take nothing to bear on your subsequent evaluation where you said that his profile also suggests he will be overly dependent upon others for decision-making, will be overly influenced by others, and will lack self-confidence and assertiveness, and will be easily influenced and manipulated by others. That's no longer a problem for him?
I didn't comment upon whether it was a problem. That is the conclusion drawn from the profile of the TSI, if that's what you're asking me.
Right. From testing of Mr. McCollum
Yes,
in 2016.
yes.
That he would need help, that he would be dependent on others for decision-making.
Is that a question?
Was that in your report?
That's in my report.
Okay. He could be overly influenced by others. Correct?
According to the interpretation of the TSI.
In your conclusions, you found over on page 8 of 8, he'd been diagnosed, that you found a diagnosis of post-traumatic stress disorder, right?
Yes,
And intellectual disabilities.
yes.
And above that, number 4, read that for the record, will you, please?
Due to the fact that Mr. McCollum was incarcerated at a young age, combined with the fact that he suffers from intellectual disability, his prisonization, i.e. institutionalization, was likely more intense than most inmates. In addition, he has had no rehabilitation or assistance in re-entering society. He is unlikely to ever recover significantly from the severe distortions to his development, life skills, and ability to enjoy intimate personal relationships caused by the harsh, dangerous, demeaning, and depersonalizing experiences of his confinement.
When you're talking about life skills there, what do you mean by that?
When he came out, for the time that I was evaluating him, things like using an ATM, like being out in public and being paranoid that people were out to get him, like conversing and having friends with others, like his poor educational history, those skills.
Okay, are they part of adaptive functioning skills? And you were assessing him in 2016, correct?
Correct.
And he'd signed a legal services agreement with Mr. McCollum in 2015. Did you know that?
With who?
Mr. Megaro, excuse me.
I am aware that he retained Mr. Megaro at some point, but I'm not aware of the details.
So if it did show, if the evidence does show that it was in February of 2015, strike that note. Let me strike that. Your opinion on 2016 was that Mr. McCollum was unlikely to ever recover significantly from the severe distortions of his development, life skills, and ability to enjoy intimate personal relationships caused by the harsh, dangerous, demeaning, and depersonalizing experiences of his confinement. Is that correct?
That's what I wrote, yes.
Now, did you later do another evaluation for Mr. Megaro?
Yes.
And when was that?
Are you referring to 8 March of 2017?
Yes.
It was 8 March of 2017.
And how did it come about that you did this next assessment?
He was about to accept or reject a settlement, I believe, from the Red Springs Police Department. And Mr. Megaro asked me to assess his competence to accept or reject that offer.
Do you know why there was some question about his competence to accept or reject that offer?
I don't know if there was questions about it or if he just wanted to have it documented.
Let me refer you to State Bar Exhibit 148. All right, do you see Exhibit 148 in front of you?
Yes,
And do you recognize this as an email you got from Mr. Megaro?
I don't remember the email, but I see that it's addressed to me.
All right, and what is this requesting of you?
I don't see a request yet in what's displayed.
Well, if you scroll down to the bottom, second last paragraph from the bottom,
What he wanted was an evaluation as to his competency to enter into the settlement agreement.
and had you had any contact with Mr. McCollum from the time you did your evaluation in July of 2016 until you did the second evaluation in March of 2017?
I had no contact with Mr. McCollum between May of 2016 and March of 2017.
Let me show you what's marked as State Bar Exhibit 149. If you go over to second to last page, you see where there's an email from you, Thomas Harbin, on March 8, 2017 at 11:34.
Yes,
Would you read that for the record, please?
Henry arrived and I evaluated his capacity / competence to accept or reject the settlement offer from Red Springs. I believe that he is competent to make that decision. Do you want a letter / report to that effect?
And what was Mr. Megaro's response?
Are you referring to the email displayed here?
Yes.
Can you also include in the letter that under the law, he would not meet the
Well,
requirement?
strike that first.
Tell you what, Mr. Murphy, let's take a break right now, our afternoon break. It's about 3:17. Doctor, if you step down, please. We'll resume at 3:30. Scattered storms.
March 8,
Yes.
and scrolling on up. There's a email from Mr. Megaro to you regarding Mr. McCollum on the 8th of March at 11:44. What did Mr. Megaro say to you at that point, or write in this email?
Do you want me to read it?
Please, sir.
Can you also include in the letter that under the law, he would not meet requirements to be declared incompetent and to be assigned a guardian?
So had you already done an assessment on him as to whether he could, Mr. McCollum was competent to accept or reject the settlement offer, and now Mr. Megaro is asking you to add to your evaluation? Yes or no?
Yes.
And were you able to do that?
I primarily restricted it to his ability to manage his financial affairs, but I did make a statement, a more general statement about being able to make decisions concerning his person and finances.
And did you send some kind of letter or attachment or draft or report to Mr. Megaro after having evaluated Mr. McCollum on March 8th?
I don't remember if I sent him an email with an attachment or just sent a letter. I think I just sent the letter.
Will you look at the email, State Bar Exhibit 149 that's
Yeah,
in
it looks
front
like I
of you?
sent a draft.
Okay. So when you said draft attached, what would that have been a draft of?
This letter / report.
Okay. And did you get a response back from Mr. Megaro regarding that?
I see what you have here. Can you point me where you want me to look?
We see an email from Patrick Megaro, March 8, 2017 at 3:03, subject matter Ray McCollum. And he says, can you revise to, and then it looks like a report.
Yes, it does look like that.
So was Mr. Megaro revising your report or requesting you to revise your report?
Attorneys always request me to revise my reports. If I don't agree with, generally the reason I send a draft is to make sure I haven't made any gross errors. And if I have, the attorney will find them and point them out to me. I don't make any revisions that I don't agree to.
And do you know what, if any revisions you made to this report?
No, I don't.
If you'll scroll, we'll scroll up to another email from you to Mr. Megaro at 4:08 p.m. What did you tell him, if you would read that email?
I can make all the changes except one minor one describing the subject's cleanliness and grooming as a standard part of a psych eval, even for competency. Do you want a digital and a hard copy or just a hard copy?
So we don't know what he added to it, but you did accept some of his recommendations for edits or changes to it.
It looks like it, yes.
All right, then there's a reply email from Mr. Megaro on March 8 at 4:10 p.m. What does it tell you? If you'd read the email, please.
Okay, let's keep that clause in. Digital copy should be sufficient for now.
Now, do you know if your report was submitted to anybody or Mr. Megaro did anything with it?
I assume it was submitted, but I don't know for sure at this point.
Okay. Do you know, let me refer your attention to let me refer you to Exhibit 651. Should be on your screen. You see the first page of that exhibit. Appears to be a hearing before Judge Boyle on motion hearing on May 5 of 2017. Have you ever seen that transcript before?
I probably, yes, I have. I think I responded to it. Well, wait a minute. I don't know if I've seen that or not.
Okay. Let me refer to you, page 18 of the transcript. All right, at line 8, the court is stating, I'll read it for the record, the court, there are a number of threshold problems with going forward. I've looked at Harbin and Associates report. I don't find that to be persuasive. This hearing took place on May 5 of 2017. Do you know if your report to Mr. Megaro of March 8, 2017 is the report that the court's talking about?
Probably, yes.
Let me refer you to State Bar Exhibit 160.
116,
160, excuse me.
thank you.
From the front page of the exhibit, do you see that there was a hearing on August 10 of 2017, and this is a transcript from that proceeding?
I see it, yes.
Did you, if you will go over to the next page, you see that you actually did testify at that hearing?
Yes.
And let's go to your go to page 15. Well, you can see from the transcript that your testimony begins at page 15. And I'll refer you over to page 24. Now, this is direct examination. Do you recall who called you as a witness?
I assume Mr. Megaro.
And would you begin on the transcript at line 4 and just read for the record?
Question, can you tell the court what that opinion was? Answer, I believe that he was at the time I evaluated him competent to knowledgeably accept or reject a settlement offer. Question, did you have any concerns that Mr. McCollum was incompetent and that he would not be able to take care of himself and make important life decisions, health choices, anything like that? Answer, the only concern that I had was his immediate prior history of blowing money. But he and I had a pretty long discussion about that, and he put most of my doubts at rest.
So what did you know about Mr. McCollum's history of blowing money?
Well, I don't remember specifically what I knew at the time, but I assume I knew that he had gone through a lot of money with vacations, buying cars, buying ATMs, buying TV, or not buying ATMs, buying TVs, the stuff that's been presented here this morning.
And that was some concern to you, was it, sir?
Initially, yes.
But you talked with him and he satisfied you that put your doubts to rest, I believe you said.
Mostly, yes.
Okay. And Mr. McCollum also testified at that hearing in front of Judge Boyle.
Yes.
Okay, so you were there and you heard his testimony?
I believe I heard his testimony, yes.
Now, let me refer you to State Bar Exhibit 151. Excuse me, 157. Do you recall getting this email on Thursday, July 27, 2017 from Mr. Megaro to you?
No.
And this would have been prior to your testimony in August of 2017. If you would, for the record, read the email that Mr. Megaro sent to you.
The case has turned into a wreck. The guardian appointed for Henry just filed a motion to have the court fire me based on his single 45-minute meeting with Henry and the history of low IQ. In his expert opinion, Henry is incompetent and was incompetent to sign the retainer agreement to hire me as his lawyer and to agree to any settlement. Take a look at this motion. I'm constantly being personally attacked in this case. I now have to defend myself against some very serious allegations of misconduct and have to go to court on August 9th. Would you be able to come give your opinion? I'm speaking to Savannah Pittman this afternoon about the evaluation, but everything looked good to me. I plan to file her petition shortly.
All right. Let me refer you to State Bar Exhibit 654. You recognize an email here from Mr. Megaro to your office, August 12 of 2017.
I see it was to me. I don't recognize it.
Yeah. Did you recommend Dr. Corvin as a potential forensic psychologist to assist in this case?
I don't remember specifically, but I heard testimony somewhere this morning that I recommended both Dr. Ballard and Dr. Corbin.
And you don't have any reason to dispute that?
No,
Okay. Let me refer you to exhibit. Well, did Dr. Corbin actually do a forensic evaluation of Mr. McCollum?
he did a forensic psychiatric evaluation.
Okay. And did you have any discussions with Mr. Megaro before that evaluation took place?
I don't remember.
Let me refer you to State Bar Exhibit 158. Start down at the bottom of the first page. It appears to be an email from you to Mr. Megaro regarding Mr. McCollum, August 4 of August 14 of 2017. What, if anything, did you read the email, would you, at this time?
Dr. Harbin, in doing that, let me just advise you, sir, that the court, for the benefit of the court reporter, would you just read it a little bit slower than you've read in the past? She's, if it were me, I'd be struggling to keep up with you.
Be happy to. Patrick, I don't mean to tell you your business, and you may have already thought of this, but I would recommend that you have some rehearsal with Henry and make sure he knows where his bank accounts are, how much is in them, how to write a check, what his income and bills are, etc.
Why did you send him that email?
I have done a lot of treatment in my career of PTSD patients. And one of the things that I know about anxiety, particularly PTSD anxiety, is that it can lead people to be confused at the time, especially in a high stress environment. And I wanted to make sure that Henry displayed himself the way that I knew his abilities to be.
And who is he getting ready to be interviewed by?
Anybody in court.
Wasn't it going to be Dr. Corbin?
I wasn't thinking specifically of Dr. Corbin. I was thinking more of cross-examinations by attorneys.
Well, this was right after you had testified on August 10 of 2017. And the judge had, Dr. Corbin had been appointed. Isn't it true that you were trying to tell Mr. Megaro that he needed to get with his client and go over his stuff with his client so his client would look competent during the evaluation?
It was my intent that his responses not be clouded by anxiety.
And what did he respond to you? If you'll, up at the top.
Point well taken. Thank you.
Let me refer you to State Bar Exhibit 144. Down at the bottom, there's an email from you to Mr. Megaro, July 25th, 2016. Would you read that in for the record?
Dear Mr. Megaro, here are drafts of the reports. They are still undergoing internal review, so please don't distribute these. Let me know if there are any errors of fact or anything else that you want to discuss.
And this would have been your first report in July of 2016, correct?
Yes.
Then there's another email dated, next one up from Mr. Megaro to you, dated November 20 of 2016, asking you to take a look at a report. We read that into the record.
Can you take a look at this report? It seems the defense has hired an expert to say, so what, when it comes to damages? Do you know this person by chance? Interestingly, the defense is also taking the position that both clients were not mentally retarded at the time they confessed to the police. One, and two, that the confessions were entirely voluntary, and three, they were actually guilty, not innocent, despite what every court, prosecutor, and the governor have said. Please get back to me with your thoughts.
And did you get back to Mr. Megaro with your thoughts? If we'll scroll up to the next email of November 21, 2016. Would you read it in record what you responded?
Dear Mr. Megaro, number one, I do know Dr. Gamble. She tends not to be plaintiff friendly. For example, she finds a higher percentage of malingering in her evaluations than anyone I know. One does not develop mental retardation in adulthood. If they are retarded now, they were retarded at the time of the confessions. Three, you know more about this than I do, but does it matter that the defense believes that they were guilty since they have been exonerated?
So what did you mean by if they were retarded then, they're retarded now?
I'm not sure what you're asking me. It seems pretty self-explanatory.
Well, I thought you made a distinction earlier about mental retardation then versus a new IDD. And this email is in 2016. So if you could explain what you meant when you said one does not develop mental retardation in adulthood. If they were retarded now, they were retarded at the time of their confessions. Are you saying that the brothers were in fact retarded at the time of their confessions?
I'm saying that if they were determined to be, if they were retarded, not determined to be, but if they were retarded as children or adolescents, then that is not something that changes into adulthood.
You later sent another email to Mr. Megaro at 1:24 p.m. Would you read that email into the record?
Mr. Megaro, I'm not sure that there is anything to refute in Dr. Gamble's report. She is essentially saying that one, they were retarded at the time of their crime, which is true, and two, that their current symptoms could be due to the effects of their intellectual disabilities, also true. But the fact that the retardation is associated with many psychological disorders doesn't mean that retardation caused them. Correlation does not imply causation. Whereas we have lots of research to indicate that trauma, including prison-related trauma, does cause later psychological pathology, especially PTSD.
So what you say, she's essentially saying they were retarded at the time of the crime, which is true. Were you agreeing that they were retarded at the time of the crime?
According to their test results, yes.
And their current symptoms, and that their current symptoms could be due to the effects of their intellectual disabilities, also true.
Without looking at Dr. Gamble's report, I wouldn't know what symptoms were being referred to, but that is what I wrote, yes.
Now, in your latter report, at State Bar Exhibit 658, You recognize this is your report dated September 18 of 2017?
Yes.
And let me scroll down. And this was written by you for what purpose?
To determine whether or not he had the ability to manage his affairs.
So at the first line of your report, at your request, I reviewed the report of forensic psychiatrist evaluation of the forensic psychiatric evaluation of Mr. McCollum conducted by George P. Corbin, MD, and dated 9 September 2017, and listened to the audio recording of Dr. Corbin's interview with Mr. McCollum. And then you go on down and you try and point out there are several issues that weaken the foundation of his opinion and Mr. McCollum's competence. What was the first area that you criticized about Dr. Dr. Corbin's report?
Can you point me to something that you're looking
Paragraph 1.
In that paragraph, I am rendering an opinion about the association between IQ scores and determination of incompetence.
And this is some way to call into question the validity of the IQ scores, correct?
Not to call into question the validity of the score, but to provide a more detailed account of how they should be interpreted.
Okay, and what was that more detailed account? That there was a range?
That there's a range, and I didn't state this, but implied that 70 is kind of an arbitrary cutoff.
All right, so when you say there's a range of scores, could you explain that?
The standard deviation on the waist test is 15 points. And so, in a bell curve, 68% of people who score at 70, their true score can be anywhere from 56 to 70 or from 70 to 85 by random error.
Okay. And so by your reasoning that similarly, his range of score could be from 56 to 41.
Yes.
Do you really think,
But,
Mr.?
based upon the previous tested scores,
So it's possible that Mr. McCollum was a 41 IQ.
it's possible that he would have scored a 41 on the test that I don't know what the full scale IQ score was found, while the 56 could go down as low as 41.
And then the upper range from a 69 could go to an 84.
Correct.
Do you really think Mr. McCollum could score an 84 on an IQ test?
Any IQ score is a function of the theoretical true score and that variance around that true score. And if he happened to have a good day, if he happened to, I don't know, if he happened to make mistakes in the right direction, he could theoretically get a score of 84.
One moment, please. Mr. Chair, we have plaintiff's exhibit 800. We don't have it digitally. We would like to.
This is, first, let's tell me, is this an exhibit that's been exchanged as part of the stipulation, or what is this that we're looking at?
No, it's not.
It's an email that we received today.
It was this the email you talked about before lunch?
It's one of the 17 we received today.
All right. Yes, you may approach. Thank you.
We haven't done 800 or 802 yet.
It's the only one. Yeah.
Mr. Dr. Harbin, we've handed up what's been marked as Plaintiff's Exhibit 801. Do you recognize what 801 is?
Yes,
What is it, sir?
it's an email from me to Mr. Williamson.
Okay. And I'd like you to direct you to, let me strike that one moment. Well, would you just read the email into the record for us, please?
Okay, Mr. Williamson, we should talk at some point before Wednesday. My competency eval of Mr. McCollum was fairly specific to the settlement with Red Springs. I knew virtually nothing about the loans until this all blew up. With regard to Dr. Corvin's report, there are some pretty cavalier statements, e.g., he presents no data to support his diagnosis of neurocognitive disorder. Similarly, he states that no evidence of malingering was observed, but there is a ton of research to suggest that professionals cannot distinguish true reports of symptoms from malingering by observation alone. He states that Mr. McCollum evidenced his intellectual disorder, but again does not state what that evidence was. Probably most disturbing was his statement that Mr. McCollum displayed evidence of impaired executive functioning without specifying what that evidence was. But we should be clear that I have no knowledge of Mr. McCollum's competence to engage Mr. Megaro or agree to the terms of the loans.
That's all my questions.
Whether we further direct Mr. Williamson?
Briefly, back to that exhibit. When you say you had no knowledge of Mr. McCollum's competence to engage Mr. Megaro or agree to the terms of the loan, did you have knowledge as to his competence to handle his financial affairs, including whatever transactions he had at that time?
At what time, sir?
When you did his evaluation?
Based upon my evaluation of him, I thought that he did have the competence to manage his financial affairs.
And you thought that that was true at that time? Correct?
Yes.
And you still think that's true?
I can only state as of my evaluation, but unless something dramatically has changed, then I still have that opinion.
Has there been anything that you've seen that would change your opinion?
No.
That's all.
Further across, Mr. Morris, questions? Mr. Bennett, you have a question?
Dr. Harbin, one of the tests you went through,
Mr. Bennett, pull the microphone closer to you if you would, sir, so we can hear you. Thank you.
let me get closer to it. Dr. Harbin, in one of the reports you gave indicated that Mr. The McCollum had verbal comprehension that was severely impaired. You remember that?
Yes, sir.
And then that says measure of verbal skills. Does that mean that he doesn't understand people when they're talking to him?
It means that his ability to do that is much lower than average. He can understand things, but below average.
So if Mr. Megaro was, had explained to him the fee agreement that he signed, would he be able to understand that?
Sir, that would depend upon what type of language was used, how complex the sentences were. I mean, I would have had to have viewed the agreement and listened to the explanation of that agreement in order to answer your question.
Says on this email that we should be clear that I, being you, have no knowledge of Mr. McCollum's competence, first of all, to engage Mr. Megaro. Are you talking about when he hired Mr. Megaro?
Yes, sir.
You just don't know anything about that?
That's right. Like I said, I was not involved in the case at that point, and I would have to see the engagement agreement as well as have witnessed whatever explanation there was in order to answer your question.
Do you know what Mr. McCollum's ability to read is
Not good.
at a fairly low level?
I'm sorry, sir.
At a fairly low level.
I believe that his verbal, well, I can check something if you like.
Okay.
His verbal comprehension index on the intelligence test that I gave him was severely impaired, which would mean, hold on, I can give you a percentage on that. Which would mean that he was at the 2nd or 3rd percentile.
So would that mean he would have difficulty understanding a fairly complex contract?
Without some good explanation, yes, sir.
Okay. And you also indicate that you have no knowledge of Mr. McCollum's competence to agree to the terms of the loans. Is that correct?
That's right. I didn't know the specifics of the loan. And again, I didn't hear the explanation or description of what he was entering into.
Thank you, sir.
Dr. Harbin, one of the questions I had earlier for Dr. Millard was, can the retesting on IQ, is there data to support whether or not that impacts the actual score? I asked that question because it appears over time his scores got better on his IQ exam. And I'm just wondering whether retesting of the IQ exam, is there any bump up that you expect with multiple retests?
That depends on the time between the tests. You know, some of the items could be remembered and therefore improve his score second time around. But there were different tests used. The tests developed over the time that he was in prison, so they weren't all those scores from the same test. There was the WACE, and then the WACE-R, and then the WACE-4, and I think one time he was tested with the Stanford Binet. So I don't think that is more likely. What I think is more likely is there's a phenomenon known as the Flynn effect, which is the norms change over time. And so your conclusions based upon those norms also change.
All right, thank you. Mr. Williamson, as a result of any questions the panel's asked, do you have any additional questions?
No, sir.
How about the State Bar?
No.
May Mr. Harbin be excused from a subpoena?
Yeah.
Yes.
All right, thank you, Dr. Harbin. You may step down, but you first have the duty of wiping down your chair and everything you've touched.
Yes, sir.
Thank you.
Mr. Chair, while he is wiping that down, may we make a motion to admit into evidence
Hold your ears.
plaintiff's exhibit 801, one of the email streams we received today?
I think, Mr. Walthall, that would probably be made at the end of the defense unless Mr. Williamson objects,
I don't.
then it'll be received. Will there be further evidence for the defense?
Yes, sir, Mr. DeVore. I have at least one witness that I think can be complete today, perhaps two, but it'll be a little bit out of the sequence I told them. I had said Mr. Halscott to go tomorrow, but I have Joe Easton, Bishop Armenteros available. I intend to call Joe Easton.
Let's proceed.
All right, defense will call Joe Easton.
Mr. Easton, if you would, sir, stand up and place your left hand on the Bible and raise your right hand, face the clerk right down here. You solemnly swear the testimony you're about to present to be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. Have a seat, sir.
But should I remove the mask?
Yes, you may.
Mr. Easton, what is your full name and residence address?
Joseph Easton, last name spelled Easton. My address is 9655 Cypress Pine Street in Orlando, Florida, 32827.
And what is your occupation?
I'm an attorney.
And what firm are you with?
I currently practice with Leopard Law in Orlando.
Were you at one time employed by the Halscott Megaro firm?
I was.
What was the time of your employment with that firm?
It was around June of 2016 to, I think it was November of 2017.
What were your general duties with that firm during your tenure?
It was predominantly research and writing, I would say, for the most part.
Were you regarded in law firm parlance as an associate or some other position?
I don't know that I was categorized as anything, but I guess you could say associate.
In any event, you were not one of the partners.
That's correct.
And while you were there, did you have occasion to observe the partners were working on matters involving Mr. McCollum and Leon Brown?
Yes.
And during that time, could you describe, well, first of all, when you arrived at the firm, was that after the pardon had been granted?
I believe so, yes.
So what matters involving Mr. McCollum and Brown were ongoing with the firm during the time you were there?
I mean, I don't think I could specifically even say. I know that at one point in time, there was a motion for summary judgment took place while I was there.
Now you're talking about a civil lawsuit.
Yes.
Well, just what do you know about that lawsuit in general?
I mean, as far as the facts go, I didn't really work on it. I worked on bits and pieces here and there, but it was not my primary area where I was focusing my time.
Well, what I want to ask you about that is number one, were you able to observe in general how much of their time was spent working on that matter? That is Mr. Megaro and Mr. Halscott.
Mr. Megaro all the time. I would say, I wouldn't say daily, but I mean, it was close to that.
What about for Mr. Housecott?
Most of my interactions were predominantly with Mr. Megaro. I know Mr. Helscott probably did some work, but I'm not exactly sure.
Were there occasions where you were asked to take care of matters not involving Mr. McCollum and Brown that Mr. Megaro ordinarily would have handled, but for his working on that matter?
Yeah, so Mr. Megaro would, he'd get very consumed with it. And so I was asked on a number of occasions to just make sure that the office and everyone was running, doing their work, doing things that they should be doing while he was working on that case.
Do you recall specifically a time when people were working on matters involving summary judgment in that case?
Yes.
What do you recall about that time and what was going on in the office?
Well, it was rather, my recollection is it was a rather extensive brief. And I recall Mr. Megaro basically saying, this is all hands on deck. Everyone needs to focus their energy on this issue and put everything else on hold. And myself and everyone else basically devoted time to proofreading and just kind of going over it in general.
And how long, if you recall, did that process last?
I almost want to say more than a day, but I can't really recall.
Now, did you yourself meet Mr. McCollum?
I did.
What was the occasion for that?
Mr. Megaro and I came up to Robeson County. He was doing some investigative work on the case and asked me to come along with him. And while we were doing interviews with individuals, we ended up meeting with Mr. McCollum.
What do you recall about that? Was that one meeting that you were involved in?
We spent, I think we may have spent 2 nights, but we ended up meeting with, after we had gone out during the day, we ended up meeting with Mr. McCollum. I believe we met at a hotel, met with him, went to dinner with him. And I think it was the first night then we went to a relative's house and met with them and hung out with them for a bit. And then I recall, I think the next morning we met with Mr. McCollum again.
You mentioned the relative's house. Do you recall at all who that relative was?
I don't.
Do you have any impression of whether that was where Mr. McCollum was living or not?
I don't think so, but it could be.
Based upon your limited interaction with Mr. McCollum, what were your impressions about him, just from your personal observation?
Well, I mean, to put it in the context of what you all are talking about, I had no reason to believe that he was incompetent when speaking with him. We had conversation. Patrick talked to him mostly. I think he probably updated him about things that were going on, but I didn't have any issues communicating with him in any way. It was, somewhat, I guess, for lack of a better term, normal.
Now, at some point, you did leave the Housecott Megaro firm.
That's correct.
And that was that to join the firm you're with now?
That's correct.
And did you leave on good terms with the Housecott Megaro?
I did. Yeah. It was mainly, I'd done litigation before where I was in court all the time, and I sort of just kind of hopped back into doing that.
And you don't currently have any sort of financial arrangements with that firm other than, well, did they agree to pay your actual expenses?
Helscott Megaro?
Yes.
They bought my flight.
Okay.
I have no other financial interest, if that's what you're asking.
Put it in southern terms, you don't really have a dog in this fight, other than what you talked about.
No, I do not.
All right, that's all.
Cross-examination.
Just briefly, Mr. Chair, Mr. Easton, am I pronouncing that correctly?
Yeah, that's correct.
You were not employed at Scott Megaro during the pardon process or the industrial commission matter. Is that right?
Correct.
Okay. What was your salary while you were employed at Scott Megaro?
It was, I think it was 70,000.
Annually?
Yes.
Okay. Was there any bonus structure
No.
beyond that? Okay. Would you categorize yourself as friends with Mr. Megaro?
I'd like to say we're friends. Yeah.
Okay. Do you have a cell phone?
I do have a cell phone.
Do you text?
I don't think you can receive text messages. You're saying, do I text with Mr. Megaro?
Right. Yeah.
I don't think he can receive text messages.
Have you emailed with him about this matter?
He emailed me an itinerary. I don't think he's emailed me anything else
When was that? When was that itinerary emailed?
recently. Where it was just the flight information.
Okay. Did you discuss your testimony here today?
Just I guess the topic, like that I was just going to mention that I had met Henry. And, I mean, I was going to mention what a great lawyer Patrick is, but I wasn't asked. So.
Okay. Did you work on the McCollum and Brown matter while you were at Scott Megaro?
Not really. No.
Okay. So when you said all hands on deck, that didn't refer to you?
Well, what I said was we all proofread it. So I guess you're asking, did I work on it? I did that. I don't recall doing anything else.
Okay. Are you licensed in North Carolina?
I'm not.
Did you get Pro Hoc Vici admission?
No, I was working under his supervision when we did it.
Okay. Are you familiar with the provision in the North Carolina Rules of Professional Conduct that allows a lawyer not licensed in North Carolina to practice here under someone else's supervision?
Am I familiar with the rule?
Are you familiar with any rule that allows a lawyer not licensed here to work in North Carolina, provide legal services as long as they're under someone else's supervision?
Yes.
There is such a rule?
If they're under someone else's supervision, yeah.
There is. Where is that rule?
Honestly, I don't remember.
Okay, but you
Like
believe there
where?
is one?
Yeah.
Okay. No further questions.
Any redirect?
No, sir.
Mr. Easton, you may step down, sir. Thank you very
Thank you.
much. Please wipe down the table and the chair where you
Sure.
are before leaving. Will there be further evidence for the defense?
Yes, the defense would call Patricia Armenteros. Benefit of the court reporter, that's ARM. Oh, you have it.
Ms. Armenteros, would you please place your left hand on the Bible and raise your right hand, face the clerk? You solemnly swear the testimony you're about to give to be the truth, the whole truth, and nothing but truth. Say after God.
I do.
All right, ma'am. Thank you. Please have a seat.
Ms. Armenteros, would you say your full name and residence address?
Patricia Armenteros, that's ARMENTEROS, and the address is 844 Grand Regency Point, Unit 103, Altamont Springs, Florida, 32714.
And where are you currently employed?
Michael T. Gibson, PA.
Is that a law firm?
Yes,
What is your position with that firm?
I'm a litigation assistant.
Is that another word that we might say is paralegal?
It is, yes.
So you are, fair to say you're not a licensed attorney.
No,
And when did you go to work for that firm?
2017, October 2nd, 2017.
And prior to that time, were you employed by Hal Scott Megaro?
I was.
What were the dates approximately of your employment at that
January 2015 to September 2017.
What were your general duties with Hal Scott Megaro?
Just phones, filing, taking care of the attorney's calendars, dealing with the customer service with the clients, communication between them and the attorneys.
Now, did you leave Hal Scott Megaro on good terms with him?
I did.
Why did you leave?
It was just one of those things, just time to move on.
Do a better job.
Yeah. Something a little less stressful.
Could you describe a little bit, I'm talking about the actual physical setup of the office when you were there.
I'm sorry, can you repeat that again?
Could you describe the physical setup of the layout of the office there? And what I'm particularly interested in was where you were, whether you could hear Mr. Megaro and observe him.
My office was actually right next to his, so I could hear a lot of the conversations if they had their doors open, but I would not be able to physically see him.
Now, in relation to your office, where was the conference room?
Oh, directly across from my seat.
Could you see into the conference?
Yes.
Now, when you were there, were you aware of Mr. Megaro working on this McCollum and Brown matter?
Yes, I was.
Were you there at a time when there was work being done on the pardon petition?
Yes.
And did you have an opportunity to observe what appeared to be the amount of time and activity that Mr. Megaro was devoting to that particular matter?
Yes.
And could you tell us what you observed about Mr. Megaro doing at that time regarding particularly the pardon petition?
We had actually received, I would say, almost a room size of boxes with documents about the pardon and everything about the case. So I saw him a lot in the conference room, just reviewing and going through those boxes.
When you saw him a lot, could you try to quantify as best you can over what period of time you observed Mr. Megaro in his review of that material?
I would say almost daily.
Almost daily for how long? Weeks, months?
Oh, I would say probably weeks to almost months, but I would say months.
Talk about the physical condition of the file now. Do you recall what the condition of the file was? Was it paper? Was it?
Yeah, it was paper.
organized or what?
It was all paper and very disorganized. So it took a lot of work to go through it and organize it. And
did you help organize it and digitize it?
yes,
And what all did that entail for you doing?
we try to organize it as best as we could and actually scanning the documents into our system into PDFs.
Can you estimate how much time you personally spent on that project?
Hours, I couldn't specify, no.
Were you there working for House Scott Megaro when the pardon was actually granted?
Yes.
Now, after the pardon was actually granted, were you there when the civil suit was filed?
Yes.
And did you have the opportunity to observe how much time Mr. Megaro was devoting to that?
Yes.
And could you describe what you observed in that regard?
Just a lot of research from his part and writing.
Was there additional review of documentation?
Yeah, I'm sure there was.
And was that, when you left, was that still ongoing, or had Mr. Megaro been removed from that case by that time?
I don't recall exactly.
Switch gears. If you could, where was the file on the McCollum and Brown matter stored?
An office right next to the conference room.
How can you estimate how big that file was and how it was stored?
We had it in boxes. I would say more than 15 to 20 boxes were in there.
Did you personally have any interaction with a client of the firm named Grace Humphrey?
I did.
What do you recall about your personal interaction with Mrs. Humphrey?
Just communication when she called about either her case or asking questions. So speak to Mr. Megaro maybe too.
Do you recall yourself having any discussions with her about obtaining a transcript of proceedings?
We discussed in reference to obtaining the trial proceeding for her case.
What specifically do you recall about those discussions? Thank you.
We just talked about us needing to obtain those transcripts so we can go ahead and get a court reporter or somebody, retain somebody to be able to transcribe those hearings so we can go ahead and include them in the record on appeal.
What did Ms. Humphrey say to you about doing that?
We spoke about the cost of the court reporter that we would use, that we would normally use. And she thought it was way too expensive. She gave me she told me that she was going to try to find somebody else to do it at a cheaper rate, which I also, discussed with her that it would be best to discuss that with Mr. Megaro.
Now, testified earlier that your office was right next to Mr. Megaro.
Correct.
And that you could overhear from time to time him say on the phone or what was going on.
Uh-huh.
You recall overhearing any conversations between Mr. Megaro and Ms. Humphrey?
Yes.
What do you recall about what you heard?
What's the basis for the objection? Well, Mr. Megaro's here. She can't testify to what was heard on the phone from Ms. Humphrey, but she can testify, I think, to what she overheard Mr. Megaro say.
With that limitation, what do you recall hearing Mr. Megaro say to Ms. Humphrey?
Mr. Megaro actually advised her against hiring a new court or a different court reporter, because the court reporters that we would hire would actually know what needed to be done. And so he advised her against her more than once.
You recall him saying anything about the necessity for doing this in a timely manner?
Yes.
What do you recall about that?
He just said that we had a deadline to meet in reference to the transcript. And so we needed to get it done, correctly and quick.
Do you know of your personal knowledge after you, do you know what Ms. Humphrey did in terms of getting a transcript?
In specifics, I'm not sure what you're asking. Sorry.
Well, let me put it more simply. Did Ms. Humphrey follow the suggestion to use the court reporter that you all had recommended?
No, she decided to still go on her own and find a court reporter. From my understanding, if I recall correctly, it was a retired court reporter that she decided to hire.
Do you recall anything else about that?
No,
All right. Now you were here as House Ms. Megaro agreed to pay some expenses for you to attend.
no, he'd only paid for flight.
Well, that's an expense.
Yeah.
Okay, paid for your flight.
Yes, he paid for flight.
No questions.
Will there be cross-examination by the state?
Real quick, Miss is it Armentaro?
Armenteros.
My name is Pat Murphy. I represent the North Carolina State Bar. You were employed, I take it, from January 2015 through September of 2017?
Mhm.
Okay.
Just a minute, Mr. Murphy. All right. Happens to all of us at one point or another. It's just a matter of time.
It happened to me first day.
Sorry, go ahead, Mr. Murphy.
Thank you. And as I understand it, you guys, while you were working with Mr. Megaro, you got a lot of boxes in regarding the case of Mr. McCollum and Mr. Brown.
Correct.
And they were disorganized and
Correct.
took a lot of time to go through those and get them organized.
Correct.
Do you know where those boxes came from?
I don't recall. No,
Was it the Center for Death Penalty litigation in North Carolina?
I don't recall.
Did you keep time records as to how much time you spent on doing that work?
No, I did not. No.
Okay. And do you know if Mr. Megaro kept time records on how much time he had in the case?
I don't know if he did.
And you don't know how much time he spent on the pardon petition, do you?
Not specifically. I couldn't give you exact time if you're looking for exactly.
It could have been a short amount of time. It could have been a long amount of time. You just don't know.
And no, I don't recall the exact time. I knew it was a significant amount of time.
And I'm just speaking about the pardon petition.
Yes.
Okay.
Mhm.
Miss Grace Humphrey was a client of the firm while you were there.
Yes.
And were you here earlier this week when she testified?
I was not.
Has anyone told you anything about what she testified to?
No.
Do you know what kind of case Mr. Megaro was handling for her?
All I recall was being a family matter.
A family matter, and it was an appeal?
And it was an appeal, yes.
And do you know whether Mr. Megaro missed some filing deadlines with respect to that case?
Not that I recall.
Do you know if there was a time when there was a hearing in Alamance County, North Carolina, on a motion to dismiss Ms. Humphrey's appeal, and Mr. Megaro didn't show up for that hearing?
I don't recall the hearing. No, I don't.
Okay. And you don't know anything about him having missed it, why he missed that hearing?
No, I don't recall.
Okay. So it wasn't, okay. Do you know that there was a subsequent hearing where he told the court that he had violated 2 of the rules of appellate procedure in her case?
I don't recall, no.
Was it the lawyer? Did you understand it was it was the lawyer's role in that case to make sure the filing deadlines were met?
Yes,
And it's not the client's duty, is it? It's the lawyer's duty.
yes.
Do you know how much Miss Humphreys paid Mr. Megaro to handle her case?
No.
All right. Thank you. That's all the questions I have.
Nothing further.
Mr. Morris? Mr. Bennett? Thank you, Ms. Armenteros. You may step down and you are excused once you wipe down the, you're way ahead of me, once you wipe down the table. Will be further evidence for the defense.
Yes, we would call Jamie Housecott.
Mr. Housecott, come around, sir. Mr. Housecott, please place your left hand on the Bible, raise your right hand, face the clerk. You solemnly swear the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, so please take a seat.
Mr. Housecott, would you tell the panel your full name and residence address?
Yes, it is Jamie Hallscott. It's my residence,
Yes.
904 Fairway Drive, Winter Park, Florida, 32792.
And what is your profession?
I'm an attorney.
Are you a law partner to Mr. Megaro?
I am.
Tell us something about your educational and professional background.
I started my life out as an electrical and computer engineer. I studied undergrad at the University of Central Florida. I went on to study law at the Barry University School of Law, where I graduated in 2012. I have practiced as an engineer as well as an attorney.
And when did you form any kind of professional relationship with Mr. Megaro?
Our firm came together in early 2014.
And how did that come about that you and Mr. Megaro formed?
Mr. Megaro and I had worked together at my previous law firm. I was a partner in a law firm called Brownstone, PA. I met Mr. Megaro there shortly after I partnered in. We worked on some cases together. We had a professional working relationship. He would have been the senior associate attorney. When I left that firm, it was kind of an arranged marriage, for lack of a better term. Folks said that we got along well, that we worked well together, and we should form our own firm. So we did.
What sort of work does that firm do?
The original one, Brownstone?
No, Housecott Megaro.
Yes, sir. Hallscott Megaro primarily does appellate litigation, as well as civil rights actions, executive clemencies, things like commutations of sentences, pardons, expungements, sealings, anything that handled from a post-conviction on, including civil rights litigation.
And you personally are licensed in what state?
I'm licensed in the state of Florida, Minnesota, as well as the District of Columbia.
Are you aware of where Mr. Megaro is like?
To my knowledge, Mr. Megaro is licensed in the state of Florida, North Carolina, Texas, Washington State, New York, and New Jersey.
Would you describe for us generally, what work the firm has done relating to such matters as pardons and commutation.
Certainly. The law firm of Hall Scott Megaro handling all aspects of post-conviction appeals and executive remedies. Naturally, when it comes to things like pardons, that's kind of the ultimate end for a criminal case. So in our experience, we've had several different pardons and commutations granted, not the least of which was in the Brown and McCollum case. We've also had a pardon granted that Mr. Megaro and I worked on directly with Governor Hickenlooper's office in the state of Colorado. And most recently, Mr. Megaro's success with a commutation of sentence from President Trump for a gentleman by the name of Corvain Cooper.
The Colorado pardon, was that prior to the McCollum and Brown matter?
It was subsequent to the Brown and McCollum matter.
Now, in addition to Mr. Megaro work on the McCollum and Brown matter,
I did.
how did you get involved in that?
Mr. Megaro and I, we've shared an office facing each other for 7 years at this point.
When you say that, just to be clear, you're talking physically, you occupied the same office space.
That is correct. It was a long running joke that we, as partners, didn't have our own offices, that we would face each other because we were highly collaborative on the cases that came into the firm. Associate attorneys would have separate offices, but we found it critical to our working relationship that the two of us would face each other and always be bouncing ideas off of each other.
Go ahead. How did you get involved with the McCollum and Brown matter?
With the McCollum and Brown matter, I had traveled to New York with Mr. Megaro, where he, Mr. Brett Schneider, Attorney Scott Brett Schneider, and myself were initially introduced to Kim Weeks and Deborah Pointer, and where I first became familiar with the initial details of Henry McCollum and Leon Brown's plight.
Now, at that point, you did not actually meet with Mr. McCollum and Brown at that point.
No, sir.
What was your understanding of the role of Ms. Weeks and Pointer at that point?
They seemed almost like family friends or acquaintances, perhaps, kind of advocate types that seemed to want to do something to help the plight. I would consider them maybe advocates or some kind of, say, social justice warriors, for lack of a better term.
And what was discussed at that meeting?
Initial details of what the case have happened in it so far, primarily from the point of view of Ms. Weeks and Ms. Pointer. They had brought it to our attention that these gentlemen had been on death row. They had been wrongfully convicted. They were just released from prison, that they were living in terrible conditions. Squalor was the word that I recall. Their water had been shut off multiple times. It sounded like the system had forgotten about them once they had been released. They were advocating that nothing had happened in this case so far, or their case since they had been released, and that the family, including Leon and Henry, were desperately seeking some kind of help to get their case moving forward.
What, if anything, happened as a result of that meeting? In other words, what happened?
Next, I believe that Mr. Megaro and Mr. Brett Schneider had met with the family. They were primarily spearheading that effort. This was Mr. Megaro's case because Ms. Weeks and Ms. Pointer knew about Mr. Megaro from his experience in civil rights litigation, as well as criminal law and criminal defense in New York, but also wanting to have someone who was a North Carolina admitted attorney to be able to visit with the family, be able to bring an outside experience. They had indicated that no one really trusted anyone in North Carolina, primarily again because of the false confessions, the 31 years in prison. It was very difficult for them to trust anyone, so they wanted an outsider.
Now, talking about you personally, what was your next involvement with the case?
My involvement with the case was sporadically throughout the case, primarily supporting Mr. Megaro in anything that he needed to accomplish his goals. He had prepared an entire strategy to move forward with the case. One of Patrick's skill sets in particular is his ability to take very large volumes of material and digest that and then formulate strategies. So I was supporting his role as in that. He had been taking the lead, so to speak, again, as the North Carolina licensed attorney to find out what was really happening in this case, test the veracity of what we had been told. And through his research, I was supporting him in that effort.
That involved your just taking over or other matters that Mr. Megaro didn't have the time to handle the otherwise would because of his commitment on the column and Brown.
Well, certainly this was a magnum opus of a case, right? When Mr. Megaro buries himself in a case, he's going to devote everything to it. So here, as the managing partner and the one who handles firm operations, I had to ensure the smooth operations of the firm so that he could devote the lion's share of his resources to the Brown and McCollum case, particularly early on. One of the biggest concerns that came to light was that nothing had happened for this family since they had been, since Leon and Henry had been released from prison. Again, living in squalor, essentially, a house that wasn't very nice, having resources turned off. They had let us know that Ken Rose had, Attorney Ken Rose had gotten a fund developed to get money for them to support them, but they hadn't seen any of that money.
Let me interrupt you. Did you know that there was a pending petition for pardon that Mr. Rose had filed?
We learned about that, yes. I learned about that.
Go on.
But nothing had really happened from the time that we had started discussing this. They had already been into it about 6 months since they were released from prison. And there was talk of a pardon, but nothing was really actually happening. There was no movement that we could see. There was a lot of there's been a pardon or an application filed, but there has been no effort to push that along. In my work handling pardons, they require either a tremendous amount of political pressure or they require some sort of issue that is so large that the governor or the president simply can't ignore that.
At this point, we are still talking about the pending request for a pardon, but of course, no lawsuit had been filed at this point.
No lawsuit, no civil lawsuit had been filed at this point.
And you mentioned that in your experience, it was important to bring political pressure. Why do you say that?
Well, an elected official isn't going to stick their necks out for anybody. It's just not going to happen. In my experience, as jaded as it may be, a governor is not going to risk a re-election or risk burning political clout just to give pardons. They're going to need to be convinced that what they're doing is unassailable. So if there is actual innocence, they need to be convinced of that. They need to be shown that. If there's any conflicting information whatsoever, it's going to be very difficult to get a governor or the president to make a decision to commute a sentence or to grant a pardon. It's not a slam dunk. It is never a slam dunk when we deal with pardons. I'm the one, for instance, that I remember with Renee Lima Marin. It required tremendous coordination with the general counsel under Governor Hickenlooper's office in Colorado. And that was about as clean as it comes. In that case, we even managed to get 98 of the 100 senators on board with asking, or senators and representatives, excuse me, to ask the governor to take some action. And it still required tremendous follow-up with the governor's office to get that pardon granted. So I know that ideally an elected official should be able to look objectively at the information and make an informed decision. But as a politician, it's always difficult to get them to take that right action. And here, when we reviewed the file and we saw what had happened over 31 years, we knew that it wasn't as clean cut. It's never a slam dunk when dealing with a pardon.
Did you also have some experience in the state of Missouri that led you to form that belief of what might be necessary?
I certainly did. The case of Cornelius Michael Anderson III, or we call him Mike Anderson. Mike was convicted in that case of armed robbery as an accessory. He was sentenced to 13 years in the Missouri Department of Corrections. There was some clerical error that occurred somewhere in the system. He had been out during his appellate phase, during his post-conviction phase, and somewhere along the way, I believe someone died, a prosecutor died, someone in the prosecutor's office. This led him to being out on an appeal bond for the entire 13 years. When those 13 years were done, the Department of Corrections said, let's release Mr. Anderson, at which point they found they did not have him. And again, issued a warrant. The U.S. Marshals kicked down his door, ripped him away from his children. His wife was not at home at the time, and told them that you owe us 13 years now. In that case, we weren't really quite sure where we go to get relief, because according to the Department of Corrections, the work had already been done, but no one knew where to put him. In fact, Mr. Anderson spent several months at a place called the Fulton Transfer Station, where it's meant to hold you for 48 hours as you go to different places, but no one actually wanted to take custody of him because everyone was pointing fingers that it's not my job. So we immediately said, let's go to the governor's office, Governor Jay Nixon, because we need to do something here. There needs to be some avenue for relief that we simply aren't getting to because no one even wants to give us jurisdiction within which to file some kind of relief, whether that be a habeas petition, habeas corpus petition, or some kind of appeal. So we immediately jumped to that executive remedy and tried to spearhead a media campaign with Jessica Lussenhop of the Riverfront Times, with various different resources in order to get a campaign. Mr. Megaro created a change.org petition that we were able to garner tens of thousands until we were in the hundreds of thousands of signatures, at which point we were able to get media generated. We were able to get appearances on national news, including Fox News. And Mr. Megaro was able to bring that plight to a sufficient level that it was able to draw attention to that cause and get Governor Jay Nixon's office involved. In that case, it actually helped us to get the Attorney General's office for the state to take the action we wanted, and the pardon became superfluous at that point. But without that political pressure, we would have never been able to get where we were going. That was prior to the Brown and McCollum case, and enabled us to take those lessons learned to understand that nothing is certain. So we had to take all social media, all public media, anything that we could find to bring to bear to get the pardons that were going to be required in this case, based on the path that had been chosen by litigation prior to our involvement.
And was it based in part upon your experience with that Missouri case that helped you form the strategy to obtain the pardon from Governor McCrory in this case?
Oh, absolutely. That was the prototypical case within which we were able to form a holistic strategy, kind of a total war approach to getting what we wanted in that case. Knowing here that realistically the compensation in the future for Henry and Leon required us to get that pardon. It wasn't well, maybe we can do it, because if we didn't, there was no going back to the 3-judge panel with the Innocence Inquiry Commission. There was no option for that. Essentially, the options had been foreclosed to us. So we knew we had this one shot and only this one shot. We weren't going to leave it to chance. It wasn't something where we just wait and let it see. In order to accomplish that, we had to hire a temp specifically just to call different churches, different resources in order to get attendance at a rally that Mr. Megaro himself had planned. In coordination with the Change.org petition, in coordination with a rally in Raleigh, we had put a tremendous amount of resources and the whole firm to bear over hundreds, if not thousands of man hours at the end of it, in order to get what we were needing done. It was kind of a boiler room situation because nothing had happened for so long in this case, 6 months from time of release to the time that we were coming on board on the case, that the clients expected results. They didn't trust attorneys. They didn't trust anyone to do anything for them. These were not stupid people. They knew that money was being raised for them and they weren't seeing any of it. And they felt like now they were being victimized again.
I'm going to object to testifying about what other people felt who are not here to testify.
Sustained.
Did you follow through on that strategy?
We did.
And did that you amplify a little bit more on what was done with social media? Was there a petition and so forth?
In addition to the Change.org petition, which is nice to have, there has to be a distribution model for that. So it was purchasing ads on things like Facebook, targeted ads, things that we get to people who were either interested in criminal justice or were attorneys or were politicians, because you can target those. So we had quite an ad spend in order to get that out there, in order to bring attention to this Change.org petition and bring attention to our rally that we had planned. We were looking at everything, getting the permits, everything that was required to literally, with a wall of people, bring attention to the governor that this is what the people want. We need to get a pardon for these gentlemen. It is the right thing to do. After 31 years, show that the state of North Carolina can be redeemed. So it was taking those core components, building them, but at the same time spending money to promote them in the effort to get as many people as quickly as possible for a rally that was planned and was hard and fast in order to show the governor that we were serious about getting a pardon for them.
Do you recall how many signatures were obtained on the petition?
I don't. It was well into it was at least 100,000 plus. It could have been many more than that. There were a lot of signatures on that petition. If you checked the change.org petition, it may still be up. It might be something that's in your files, but the outpouring was tremendous.
You mentioned the rally. Did that rally actually take place?
The rally was planned and scheduled, but on the eve of the rally, essentially, not the day of, but it was a short time before. I know that Mr. Megaro had contact with the governor's office or someone associated with the governor's office that basically kind of put the brakes on this. Hold up. What are you doing here? We don't want this publicity. If you can agree to pull back on this rally, we can work more quickly to get you what you want. So there was, the governor's office recognized the sheer force of what was happening. There was a buzz on the internet about this.
Objection to stating what the governor's office knew.
Mr. It's sustained. Let's stay away from hearsay.
Okay. There was a tremendous outpouring, at which point the governor's office reached out I believe through a representative to Attorney Megaro, for the purposes of,
Objection. If that's something Mr. Megaro can testify to, but if Mr. Halscott was not on that phone call, it's still hearsay.
What information do you have of your own knowledge, Mr. Holdscott, regarding the conversations between the governor's officer and Mr. Megaro?
I was present in the same office as Mr. Megaro during untold numbers of phone calls. We literally faced each other for all this time.
All right, overruled.
So the governor's office reached out for those purposes. And we delayed it in order to allow Mr. Megaro to get Henry and Leon prepared and here for an initial meeting with officials from the governor's office, representatives.
And he can testify as to that. But to your knowledge, did that meeting take place?
It did.
And was the pardon actually granted?
The pardons were granted.
And what was the importance of getting the pardons granted, to moving towards additional remedies for Mr. Brown and McCullough?
The pardons were really the linchpin to getting them the statutory compensation from the Industrial Commission, but also importantly, helping further in the civil rights litigation. Even if the defendants in the case wanted to argue for some reason that Henry and Leon did in fact commit the crime, or they didn't have forced confessions, it would carry no weight. At this point, we have a determination through a pardon of actual innocence that they did not commit this crime. They had been exonerated, which was tremendously powerful to getting them something for all that time of suffering, some compensation for the wrong that had been done to them.
I want to change gears a little bit. I believe you testified as to the amount of time. Well, let me just ask you, did you personally observe what Mr. Megaro did in preparation for the meeting with the governor and the governor's representative?
I did.
And what did you observe him doing?
Oh my. Phone calls, coordinating printing of T-shirts, coordinating printing of flyers, himself calling organizations, in addition to our temp, himself calling organizations to get people there, spreading information through listservs, other attorneys, calling civil rights advocates, trying to get everyone from, Kim Kardashian to anyone who would listen, any kind of social rights activist on board with this, Jesse Jackson, anybody he could try and get a call into. It was literally a media blitz with Mr. Megaro driving the bus on that. It was almost a fever pitch for really weeks in order to get this done. It needed constant pressure and constant attention, and he devoted himself to that.
Well, in addition to that, did he spend time immersed into the record in their case that had been developed over years of litigation?
Yes. A little bit to my dismay, he hijacked my entire conference room. The way our office was set up, there was a conference room in the center with offices surrounding it. Our office was in the corner, and we shared the conference room, but he didn't have enough room. We had an entire room dedicated. We kicked some attorneys out of their office. It was an attorney and a paralegal, took them out of their office just so we could have one that was large enough to hold the volume of boxes in the case. He then took those boxes, put them in the conference room as he needed them, and immersed himself not to be disturbed until he could get through everything in the file. It's a superhuman feat. I would not have been able to do it, but he reads quickly and just buried himself in it. So I didn't have a conference room going on for, gosh, the better part of probably 8 weeks that I can recall.
And once the pardon was granted, what happened next?
To my knowledge, immediately after the pardon was granted, the Industrial Commission petition drafted and prepared by Mr. Megaro was submitted, and then he attended that hearing for the purposes of getting the statutory compensation, and at the same time, drafting and preparing the civil complaint in the 1983 Civil Rights Action.
And you recall in relation to the granting of the pardon, how long it took to get in the industrial commission petition and also to file the civil lawsuit in federal court?
Mr. Megaro is much better at multitasking than I am, but he was working on all of these simultaneously, preparing things ahead of time, getting them ready. It could have been several days. I don't recall the exact time frame, but I know he was always working on something to the point where it was all he was working on.
And once the civil suit was filed, and based upon your personal observation, how much of Mr. Megaro's time did that require?
Most of it, I would say 75 to 80% of his time. If it wasn't daily, it was every other day. Mostly it was daily, at least some hours a day. I know that he performed somewhere in the neighborhood of 20 plus depositions. I lost count. He was up here investigating. I was up here with him several times for hearings, for mediations. I left the depositions to him and Mr. Brett Schneider. They simply enjoy that better than I do. But it was pretty much an all-consuming effort on his time.
Describe your personal involvement in investigation. What did you do?
Certainly. When it came to investigation, I was focused on the insurance aspect with the town of Red Springs. We had gone to a mediation where there were insurance folks present, but I was able to review insurance policies for the town of Red Springs from the years prior to, during, and after the incidents that happened there. Part of my analytical brain is I like to review those. I want to see what the contract says. What are the parties really on the hook for? I had worked through that with attorney Neil Yarborough. We had a very good working relationship.
And that was, what was Neil Yarborough's role?
Neil Yarborough was one of multiple counsel for the town of Red Springs, an insurance counsel, to the best of my knowledge, or counsel that represented the town.
Did you have any knowledge that he was actually the town attorney?
I believe he was. I'm trying to remember back then, but he was intimately involved in the defense of the town of Red Springs.
All right, continue.
So I worked with attorney Yarborough very closely in analyzing documents that were provided with regards to assets of the town of Red Springs, insurance that the town of Red Springs had or did not have. We in fact found many gaps. We weren't even sure that there was insurance coverage during the years where this happened, particularly 1983. And even in some of those cases, there were policy limits of about $250,000. Those also had some exclusions in them, including intentional torts. So in looking at that and in consulting, we found that it was highly likely that there would have been no insurance coverage. Looking at things like the entire annual budget for the town of Red Springs, the settlement that was eventually entered into and ratified by Judge Boyle was more than their entire ad valorem assessment for the year. I think they had a rainy day save our town fund which was only in approximately $90,000. So this was the joke that Neil Yarborough said was, this is the poorest town in the poorest county in North Carolina.
Let me just interrupt you for a moment there. Have you been to Red Springs?
I have.
Could you comment on the veracity of Mr. Yarborough's comment about it?
I have no reason to doubt the veracity after what I've seen. It is a town that is not all that different from the photos of 1983. It has not really changed, kind of the land that time forgot.
Continue on, I interrupted you. I'm sorry.
So that was one of the key aspects of research that I had done in this case, which led me to consult with Mr. Megaro on it, who also looked at those same documents in ensuring that the due diligence was done before working to move forward with a settlement with the town of Red Springs that we felt was reasonable, given the assets that the town had, to our knowledge, the insurance coverage or lack thereof, the relative culpability of the defendant town. Essentially, I made the analogy to Mr. Megaro that it's a lot like a marriage breaking up and then trying to sue the banquet hall that you had the rehearsal dinner in. It's a long stretch to get that culpability. They're not the reason your marriage broke up.
You're talking about the liability assessment.
The liability assessment of the town of Red Springs, correct. That was factored into our decision about whether or not a settlement with Red Springs, I think was for $1 million, $1,000,000 was sufficient or possible based on everything. Even in my discussions with Neil Yarborough, if we took every possibility and every insurer kicked in what might have been insurance coverage, but really wasn't, with all of these assets, we would have been looking at an absolute best case scenario with all of the stars and planets lining up of about 1.25 million. So instead of pushing through and not getting some compensation for Henry and Leon, we looked very carefully at, and in conjunction with Dwayne Gilliam, who was the guardian for Leon Brown, made the proper and reasonable decision to move forward with that settlement, which, as we know, Judge Boyle ratified and approved.
Well, you spoke about the insurance aspects. Could you expand a little bit more on what factored into your analysis as to the liability of Red Springs?
Certainly. If we break the defendants into three buckets, we essentially have the town, we have the state defendants, and we have the county defendants. Each one during the time period, the 1983, 1984 timeframe, having different levels of culpability based on what their role was, whether they were collecting evidence, whether they were hiding evidence, whether they were merely just a venue within which something happened. For instance, the town of Red Springs being really just a venue, as in the total analysis that I looked at, versus the other defendants having much more personal culpability. The sheriff of Robeson County and the State Bureau of Investigation defendants having conducted the investigation, having conducted interviews with people like Roscoe Artis, not making these connections, or in worst case, actually actively concealing evidence of actual innocence. In the hierarchy, the town of Red Springs was at the very bottom.
Did you determine to your satisfaction what was the actions, if any, taken by Red Springs that could be a basis for liability?
We did. Without an exhaustive review of the case file, I wouldn't be able to say exactly what actions we reviewed, but it was a fairly lengthy analysis that we performed in determining the liability and the actions that were taken by that particular defendant in making a decision whether or not a settlement was reasonable, based on all the factors.
Now, in addition to what you just described as looking into the insurance situation, were there any other aspects of the McCollum Brown matter that you participated personally in?
I helped review aspects of the file with Mr. Megaro. I was helping as the managing partner of the firm. I was responsible for making sure that he had resources to digitally inventory and catalog as well as hiring decisions. It became apparent very quickly that as much as Mr. Megaro would want to shoulder the whole burden, he needed help. We hired law clerks, we hired assistants to do tasks as simple as recognizing text in PDFs, making them searchable. Of the files we had, there was scanners and copiers going every day, all day. A lot of the documents did not exist digitally. They had to be scanned in. Then we had to use the OCR, the optical character recognition, to make them full text searchable in order to find things that we wanted. But Mr. Megaro didn't have those resources all the time, so we had to get them for him in order to ensure that he was able to prosecute this case as quickly and efficiently as possible. During that time period, of course, I became intimately familiar with the case file. I was present at mediation. I was present at various different hearings throughout the process, up to and including the point at which we were relieved as counsel.
Getting specifically to Mr. McCollum, did you meet him?
I did. I have met Mr. McCollum on multiple occasions.
Could you just describe on what occasions you personally met Mr. McCollum?
The first time I met Henry, I had come up shortly before they were going to go to the governor's office. I had skipped Mother's Day that year, and I had traveled up in order to assist with preparing them to testify to the governor's assistance. That was when I first met Henry and Leon in person, along with their sister and other various family members. Mr. Megaro had just helped them to get into their new home. They'd moved out of that squalor into actually a very nice home in a much better neighborhood. I was able to meet them. I stayed there for several days. I believe it was that Wednesday. It was a Tuesday or Wednesday after Mother's Day that there was the meeting here. I think it was the Brownstone where the meeting was. No relation to my former law firm, but where they were to meet with the governor's representatives. But Mr. Megaro had already met with them multiple times, so he was well aware of the nervous tendencies, I think indicated through post-traumatic stress.
Well, don't say what he was aware of. I want to
Okay.
focus on what you observed and your impression.
Well, I was going to say that Mr. Megaro had prepped me for that, to understand that I needed to speak with and prepare Mr. McCollum and Mr. Brown to testify, to take their fears away. When I was younger, I had a fear of speaking to the public. I had a fear of I know that's hard to believe nowadays, but I had a fear of that. And I was going to bring some of those techniques to bear, because it could be a very daunting thing to, after all these years, be speaking possibly to the governor, at least to his representatives. What kind of questions were they going to be asked? Whether or not they would be able to make a good impression and be able to explain themselves and be able to come across in a way that would put the governor at ease. Again, everything needed to be right for this pardon to occur for each of them. So I was going to prepare them ahead of time, make them feel at ease. But that was based on Mr. Megaro's interactions with them and providing me with a briefing that would enable me to be most successful in that act.
And this is already implied, but was it your understanding that Mr. McCollum, Mr. Brown would actually be present and subject to questioning at that meeting with the governor and the governor's representative?
Oh, absolutely. We expected them to be peppered with questions. Again, my feeling and my personal experience that elected officials don't just give away pardons absent some kind of tremendous pressure, which we were already applying, and or an absolute belief that everything was perfect with the case. There wasn't even a slight doubt as to their innocence. Those two factors really needed to align in order to ensure. So I had a feeling that they were going to be asked a tremendous amount of questions.
And when was your next interaction with Mr. McCollum?
I don't recall when we would come up here for things like mediations or any other kind of investigation or depositions. There would be interactions with Mr. McCollum. But the next time I recall was when he came down. They brought their family down to. They wanted to do a Disney World vacation. I know everyone has said Disneyland here, which hurts me because it's very different. Disneyland is in Anaheim, California, and we're the home of Disney World in my hometown of Orlando. But they wanted to do this kind of once in a lifetime vacation. So I got to see Henry again. I got to see Leon again, Geraldine again. This was a few months later, I think September, October timeframe, October, if I recall correctly. They came down to have a great, Disney World vacation. So that was the next time that I recall seeing them personally.
And was there a time after that?
There were several times after that over the years that I met with Henry. Never by myself. I mean, this was always Mr. Megaro's baby. He wanted this case to go perfectly. So I was always in a supporting role. So it would be tangential to Mr. Megaro's efforts that I would interact with Henry or Leon.
Williamson, Mr. Williamson, let me ask you at this point, for the benefit of the court reporter and others, it's been 2 hours since we took our last break. Do you have, without in any way attempting to limit you, do you have a forecast as to how much longer your examination will be? I'll be asking the same in terms of the state's projection as to their cross-examination, realizing it's all an estimate and that I'm not trying to limit you in any way, just trying to get a forecast of trying to coordinate today and tonight and tomorrow.
I hate to commit, but I think I could finish within 30 minutes. A couple of us would appreciate it.
We're going to do that regardless. So
very good.
What say the state bar?
Rough estimate, Mr. Chair, maybe 45 minutes to an hour.
So can we try to finish the direct tonight? Is that all right with everyone? And then we can pick up with the cross tomorrow. Now, Mr. Williamson, the other night you told us 30 minutes and it went an hour. So we're going to shoot for around. We're going to shoot for around 6 o'clock or so and see how we get to that point. And we'll see how we stand. Does that sound like a good plan?
That'll be the plan.
All right, let's, and again, I'm not trying to limit you in any way. You take as much time as you need, but let's stand in recess for 5 minutes, please.
Thank you, Mr. DeVore. At this point, I want to turn your attention to your impressions of Mr. McCollum.
My impressions of Mr. McCollum.
Let me ask you a question first. I didn't ask you a question. I turned your attention to it. Now that I've done that, what were your impressions of Mr. McCollum?
I found Henry to be a remarkable person. When he tells his story, the depth to it is amazing. He remembers everyone.
Objection.
Well, based on hearsay,
Yes, sir.
I think that Mr. Halscott, you can testify as to your impressions, but I think you need to avoid anything that Mr. McCollum may have spoken to you since he is not present in the courtroom, and that would be hearsay.
Yes, sir.
Let me ask you this way. What were your impressions about his memory?
His memory is flawless. I have no reason to doubt it. There were things that were remembered that I would not have remembered. I often joke that I'm the smartest man in the room, card carrying Mensa member and everything, but Henry showed me up a few different things. At one point, we had to transmit a video to our office. My background in computer and electrical engineering, I was an IT professional for almost 20 years. Worked in software for a long time, myself carry an iPhone. We couldn't figure out how to get that large file. Shortly thereafter, obviously, Mr. Megaro was disconcerted that he couldn't get the file. We get a link to retrieve the file from iCloud. And we were joking about this, and Mr. Megaro was ribbing on me about it because Henry McCollum was able to figure out how to prepare a file, distribute it through iCloud, and send a link to us. And we're like, how did you do that? But there it was. So he was able to figure out something that, embarrassingly, as the smartest man in the room, I wasn't. So I had no reason to doubt that his intelligence or his memory had any defects, at least none that I saw.
Are there any other specific incidents that you can recall regarding what he did and you observed that would be helpful for the panel to hear?
Every interaction I had with Henry, he was just a normal guy. He was just like anybody else. Again, I'm not a mental health professional, forensic psychiatrist. I'm not going to dive into the weeds about various different scores, plus or minus 2 points. But I never had any reason to believe that there was anything wrong with him, other than he had been forced under duress to give a false confession, one which I myself might have given at the age of 19. So I had no reason to believe that there was anything strange about him or different about him, other than his apprehension in certain circumstances, just due to his experiences.
Now, you practice criminal law.
Yes, sir.
Have you had occasion to have clients that you recognize were, quote, I'll use the shorthand, off in some way?
We tend to see that in the criminal world, yes.
As a client, was Mr. McCollum one of those in that category?
Not in my professional experience, no.
All right. Thank you. I used less than half my time, Mr. DeVore.
I'm most impressed, Mr. Williamson. Thank you for that. I still believe Mr. Walthall.
I'm sorry. There's one other
All right, sir.
aspect. Let me, like a lawyer. This will be short. Did you have any interaction regarding Grace Humphrey?
Minimal interactions, only the hearing of conversations, at least the parts of them that I heard by sharing an office with Mr. Megaro and his frustrations. That I could tell there was a frustration there, but I didn't interact with Grace other than to know that she was not doing what we were telling her to do, and beyond that, I didn't have any personal direct that I can recall.
Mr. Walthall, Mr. Murphy, I want to make sure that you're not rushed by the lateness in the day. If it's all right with you, we'll just start with you folks in the morning. Is that all right? That will give you the overnight to.
Yes, sir. That's fine.
All right. Again, the plan will be, I will send a text to or a call Miss Mine early in the morning. And if let's assume that we will begin at 8:15 in the morning, unless you receive some conversation or some message that we're not going to meet in the morning. Otherwise, we'll go at 8:15 and then assess the weather as it goes during the day, and hopefully everyone remains safe if we have bad storms.
Yes, sir. That's fine.
All right. Thanks, everyone. Thank you for your patience today, and we'll resume tomorrow morning at 8:15. We're in recess.